Item number 20, Lordship. An affidavit in opposition filed by the respondent number 245 and today, Lordship. It may be called for record, Lordship.
May I please, your Lordship? Lordship, with the consent from the other side, I beg to mention item number 7 for adjournment. As learned Deputy SJ, Mr. R.K. Debsabri, and learned CGC, Mr. S.K. Mehdi is out of station.
I'm appearing for the petitioner, Lordship. Matter will be fixed on 3rd, Lordship.
Affidavit file?
Yes, Lordship. Everything is ready.
No, that there is instruction was to be taken from the army by the ASG, and affidavit has been served upon you, ASG. States that circle officers report was to be.
File.
That has been served.
Okay, when?
On 3rd, Lordship.
They informed me to make request for 6th
No,
of.
Lordship, I have talked with SK Mehdi just now, Lordship.
Okay.
On 3rd.
Okay, as agreed to by the learned counsel for the parties, list this matter on 3rd of September.
Deeply of.
May it please the Lordship.
Yes.
Lordship, I beg to mention item number 23, Lordship.
20,
3, Lordship. Lordship may not like to take up the matter, Lordship.
list this matter before any other bench without.
Lordship, item number 30 also, sir. Lordship. Lordship, item number 30, Lordship, kindly adjourn the matter for today. We are awaiting actual instruction on the
Item number 30, you are for whom?
for Guwahati University. Petitioner.
Okay, any approval has been there?
The instruction is awaited from the client, Lordship.
Okay. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 3 weeks.
Lordship.
Item 18, bail hearing.
Allowed. Mr. Mannan may be a little bit late in some correction, there is some correction. Maybe you may get the copy tomorrow or tomorrow.
Yes.
We'll try to upload it.
No problem. Mushroom.
Item number? Yes, কিবা বনাইছিলা নেকি? কিবা বনাইছিলা নেকি? Hmm. None appears for the petitioner on call. The learned counsel for the petitioner. Now, this case was adjourned on 30/7/2024 on the prayer of the learned counsel for the petitioner on the ground that the petitioner number 1 has in the meantime expired, and therefore an adjournment should be granted for substitution of the legal years of the petition. However, none appears for the petitioner on call. No IA has also been filed. Be that as it may, in the interest of justice, matter stands adjourned and be listed after 3 weeks.
Item 20.
Wait, please, Your Lordship. This application
Mm.
is directed against the arbitrary and illegal action of the banks, respondent number 6 to 9. In freezing,
maybe
no,
for
let
the
me
time
finish.
being.
This is my application.
Because the affidavit has been called for in opposition. It was mentioned, Milord.
Well,
Maybe kept for the
Lordship,
timing, Milord. Affidavit in opposition has been called for by your lordships.
Just
During
now.
mentioning, Milord.
It mentioned.
Yes,
Okay,
yes,
let
Milord,
it-
it was
let it come.
mentioned.
Five.
Lordship is going for a final hearing now.
What finally? You have already completed, Mr. Das was to add something if he wants. He has given his written. We'll make it savvy today. That's all.
No, I have to make one submission then, my lord.
You are arguing.
Yes, because my lord, he is not present.
Okay,
my
okay,
lord.
okay, proceed,
Yes, just,
proceed.
3 and 4 to call.
Hmm.
My lord, page 3, my lord.
yes,
Hmm.
lordship, kindly give me just 30 seconds, and brief is there, my lord. Just,
Okay.
he may
Okay.
start, my lord.
Page 3, clause 3, my lord.
Hmm?
Yes. Serial number 3, my lord.
Hmm.
Three and 4.
Hmm.
And that notification and the judgment I have annexed to the.
Absolutely. In fact, that judgment you have already handled. Your case is that is when that is not established, then recover that it is not established that this is the contraband.
Yes.
That's all. This is
Yes.
your case.
And moreover, my lord, one point my lordship may see, my lord, the seizure, my lord,
Hmm.
not conscious possession. And they are saying, my lord, beneath the seat of the motorcycle, but there is no space in the beneath the space, beneath the.
But
seat,
there is
my lord.
no cross examination to that effect.
Yeah, that's true, my lord. That's
That is, I have
that's-
gone
that's-
through. In fact,
that's-
I have dictated the evidence because most crucial part is dictating all these evidences.
Yes.
Isn't it?
Yes.
You can argue, read it and go, but we'll have to summarize all the evidences, their cross examinations. That takes time.
And moreover, my one point is that my lord, the IO of the case, he expired.
Hmm.
So he was not.
Not exam.
Yes.
If you some time we will go to the other matters, yes, concluded, you can go through and come back. We'll complete it today.
Yes, sir.
Okay?
Yes.
Okay, you take some time. Take your break.
I may not come.
No, not necessary. That
Two, my, or.
or maybe two, let us continue with the other matters. You conclude your argument so that we can,
I have served a copy also.
you
Because,
go through it.
yes, yes. fine.
You go through it, these are just confine your argument to those points, that's all.
Paragraph 3 and 4.
Paragraph 3 and 4, confine to that only.
Lord,
And he has relied on a judgment of a division bench, recent judgment,
That also have given.
that, go through
yes,
it.
yes, yes.
I am obliged.
Yes.
Six.
Hmm? Yes, let us understand what is your writ petition, let us see.
Yes, ma'am. Repetition is that.
Hmm.
Lordship will find.
Hmm.
The appointment of one-man committee at page annexure 11, page 48.
The next, sir,
11, page 48.
next, sir, 11, page 4.
My lord, by this order, my lord, Junior Joint Registrar has dissolved the committee and one-man committee has appointed. And why this one-man committee is appointed, we have to go back to the committee constituted earlier, how this committee constituted. So now your lordship may kindly look into page 25.
Just a minute.
Page 25 with the approval of
Who are you? Who are you?
we are shareholders and also
You are
BOD.
shareholders.
We are also BOD of the present dissolved committee, madam.
You were the, page 25 is the committee where you were the board of directors. Is
Yeah,
that-
yes, yeah, there is approval order.
Hmm.
Then
So
these
these are the petitioners. Who are the petitioners here?
petitioners are here, the board of members.
All these 7. Page 25.
No, no,
This is
only,
the earlier.
no, earlier, I am Bijoy Das.
Okay, 7.
Yeah, and Sudhir Das is not here, my lord.
Okay.
Then next, my lord, subsequent committee was constituted.
So this was the first committee for the purpose of this
Yeah,
case.
yeah, of this case, my lord.
Oh,
Now the next subsequent committee, my lord, constituted
Hmm.
on 28/8/2022. Vernacular is 34. 28/8/22, vernacular is 34, and by resolution of number 8, there is page 33. the committee has been constituted.
Page 30.
My lord, this committee has been constituted after expiry of earlier committee on 15/9/2000.
So according to you, the 29 December, the committee constituted on 29 December expired when?
On 15/9/2021.
15/9/2021.
Yeah.
It is expired.
Expired.
Now that will get, where would you get that? Now thereafter the second committee at page 34.
Yeah, 33 and 34.
Next committee is page 33 and 34.
Yeah, 28/8/22 committee has been constituted.
20 page,
Page 33 and 34. 30 was the vernacular.
page 33 is a resolution 8.
Yes, my lord, they are
Discussion was held towards information of committee for formation of committee. The term, where is the, let us go to the vernacular.
yes, my lord.
Page,
Vernacular is Bengali, my lord.
what? No problem on that. Page,
Yes, my lord, I'm coming. Your lordship will find 37. Page 37, Atmo Prastab. অধ্যকার সভায় আরো প্রস্তাব গ্রহণ করেন যে আমাদের অধ্যকার বার্ষিক সাধারণ সভায় সমিতির নির্ধারিত কার্যসূচি অনুযায়ী 2022-23 ইংরাজি সনের কার্যকরী বর্তমান কার্যকরী কমিটির গঠন করার বিষয় বিস্তারিতভাবে আলোচনা হয়। সভায় সমিতির বিভিন্ন আলোচনার পরে পুরাতন কার্যকরী কমিটি সুন্দর ও সুষ্ঠুভাবে পরিচালনা করায় সভায় সন্তুষ্ট প্রয়োগ করে। আগামী 2026-27 ইংরাজিদের কার্যকরী কমিটি পরিচালনার পুনরায় বিগত কমিটি বহাল রাখার জন্য সভায় মত প্রকাশ করে।
so according to you, this meeting resolved to continue with the committee at page 25.
Yeah, that earlier committee, my
Okay,
lord, earlier committee. My lord.
Hmm.
Now here your lordship will find
Hmm.
in the just my lord in the members present in the meeting, my lord, page 34.
Now we'll go to that later on. What happened thereafter?
Okay. Thereafter, my lord, the committee he got after expiry, my lord. No one-man committee is there. This
No,
yes.
this committee is approved, when approved?
yes, approve is my lord approval letter, my lord, your lordship will find. You will not have, so I have not annexed, my lord.
Okay, as we assume that this
Yes,
has been
yes,
approved,
yes,
then,
approved, my lord.
then what happened?
This is approved. So, my lord, the allegation has been made against this committee because after expiry of nearly gap of 11 months something, the board of its own has constituted a committee, my lord.
Okay,
Then, my lord, a complaint has been made, my lord. Then, my lord, assistant registrar has appointed an inquiry officer to inquire the matter. Yes. So the inquiry that
now where is the order dissolving this committee?
yes, that your lordship will find.
So ultimately, this committee constituted as page 37 was dissolved.
Dissolved
Where is
by
that?
page 48, my lord.
Page?
48, annexure 11.
Because we are not going for disposal, just we are
Yeah,
trying to
yeah.
understand whether
Yes,
any
sir,
case
yes,
for interim order is made out. That's all.
Yes, yes.
Then page 48.
Yes, 48, annexure 11. This one dissolved, my lord. Then one-man committee appointed.
Okay, one.
Then one-man committee,
Hmm.
while he making scrutiny, then he has prepared a voter list, my lord. For 3 months, he was appointed one-man committee.
For next election.
Next election, because
Then-
he has to hold the election within 90 days.
Okay,
So,
then
my lord, one-man committee has prepared a voter list, page 61.
page 61.
Yes.
Now,
So here, up to 1 to 15 members, he has, my lord, prepared a voter list, my lord, right or wrong, that is. Then, my lord, the respondent number 5, who was initially entered into the committee in the board time to time as a co-op member, my lord. He is not a shareholder, my lord. As a co-op member,
okay, what happened?
so he found that his name is not there in the voter list, my lord. So he made a representation before the ARCS Silchar, my lord. The representation is page, annexure 70, page 62.
Page
62. Then, my lord, reply has been given by the ARCS,
page
page 65, page 18.
Hmm.
So, my lord, the reply I may be allowed to read, my lord. That one, as per this office order number, so it is seen that you become a member of so-and-so society through co-option under section 42(4) of the Assam Constitution who are enrolled through co-option are not deemed to have any voting right. In addition to the above, the tenure of such membership is coterminous with the tenure of the board of directors of society. Then two,
So
under
therefore his prayer was rejected.
rejected, my lord.
Then,
He made an appeal
Hmm.
before the Junior Joint of Registrar of Corporate Societies. So under section 111,
Hmm.
he made an appeal, my lord. That appeal has been allowed.
where is that?
Yes. That is page 69,
Yes.
another 20, page 69.
Okay, what is the ground of allowing the?
The ground is that he was in the 2008, he has been entered in the co-option member. Subsequently, in the constitutional body on 2016 also, he was elected as a BOD. Again, in the subsequent 2020 also, he is elected as BOD. These are the grounds. Now, the Junior Joint Registrar, what happened? While allowing his appeal, he has also restored the committee which he has dissolved. That is the thing, madam. The committee which
Now, what is the present status?
the present state, that is because he has restored.
Huh.
The person, he himself has dissolved the committee, my lord.
Huh.
By his order, the committee was dissolved on 1/1/2024. After 90 days.
So after one-man committee without holding the election, earlier committee is restored.
Yes,
Yes,
that's
this
what-
is your case.
Yes,
Yes, Mr. Talakdar. Is it correct?
My lord, it appears,
Factually tell us. We'll go to law later on.
law, my lord. In fact, what has happened, my lord, this writ petition was moved on 28/6.
Hmm.
Now, on 28/6, this honorable court had issued notice
Hmm.
and certain interim order was passed.
Hmm.
Now, today, my lord, 3 IAR before your lordship.
Hmm.
In respect of 2,
Hmm.
with regard to implement of parties, my lord, I have nothing to say, your
Hmm.
lordship may allow.
Hmm.
Third one is in respect of, my lord, some interim orders.
Hmm.
So in that respect, my lord, I have to submit before your lordship
Hmm.
that that application may not be maintainable.
Hmm.
In view of the fact that the state.
You are protecting the action of the appellate authority.
Absolutely, my lord. Yes. Also,
You give us the reason, why are you protecting?
what I'm trying to say.
Yes.
Today, my lord, the IA is before your lordship.
Hmm.
If your lordship hears the entire matter,
Hmm.
fixes this matter thereafter tomorrow or whatsoever,
Hmm.
I'll argue on the, my lord, merit of the case.
Hmm.
But so far as the application, my
There
lord,
is a concept of ad interim injunction.
no, on the top of it, my
Ah,
lord,
Yes.
what, my lord, the
Temporary, permanent, ad interim.
prayer,
We are on ad interim.
prayer is,
Hmm.
my lord, for stay of a subsequent development.
Hmm.
Now, if your lordship goes to
So
the,
therefore, please answer the question so that we understand or we can understand that whether there is a case of an ad interim injunction or not. We'll go to the subsequent. If not, we'll issue a notice. We'll wait. We'll ask you to file an objection.
Yeah.
The first question is: do you deny the facts that earlier committee was dissolved?
my lord,
No. Do you deny the fact that one-man committee was constituted? Do you deny that one-man committee's duty under the scheme of the act is to prepare the voter list and hold an election? Because it cannot be run by a committee, it is a democratic process. So therefore, he prepared some election. There was some dispute as regards the right of a person, whether he can be a voter or not. That was decided by one authority saying that you do not, because you are not a shareholder, rather you are a co-opted member. That is correct, not correct, can be challenged. It was challenged in a appeal. In appellate provision, appeal, not only he was allowed to participate, allowed to be the voters, at the same time, the original committee which was dissolved has been restored. This is the facts projected. Is it correct?
that is correct, my lord. In
Okay.
fact,
If that is correct, now what is to be done at this stage? What the cooperative department or per se, the authorities propose? Now, so therefore that committee will continue
yes, my lord, the
without any election.
two alternatives, my lord.
Yes.
Two alternatives. Firstly, if your lordship interferes with the order of the appellate authority,
Mm.
then the one-man committee is required to hold the election.
Mm.
And if your lordship does not interfere with the order,
Mm.
because the appellate authority has, my lord, assigned certain grounds.
Mm.
And if your lordship finds that the grounds are germane
Mm.
for restoration of the board, your lordship will not interfere with
Mm.
the order.
Mm.
In that respect,
What
my-
was the period of that dissolved board? What was the period? 5 years. It was
having been constituted on 28/8/22,
Hmm.
my lord, it will by virtue of 5 years, my lord, it will continue up to 27
Hmm.
earlier board.
Okay.
So duration is subsisting, my lord.
Hmm.
Now, my lord, my submission is, my lord, there are reasons assigned by the appellate authority.
Okay, okay.
Now, my lord, in fact, I have not gone into the merits of the order because today, my lord, only the applications, 3 applications.
Now,
are
what is your
listed.
apprehension? Tell us today. What is the things they are doing?
My lord, may I only one line? Because if your lordship passes an order today,
Hmm.
that it would be amounting to, my lord, amend the earlier interim order passed by your lordships, number one.
Hmm. Is
Number
it not
two,
permissible?
not permissible. That is why I am trying to say.
Not
my lord.
permissible.
No, what permissible, my lord, but one after another, my lord, application, can he, my lord, file one after another application and seek, my lord, interim orders?
Maybe
Because-
we are in a writ court. In a given situation, if you do illegality, of course not. If it is, if it can be interlinked to the subject, main subject.
My lord, on the count of the, my lord, petition, the projection, this honorable court has heard the matter
Hmm.
and was pleased to pass certain direction.
Hmm.
Yes. So if he is aggrieved of that direction, my lord, he may file a review or he may file, my lord,
No,
an
no,
appeal.
no, Mr. Talukdar, you are absolutely not. We will not agree with this.
Yeah.
An interim order is part. Situation may so arise that we may have to modify. Situation may so arise, we may suo motu modify.
Correct, my lord.
Then
Here your lordship.
where is the question of review?
The prayer is, my lord, not to allow
Hmm.
the board members, my lord, from functioning.
Hmm.
That order, my lord, while issuing notice, my lord, this honorable court did not pass. Honorable court says that any decision or order passed by the board shall be subject to outcome of the.
Now we understand the
My
whole
lord.
case. Now tell us what is.
Yes, my lord. Subsequently, my lord, what
Hmm.
subsequent development has come up, my lord. You also kindly, my lord, look into page 34 now. The earlier committee who are the present in the board.
Hmm.
Earlier committee, my lord. Page 34, vernacular.
Hmm.
My lord, the situation.
Certificate of the writ petition?
Yes, my page 34.
Hmm.
Yes, with petition, my lord. Adhiranjan Das present.
Hmm.
Sudhir Das is present petitioner.
Hmm.
Chanchal Das, Jayanto Das, Bijoy Das is present petitioner. Then Sobita Das.
Hmm.
Kalpana Das, she is not a shareholder, my lord.
Hmm.
Her mother was shareholder. Her
No, no,
mother-
we cannot go to all this.
Okay, my lord.
We cannot go to all
I-
this. You
okay,
see
ma'am. Yes, my
what
lord.
is the new
Yes.
facts that you have
Yes.
filed an IA?
That-
Tell us
yes,
that.
Yes, my lord. Then Veerbhadra Sinha, he is also,
Oh, Mr.
yes, my lord. Now what happened? 3 of members from here died, expired, my lord.
Hmm.
Now presently what these 3 persons, 3 board of members remain, including us, we are total 7, my lord, including us. We did not attend the meeting. So 3 members, along with the nominees of that person, their DOD, my lord, the DOD who have already expired, they have collected them, and 19/7/2024 was, they have drawn the proceeding, my lord. And secretary was removed. Now the 4 of that BOD, my lord, are not the BOD, my lord. They cannot, my lord. There is a thing. So subsequent development is going on. There,
Where is let
Yes,
us go to the
yes,
your
that,
IA.
now I am allowed, we have to go, my lord. IA, your lordship will find.
Which IA? IA number?
That IA for interim order, my lord.
Number.
Because just
You did
yesterday
not have
only.
that much time to
Yeah.
look into. You want an interim order and you do not know what is the number of the IA. Where is the impugn action?
Yes, my lord, page 66.
Yes.
66. Now, your lordship will find member, page 67, is the member present in that meeting, man. Sobita Das, yes, she was BOD. Chanchal Das also BOD. Sojal Das. he-
Just a minute, just a minute. Where do you get that? Page? Yes.
Yeah.
Who is this?
Sobita Das BOD, okay, no problem. Sojal Das, he is not a BOD. Putul Das, okay, he BOD. Kalpana, she is not BOD. Rajesh Das, he is not BOD because his name is, he was not present on that day. Anand Das not BOD. Bappa Das not BOD. Out of these 8, one is, if we consider one is as a secretary, then 7. 7 members out of these 3 members are from outside the, my lord, the jurisdiction, my lord, they are not BOD. Now, how could they, my lord, this resolve this resolution, and my lord, the temporary secretary appointed by the one-man committee has been removed. Your
Mr.
lordship,
Talukdar, where this meeting was held?
No, my lord, what I'm trying to say, these are disputed question of facts. My lord, we
No,
kindly
we are
say-
not going to.
Yes.
Where this meeting was held?
my lord, that meeting of the cooperative society, my lord, I don't know. I have to obtain instruction.
What instruction? Come to page 66, first line.
Yes.
Place.
My lord. That, my lord, the vernacular is not legible. We don't know, my lord, what is there in the vernacular. Your lordship will see kindly, my lord, this, how can I read this one, my lord? And my lord, one respectful submission, my lord, by the order
Come to page
28
66,
my
it
lord.
is English. Do you say that this is not proper translation?
My lord, I don't know, my lord, what is translated.
So you are disputing all this. Till you file an affidavit, we are saying it is all this.
No, lordship may
There is a
pass-
limit, Mr.
lordship may
Talukdar.
pass any order, my lord.
Yes.
Yes. lordship
We
may
will not
any-
pass any order. We will pass order which is reasonable and according to us.
Absolutely.
And will not allow this kind of things in cooperative
No,
society.
absolutely.
And we expect
Yes.
that your officers protects the scheme of the act and the rights of the cooperative society.
But
This is
they-
not the way.
No, the board of directors, my lord, they are not related to the office, my lord. They are doing things, my lord, we don't know. This is, my lord, inside.
You
the
should know.
cooperative
Why
society.
you don't know?
No.
You
my
should know.
no,
You
lordship
have
will-
the instruction.
lordship will
This is
kindly-
not the way.
Lordship will kindly see, my lord, lordship may hear the matter. Eventually, if your lordship finds that the appellate order is bad, your lordship will set it aside and direct, my lord, the one-man committee to hold an election. What I'm trying to say, by 28/6, this honorable court has passed an order. Whatever, my lord, decision or order is passed by the board shall be subject to outcome of the writ petition. That protection is already there, my lord. So these orders, my lord, will go. It will require the approval of your lordships, my lord. Lordship will, my lord, fix a date for hearing. And I say, if
We will hear it matter today itself. Today, or otherwise you are passing a stay order. Yes. Yes, this will not.
lordship may take up next week, my lord. Today is, my lord, Thursday. Or Monday or Tuesday, my lord, I'll submit if your lordship finds anything, my lord, illegal.
We are
lordship will study
passing an order, no decision should be taken by this board constituted
that. Lordship
majority.
may pass it, my lord.
Yes.
I cannot say anything, my lord.
We'll pass that order, yes, we'll pass the detailed order after many hearing matters are there.
My lord.
We'll request you to instruct your officer.
My lord.
No
Absolutely.
decision by
Absolutely,
this
my lord.
board.
I cannot have a say, my lord.
No decision by this board. Next, give a date. This is not the way how to deal with.
Lordship
Yes,
may take up next week, Monday, Tuesday, any day.
yes, give date on Tuesday.
And if I find, my lord, that appellate order is, my lord, not accordance with law, I will submit before your lordship to set it aside, my lord. But I have not gone through, my lord, what are the reasons
You
assigned
go
there.
through it, you go
My
through
lord.
it, but
it is
we
fair.
we will not allow to change the entire situation.
My
Let this board continue. We are not saying anything,
My lord.
but not no major decision by
My lord.
this.
Correct.
They will not, including the change and anything of the
Yes,
voter list.
Correct.
That much.
10 September, no?
Hmm.
Okay, all right. 10
So
September.
status quo, my lord, otherwise, because.
Status quo.
Yes,
Status
ma'am.
quo means they will make
Yes.
specific. We are not believer of status
Yes,
quo.
my lord, yes.
Will pass a specific order that this board purportedly constituted after dissolution of the earlier board, which is the subject matter of the present appeal, as well as the appellate reconstituted in terms of the appellate order, which is under challenge in this report, shall not take any major decision. That's it.
Obliged, my lord.
Tomorrow, lordship will hear it. I think, my lord, if it is not sustainable, I'll propose, my lord, to set it aside, my lord. I'm very fair to your lordship. Instead of passing these interim orders, that will delay, my lord, the election, my lord.
Apparently, it seems that there was a dissolution that was not under challenge.
My lord.
There was a dissolution, one-man committee proceeded. There was no challenge to that.
And, my lord, what?
There was no challenge. See,
what is
listen, there was
disturbing
no
me, my lord?
challenge. What was the challenge?
Yes, absolutely.
That I want to be a member.
Yes.
And in that, including him, has been
Well, what
restored.
is disturbing me, the application before the ARCS and the outcome of the appellate authority, my lord, has no, my lord, link.
That's why I'm
That is
saying.
why, my lord, lordship will kindly give me today's time.
Hmm.
Tomorrow, my lord, if I find, my lord, I'll propose your lordship to set it aside, my lord.
Okay, tomorrow.
Yes.
But don't take any
No,
major
no, I'll
decision.
not take, my lord. I'll only go through the order.
What
are
Mr.
taking?
Talukdar is just no undertaking. Will intimate.
Will
See,
tomorrow-
have faith on everything. It's not that you'll have to show your clients an order.
These are live streaming, my lord.
Yes.
How can I say
Yes.
contrary, my lord,
Yes.
what I have submitted?
Yes. So no major decision till tomorrow.
My lord, correct.
No.
correct. Your lordship will set it aside tomorrow if your lordship finds, my lord.
See, only thing is that admittedly there was a committee.
My lord.
They did not hold the election
Man.
within the specific period. Thereafter, they themselves declared that okay, fine, this we have full trust on this. This committee will be resolved. this course of action may not be permissible. Therefore, rightly that was dissolved. A one man was constituted to hold the election.
Yes, yes.
While he was under process, that order was also not challenged.
My lord, yes, correct.
Isn't it?
The
Now
dissolution
the
order
some
is not
third
under
party
challenge.
comes and maybe third party, maybe he might have a right, says that I am having a voting right.
My lord.
That appeal was relatable to his right.
Yes, yes.
Now, how can the
Correct, correct.
committee be
I
done?
I see, apparently, my lord, it is fallacious, my lord.
So then,
Lordship will take up
that's
tomorrow,
all.
my lord.
Yes, tomorrow.
Oblige, my lord.
You will, if necessary, will may not even file this implement. If we
My lord,
go to
my
this,
lord.
we'll see
Correct,
tomorrow.
correct.
Please this matter tomorrow. That aspect you look into. That's all.
Only I see, my lord, the
Yes.
appellate order, whether there are any reasons assigned.
Even suppose that third party, I think he's represent, you are representing. So if third party right, he might have a right.
yes.
That may be a separate
That's a
issue.
separate
But
procedure.
we'll have to segregate two parts.
Yes.
One is reconstituting the committee and other is the right of a individual, whether a person who is not a shareholder is having a right.
Yes.
That is a different aspect.
I see.
That's all.
And on the top of it, the order of dissolution
Mm.
by which the my lord, board was dissolved,
Mm.
that is also not under
Not
challenge.
under challenge.
Not under challenge.
That is not
It
under
already
challenge.
dissolved. my
What is under challenge is
Yes.
a right of an
Yes,
individual
correct, correct.
to vote or not to vote.
Lordship will take up tomorrow.
That's all.
Fair enough.
Yes.
Oblige.
Oblige.
Yes, sir.
May it please, Your Lord.
What is this?
Application is
Why this
directed
matter is
against,
listed in the orders?
the order dated 13/8/24, if I may most humbly draw your lordship's attention.
Yes.
It says,
Who's
"Malad, the
responsible
banks,
for it?
the banks have frozen the account of the petitioner society on a letter dated 11/7/24, issued by the IFCI, which was the initial sponsor of this institution when it came into being. This
So
institution,
you are Rashtriya Gramin Vikas
Yes,
Nidhi.
my lord.
What is this institution? This is a cooperative society.
it's a society under the Societies Registration Act.
Okay.
Well, what they have done, there was a dispute. There was a title suit which was filed
Dispute between whom?
between the society
Hmm.
and the chairman, the ex-chairman of the society. There was a title suit which was filed on 30th of September last year
Mm.
in the Learned Trial Court.
Hmm.
That
Where is the suit?
suit is at page, my lord, I'll place. Yeah, note to the other. Suit begins at page.
Now, today matter is listed for?
Well, I've listed for what they have done.
No,
Yes.
we are going for final disposal or some interim
One way or the other.
No, where is the title suit? Let us
title suit is
first understand, because
Yes.
this matter was in the order, so we are not prepared in that way.
Pages 69
here,
to 85,
page-
my lord. Pages 69 to 85 of your lordship.
Page 69.
Yes, my lord.
Suit was filed by the RGBN.
Yes, my lord, this society. During the pendency of this suit, they filed a counter suit, my lord, on the 10th of July. My lord, this date is very important. And this date,
Just a minute,
Ah.
just a minute. Just let us understand the facts. What is the suit for?
suit is, my lord, what has happened is this man, respondent number 3, who is now no longer with IFCI, the Industrial Finance Corporation of India. He, by virtue of his ex officio position as chairman of IFCI under the original memorandum of association of the society.
Now,
he was
what is
chairman.
what your society memorandum of understanding of the society says as regards right and liabilities of a chairman?
That I'll place. Lordship may come to original one, my lord, 25 to 38, pages 25 to 38.
How chairman is to be appointed?
Chairman, initially permanent members are sponsors.
Where
Institution-
do you get that?
Page 32.
Page 32.
Yes, madam.
Who will be the sponsors?
who initially, now, my lord, there are corporate houses also. Initially, it was them who had
No,
put in
no.
some money.
Whatever on the date of filing of the suit,
Yes.
what was the structure of this institution?
It
See,
was
see, madam,
this,
I have not gone through the brief. What I can understand is that it's a fight between an institution and its chairman,
yes.
ex-chairman or chairman.
Yes.
Now, we will have to understand to remove a chairman, why a suit?
My lord, what
What is the
happened? My
procedure
lord,
for
the-
removal of a
procedure
chairman?
is spelled out here, my lord.
So therefore,
Yes.
we first will have to understand what is the structure of RGVN, how a chairman is appointed,
Yes. my lord.
how it can be removed. Because your whole case is that you want a declaration that he should not act as this, that.
That part, my lord, I forgo. Here,
No, no, your forego will not there because it's a part of this, we'll have to deal with.
the prayer can always be molded, my lord. They are harping on that in their affidavit today, that the prayer can be molded, my lord.
No,
That-
no, where, madam, see, what we are deliberating is the preliminary, what is the issue? To understand. What is your prayer in the suit? That is the vital.
Put, my lord,
You
prayer.
say in the suit that let the defendant not work as a chairman. Our first question is, what is the necessity of a society to seek a declaration against its chairman? Is there any provision for removal?
Very- my lord,
So
very-
let us see what is the structure
structure,
and
my
who
lord.
should be what is the qualification of a chairman?
My lord, under the original deed, my lord, it is institutional
No,
members.
not originally, on the date of, on the date of the dispute.
On the date of the dispute,
Dispute.
my lord, this was the memorandum of association. Well, governing board will consist of not less than 7, not more than 21 members.
Okay,
So what had
who will be
happened,
the members?
my lord, initially permanent members, sponsors, and
Who,
institutional members.
how sponsor is defined?
It's not defined here, my lord.
Now, who will be the
Initial-
sponsor?
Initial stage, my lord, the people who had
We
put
say,
in the.
madam, let us do one thing. They have filed an affidavit. Let us go through the brief, give a date, we'll finally decide.
Short date, my lord, here the question that it is my duty to place before this honorable court. My lord, there's a letter. While this dispute is underway in the trial court, they have filed a suit on the 10th of July 24. 11th of July, they issue a letter addressed to the bank.
They mean who? The chairman.
Not the chairman, my lord. Chairman is very intelligent. He doesn't sign. He uses a subordinate person, respondent number 5, to issue a letter to the banks that we caution you, do not freeze these accounts. 3 banks they have written to. One bank had afforded us an opportunity of being heard. They have not frozen our accounts. But the second and the third bank, SBI and ICICI, without hearing us, they have admitted, the order dated 13/8/24 says that they have admitted it is this letter.
Who issued this letter?
The respondent number 5, the subordinate of respondent number 3, who was the.
What is his designation declared? What
Absolutely
is,
non-entity.
what is his designation declared in the letter?
Deputy General Manager, and my lord, to do any
Now,
act.
what is the procedure of taking a decision by the society?
My lord, it is
What
the
what the memorandum of association says?
governing board.
Governing board.
Not less than 7. What he had done, my lord.
No, no. Madam, don't be so excited.
My lord,
What he has done will come to later on because we
Very-
want to know the parameters.
very well.
First,
Very well.
that this is an association, this is, its identity is this.
Yes.
The chairman should be this. Everything will be controlled by this board. Now this board is having a power.
First
Until
members-
and unless we understand the structure of the
First members, my lord.
institution and who is having the power, how can we decide whether he is having a power or you are having a power
Well,
to
that
write
is-
to the bank?
That is a subject matter of the suit, my lord. That is in the suit. That
Then if
is
that is in the suit, then suit, it will decide in the suit.
very well, my lord. Here, what has happened is he has hit us below the belt. He has used his subordinate,
Us means who?
the petitioner, my lord.
Who
before-
are the
The
petitioners?
society before this.
So
honorable
if
court.
society is a petitioner, society remove him. What is the procedure of removal?
My lord, we had an EOGM, and in the EOGM, there was a
You
decision.
followed it, ask the
Yes.
bank to do that. He is no more a chairman. This is the new chairman. This is our committee.
Banks have frozen our accounts, my lord.
So you
223
tell the bank will,
people, my lord.
so therefore we'll have to understand what the structure of the society.
Structure, first members, page
So therefore, give
29.
a date, give a date. This will not be,
Well,
why this matter is
Yes,
listed
the
orders?
Salaries, Malad, the salaries of the people are at stake.
No, we'll take it, take up this matter on next Tuesday,
Tuesday, Malad, is this third.
third.
Malad, can I pray that it be taken up on Monday, most humbly?
Monday, there will be 70 matters. You can take a risk.
Then in that case,
You can take a risk.
Tuesday.
70 matters. Tuesday, we'll take up this matter. But
Lordship takes it up on Tuesday, but one thing, Malad, if I may most humbly draw your.
no, we will not waste time today.
No, Malad, there's a reason. They have issued, respondent number 5, saw any authority of law, has issued this letter dated 11/7/24 to the banks.
Mm.
The banks have, without affording an opportunity to us, frozen our accounts. That banks can only do in terms of the RBI circular. If the
So
funds
therefore,
are.
writ petition, subject matter of this writ petition is the power of the bank,
Yes,
whether they can freeze.
yes,
Now, therefore, a question is to be answered
yes.
that who is having the authority to instruct the bank? If
Well,
we say,
That only the central government under the UAPA Act, Unlawful Activities Prevention Act,
no,
and the director. and the
suppose a society chairman says, this is, suppose I am a account holder of a bank. I say, please don't stop this operation of this bank account.
That cannot be done. Bank account can only be done under the Unlawful Activities Prevention Act, under the PMLA Act, or under the RBI circular. If the proceeds.
Yes, Mr.
of-
Sharma. Page number 33. Huh?
They are the chairman is the IFC.
Hmm.
How many of the IFC shall be the ex officio chairman of the governing body?
Page 33. Where's Chairman 7?
Chairman. 33.
Okay, now who has written you the letter?
Letter is being under the head of IFCI.
Hmm.
And it has been.
Who is representing IFCI?
Also respect.
Well, there is no board resolution. Everything that has been filed
We
before this
understand.
honorable
Day
court.
after Tuesday. Tuesday. We understand now.
Yes, my lord.
Lordship will only Lordship is time and again questioning what is High Court report. Lordship, only Lordship will get the whole thing in my affidavit, Lordship,
Well,
at 570.
I will,
The
I
whole
will answer.
thing, the Lordship's question answer, Lordship will get at 570.
Well,
My
only
affidavit,
thing,
Lordship. Lordship will
everything
read
has
that,
been answered
Then Lordship can.
other than the power of the person who had signed that letter 11/7/2024. That is silent, and that can only be done in
So
terms of
therefore, we
section
want to know the
179 of the Companies
structure of
Act.
the organization and how is to be run. Because this is a society.
Yes, my lord.
Society must, like a company, suppose board of director, here may be something
Governing
different.
board.
It will be in terms of their memorandum of association.
Yes, my lord.
Or what
Yes,
do you
my lord.
say? That is a part of the document?
Yes, my lord.
Yes, everything.
Okay.
Only thing, my lord, they have not answered anything.
Lordship will see there's two
And-
suit pending. Lordship later complete.
No, we are not wasting time today. We'll come prepared.
They are silent.
Madam,
My lord, only.
let us keep the energy for the next day.
My lord,
Wastage of energy is very bad.
my lord, the
Next case,
lives
next
of
case,
people are at
next
stake,
case,
thousands of
next
people,
case,
my lord.
next case.
They're working in the northeast,
Tuesday,
somebody
Tuesday,
sitting in Delhi is
Tuesday.
doing this.
Tuesday.
My lord.
I'm sorry to intervene. One of the item number 14, I could not reach one of the, where one of the I was representing, that's one was 8. So I am withdrawing my.
No, not yet started. This is item number 1.
Somebody told me that it is already been submitted.
John, I have a small prayer, my lord. Can it be
What
picked up?
prayer?
Hasde, my lord.
No, my lord, there is grave urgency.
No problem.
No, my lord.
No problem.
No, there's grave urgency.
Lordship wanted to have some instructions from the government, senior government advocate, my lord. He was he informed me he has to go to.
Everything is clear now. Have you gone through the act and
No,
rules-
I have gone to the act. He has gone to court number 1, my lord. He is just come.
let him go. Our concept is clear.
Lordship.
So you argue.
Yes, my lord.
So from last date's deliberation, my lord, one aspect is clear that the license has to cover the place where the work is to be done. My license is all India or all Assam license, as well as the other two bidders, my lord, they're the private respondent. So we have license which covers all over Assam, and the petitioner doesn't have license which includes the place where the work is to be done. Now, my lord, even as on date also, he doesn't have that license, my lord. Now, on the last occasion, my lord, when we discussed the rule, my lord, perhaps, my lord, one aspect I just failed to point out before your lordships. On the last date, my lord, this court, my lord, came to a conclusion or
What we have
prima facie
not
finding.
kept the-
No,
we are- all these are debates.
Yes.
Don't think that what we are pursuing, what we are debating is opinion.
no, obviously.
Opinion is the final when we write the judgment, that's all.
So that's why, my lord, what I am saying.
And I'm open to
Yes,
change of my opinion.
yes.
Yes.
So that's why, my lord, I'm making this submission. That faith, my lord, I have in this court, my lord. My lord, perhaps I failed to convey to your lordship that the 21-1 license, my lord, it was prima facie, it was revealed during the deliberation that 21-1 license one can have after the work is awarded. But that is not the correct factual position. That's what
Not,
I'd like
this
to.
is not the correct legal position, not.
Yes,
fact-
I'm sorry.
Okay, tell-
Yes, correct legal position. my lord.
Yes,
Because we have to, there is an amendment in the form
Hmm.
that I failed to indicate
okay,
before you.
what is the
lordship.
amendment?
My lord will kindly have the rules, my lord.
Yes, rules.
Lordship, now, form 5, which the principal employer has to give, it will be page 309, right hand side, my lord.
Form 5.
Form 5, right hand side, top, my lord, page 309.
Hmm.
Lordship's got, my lord?
Hmm.
Yes. My lord, may I just read, my lord? Form of certificate by the principal employer,
Hmm.
certified that I have engaged, stroke proposed to engage.
Hmm.
No, this aspect, my lord, I just failed to place before you on the last occasion. So, I have engaged or proposed to engage the applicant, so and so, so and so. Now, if your lordships kindly come to form 4.
Hmm. Yes.
Particular serial number 4,
Hmm.
particular of the contract labor, nature of the work in which contract labor is employed or is to be employed in the establishment.
Hmm.
So it is not a fact that 21-1 license one can procure or obtain.
What do you mean by establishment?
So far as 21-1 is concerned, the establishment is the place of contract.
Hmm.
So
Hmm.
far as 21-1.
Yes.
Now, here, nature of the work which contractor is employed or proposed to be employed in the establishment. Now, the 21-1 license.
Hmm.
So, all the 3 private respondents,
Hmm.
we applied for all Assam license.
No,
Which-
license against what?
No, it's not.
Any contractor or any proposed contractor?
My lord, our license where we apply, when we, my lord, registered with the animal husbandry department.
That's, there are two concepts. One is his registration
Yes,
and other is licensing.
yes,
Registration relates to the employer establishment
yes,
and licensing relates to the contractor. Contractor is defined, establishment is defined,
Yes.
employer is defined.
yes.
So in that context, you will have to read all the rules.
True, my lord.
So when we
So,
registered,
subject to just, I'll express my,
Yes.
what my understanding
Yes,
is.
my
The rest you can debate,
yes,
and I'm open to change.
my lord,
The concept is that to give certain benefits to the contract laborers.
yes,
Contract laborers is defined. Who will be the contract laborer? Now, the responsibility to ascertain that contract benefit of the regulation is given. A mandate is given under chapter 3 or 4, I forgot it, in the Principal Act, that all this establishment will have to register that will employ contract labor.
yes.
This is not for the contractors. The registration is for the department.
Two parts in the act.
You're
One is,
coming?
yes,
Yes. So that is registration. Registration is for the establishment.
yes,
Establishment will register that will use contract laborers. Now, they will say that will assure what is required, these houses, this for children, these, what not. They give a certificate that please register us, online application procedures are there. Now it is registered that you use contract laborers. You will use
principal employer.
principal
Well,
employer.
in the
That
act,
is
there
the
are
establishment. Okay.
two parts.
Let us
Yes, yes,
plus express my
yes,
mind.
yes, I'm sorry.
Oh.
Yes,
Note it down.
yes, yes,
Other part is the contractor.
yes,
Okay. Now, contractor, whenever works under an establishment registered under contract labor's regulation, that the principal employer, he will have to get a license. That license is relatable to a project or an work contract. There are two parts. When it is a contract temporary, that is one part, we'll deal with it in details. And other part is which are permanent establishments, like an Oil India Limited. Oil India Limited, the employer is Oil India. They are having a registration to use contract labor. Now, in their case, their contractors uses contract labor. So they will have to give a license, they will seek a license from the authority, the contractor. Then the employer will have to give a certificate. Yes, he will use, and these are the facilities he is having. So this is kind of a permanent factory, industries, workplace. And other parties where a specific project is given, contract like this, that a building will be constructed, he will do it and go away. There is also license is required. So there, if you read the rule and the act as a whole, the license can be granted in a proposed work. In your case, of course, in a proposal, of course, the employer will be within its right to insist upon an contractor that you had experience in using or employing contract labor, and you had an contract labor license, which may not be essential because until and unless as per the terms of the tender, contract license is there, you cannot allow the work. So this is the scheme of the act. Now, you will have to, that's why we are asking Mr. Nath to be here. We are not getting from first page to last page, I have read with my limited knowledge. And I have not found anything to suggest that somebody will have a general license for whole of Assam, that he's a license holder.
so that is, prima facie, that is the understanding.
No,
of the
that is
honorable
that is according to subject to what you
court.
argue.
What I'll simplify the issue, my lord, even more.
Mm.
My lord, I am a contractor.
Mm.
I got myself registered with the animal husbandry department.
Mm.
So at that time also, I'll have to give a labor license.
Mm.
At the time of registration also, I have to submit a labor license.
Mm.
My lord,
Under what provision? See, Mr. Das, what they insist, what they not.
No, there is a,
In a courts of law, I always make it clear that we will accept things which are authorized under law or which is the requirement of law.
trying
Yes.
to convey, my lord. Because
Hmm.
they have their format for registration with the department. Like PWD also have a format, my lord, irrigation department is also have a format. Like they have also a format. So they ask us to get ourselves registered, and that is renewed from time to time. So whilst submitting our registration, my lord, we submitted a labor license.
Mm.
I am a prudent businessman. I intended to work all over Assam with the Animal Husbandry Department.
You have good that also.
No, let me just.
Mm.
So I am a prudent businessman. I intend to work with the Animal Husbandry Department all over Assam.
Mm.
So I got a Form 5 from Animal Husbandry Department proposed to.
Mm.
Under proposed to engage, my lord, the Animal Husbandry Department can issue me a Form 5. So I procured that Form 5. I submitted my application for registration before the Labour Commissioner, and he gave me all Assam license, as well as the other bidders also got. Now the petitioner, my lord, he also got a Form 5. He submitted application for Kamrup district. He is also a prudent businessman. He wanted to work only in the district of Kamrup. So the requirement of that NIT is that up-to-date labor license. Now work is to be done at Sibsagar. Now, as per the scheme of 21(1), it provides that you have the license has to cover that area. Our license covers the area where work is to be done. His license does not cover the area. So that is the more simplified version, Miller. That is more simplified version since he does
So
not have-
therefore, to summarize your argument, since the authorities
So he is
insist.
not questioning that our licenses are illegal.
No.
What is it?
We are also not going
Let
to
us-
that issue.
Let us see.
We are not going at all into the whether your license is valid or not. This is not the subject.
What
matter of
his argument is that he has got a license for Kamrup and that license is registered with Animal Husbandry Department, so he is entitled.
Hmm.
Now, with all due respect, my lord, that cannot be an argument.
Hmm.
21(1) says you need to have a license.
Hmm.
So if that license you don't have
Hmm.
with regard to the place where the work is to be executed,
Hmm.
if I may read 21(1) again, my lord.
Hmm.
If you don't have that
Before that, you read section 11 and 13 of the act.
contract act. Yes. Chapter 4, licensing of a contractor.
Hmm.
11, appointment of licensing officer.
Hmm.
The appropriate government may, by an order notified in the official gazette,
Hmm.
appoint such person being gazetted officers of the government
Hmm.
as it thinks fit to be licensing officer for the purpose of this chapter,
And
and
read it.
define the limits within which a licensing officer shall exercise the power conferred on licensing officers by or under this act. True, my lord. If the Labor Department has issued a license covering all
So,
of,
no, therefore, Labor Department issuing licenses is not our concern. We want to understand who is authorized under the act and how a license is to be given. So
Yes.
paragraph, your whole rule will depend upon the section 11. Okay?
yes, the
So
limit has to be-
section 11, there are two parts.
Yes.
One is some persons is to be
appointed as
appointed
gazetted
as a
officer.
licensing officer, and second, and not or,
Yes.
and
Yes,
define the limits within which the licensing officer shall
Shall
exercise
exercise.
jurisdiction.
yes.
Now, what is the limit and why the use the
Functioning-
word of the definition is given limit, define the limits is given. Now
Yes.
come to section 13.
Grant of license.
Hmm.
Every application for grant of a license under subsection 1 of section 12 shall be made in the prescribed form and shall contain particulars regarding the location of the establishment,
Hmm.
the nature of process, operation or work for which contract labor is to be employed, and such other particulars as may be prescribed. The licensing officer may make such investigation in respect of the application received under subsection 1, and in making any such investigation, the licensing officer shall follow such procedure as may be prescribed. The license granted under this chapter shall be valid for a period specified therein and may be renewed from time to time for such period and on payment of such fees
Mm.
and on such condition as may be prescribed.
Okay, now come to 12.
12, Rule-
Section 12.
section 12, yes.
Mm.
Licensing of contractor with effect from such date as the appropriate government may, by notification in the official gazette, appoint no contractor to whom this act applies shall undertake or execute any work through contract labor except under and in accordance with the license issued on behalf by the licensing officer.
So you cannot execute a contract work without a license. Okay, so suppose you are having a license. Mm.
The department cannot execute the contract work
Mm.
without a license
Mm.
of which covers that particular area establishment.
Mm.
My lord, on the last date, I tried to persuade your lordships with regard to this establishment. So that aspect is absolutely clear to your lordships, my lord, what is establishment is.
Mm.
So
Establishment is defined.
if the
Establishment is defined.
true, my lord, I have seen
Ah.
two definitions are there. The
Not in
principal
the
and-
rules, not in the rules, in the act itself.
Yes,
Ah.
I have seen, my lord.
Mm.
Act itself it is defined.
Mm.
So here the establishment will be
Mm.
Shivsagar. There is no doubt, iota of doubt with regard to that.
Let us see what is the establishment defined.
Yes, my lord.
Come to the section.
I'll satisfy your lordship from the rules also.
No, let us go to the principal act.
Yes,
Why
yes.
should we go to the rules?
2E.
2E.
No, rule, I'll just come to that, my lord.
Mm.
2E.
Mm.
Establishment means,
Mm.
number one, any office or department of the government
Mm.
or a local authority
Mm.
or any place where any industry, trade, business, manufacture
Mm.
or occupation is carried on.
Mm.
So, office or department,
Mm.
so establishment as per one is the director, that is my office or department,
Mm.
and place where industry, trade, business, where the work will be executed
Mm.
or occupation is carried on.
Mm.
Now, if we have to get a clear picture of what is the establishment,
Mm.
Lordship will kindly come to the rule.
Mm.
Rule,
So therefore,
Fine.
we'll go to the establishment a little bit later.
yes,
So we have got the licensing authority. What is licensing authority? What is his jurisdiction?
yes,
Now relate that provision of area to
yes.
to Rule 21. Rule 21(1).
No, there is no iota of doubt with regard to the fact which will be verified by my friend that there has to be a licensing officer whose jurisdiction has to be earmarked. There is no iota of doubt with regard to that. Now here I understand what is troubling your lordship. Your lordship is
No. Let us see. Nothing is troubling us. Issue is
because he is to inspect. How he will
no,
inspect?
not only that.
Yes.
Forget about all this. Here, issue is very limited. Issue is a technical bid has been rejected on the ground that you are not having a license or some license
Yes.
or to the local area.
Yes.
So we'll have
No license only with regard to Kamrup.
Kamrup. So
The
therefore,
words are
will
there.
not permit, you are disqualified.
You are discovered.
So therefore, next question would be, suppose a person has not worked in except Kamrup. Okay. So therefore, according to us, it will mean that all persons beyond would not only those who work only a specific district or who has not worked all Assam, he is disqualified. That is to be your interpretation.
May I just place my version? Lordships, this proposed to, it has got serious significance. My lord. It was brought in by way of an amendment. Suppose, my lord, I am intending to participate in a tender process.
Mm.
I know that my work will be.
No, propose, let us again, before that I clear.
Yes.
Propose means when it is, the decision is made that I will use him.
No,
We propose to use him,
no.
subject to license.
no, my lord. Subject to correction. The propose, prior to propose, I have engaged.
Mm.
Stroke,
Mm.
propose to engage.
Mm.
I have engaged will be the first situation.
Okay, accepted.
So, if a tenderer,
Okay, fine then. Suppose there will be a license required after the work is given. That will be different. That license he cannot give right now.
no, my lord. Lordship, let me complete, my lord. My lord, propose to engage.
Mm.
So I am an intending bidder.
Mm.
I know that work is going to be executed in Kamrup.
Mm.
So it is my duty. If I have already have a All Assam license, fine, no issue. If I don't have a license which covers that area where the work is to be executed, then it is my duty to get a Form 5
Mm.
from the principal employer
Mm.
under this proposed to engage.
Mm.
I can get it.
Okay,
And thereafter,
not form 5.
Form 5.
Mm.
So then thereafter, I can submit an application before the, by filling a Form 4
Mm.
to get a license, whether
Now-
I get it,
now what
I
is the-
apply for all Assam or particular district.
Okay, fine.
That is in the Milord now ease of doing business. These things are done. Milord, there are tabs wherein district-wide license is issued and all Assam license is issued. That is my instruction from the client.
Mm.
So he opted for Kamrup.
Mm.
Even renewal also, when he renewed after this tender process, that is also with regard to Kamrup. Now, how can he defend that, Milord? It may be a mistake on his part, but that mistake is not curable. Nobody stopped him after the Milord publishing of the NIT to get a license, to get a Form 5, to submit a Form 4, and get a license with regard to Sibsagar or all over Assam, Milord. Now, how can he defend that by his statements made in para 7 of the writ petition? Lordship will kindly come to para 7 of the writ petition. It may be his mistake. I'm not saying he is playing something. It may be his mistake. Because getting labor license now online is a 10 minutes business, Milord. E-payment has to be made. Immediately, Milord, digitally signed labor license comes out.
This is the difficulty.
Lord,
Yes.
Lordship will. Lordship,
Yes.
So he could have easily got. So having not
So
procured,
according to you, in terms of the tender, a person is to give a labor license, a contract labor license to do engage contract labor. Now, what should be the form of that license? Earlier, relatable to other cases, or a general license that you can do it.
Milord, what?
So there may be two
Milord,
situations.
Milord,
What
one
is
thing I would like to just clarify.
engage and propose?
On the last date, Milord, I made a mistake. I just tried to, Milord, made submission that concept of previous license.
Mm.
Milord, there is no concept of previous license. I still
fine.
myself corrected, Milord.
Yes.
Lordship will just wipe out this, Milord, notion that the department will consider previous license.
Mm.
Now I skipped this proposed to.
Mm.
So that's why I thought from my mind that they were considering the previous license.
Mm.
Now there is no concept of previous license, Milord. It's a license. A contractor who intends to work with the animal husbandry department, I am a contractor, I registered, and at that time itself, I decided that I will work anywhere in the state of Assam with the animal husbandry department. I applied for all Assam license. Labor department granted me all Assam license. Now, whether they have given me correct or wrong in terms of the rule, I don't know. But the fact remains that by invoking that proposed to, engaged, they could have got a Form 5 from the principal employer after the NIT. Because they are also a prudent businessman. And they would have submitted Form 4 before the licensing authority or the labor commissioner.
What is your date of your license?
My date of license is, my lord, I'll just place 2023, my lord.
No, give the date.
My date of license is, my lord, date of issue 13/6/2023. It was when we registered, we submitted. That's why they
What is the period validity?
up to 10/6/2024. NIT issued on 5/3, last date of submission of bid 5/3/2024.
Okay.
That's why the department in their affidavit said that we searched for the historical document, not with me. I'm all right. His case is with regard to the other two respondents. That's why department says that when we search for the historical document, we found that they have a all Assam license. Similar situation with them also. I'll come another aspect, Milord. Let us first clarify this. So you were supposed to do that. You did not do. Now you made up a case at para 7. Lordship will kindly say para 7 of the writ petition. The petitioner respectfully begs to state that the grounds and oblique or reasons for rejection of the petitioner's bid was labor license is valid for Kamrup district only, quote unquote. The ground for rejection of the technical bid of the petitioner is non-existent, absolutely fallacious, in view of the fact that the copy of the labor license, although indicated that the labor license is valid for Kamrup district, however, the copy of the license categorically states that the said license is valid for undertaking work of contract and supply in the establishment of Director of Animal Husbandry and Veterinary Assam, care of Seniguchi, Guwahati, Kamrup Metro, Assam, meaning thereby the petitioner is eligible for undertaking any contractual work in the Animal Husbandry and Veterinary Department, and hence the rejection of bid of the petitioner on this count is absolutely irrational and not tenable in the eye of law. If we accept this, will it not be in violation of 21(1) establishment? Now let us understand what is this establishment is all about. Lordship will kindly come to the rule.
Rule, which rule?
Lord, I'll take your lordship to the several rules from where your lordship will get an idea what is establishment is all about.
Okay. No, establishment is defined. What more is required?
No. Why I'm saying so? Establishment is one in
Defined in the Central Act.
If your lordship is convinced that the establishment is the Sibsagar, then I don't need to take your lordship with all this rule. Because I am.
You want to say that
the
Animal and Veterinary Department is not the establishment. Establishment is the branch office at the Sibsagar.
I'm not saying the branch office. The establishment will be the place where the work is to be executed.
Okay.
That is what I am trying to portray.
Okay.
Lordship will kindly come to Rule 25 6A.
25
6A, Roman 6A.
(2).
25, my lord.
25
2. Yes, 25 2. In the next page, my lord will find
5 to Roman
6A.
6A.
I'll just take your lordship with one or two portions which will give your lordships an idea with regard to establishment. In every establishment where 20 or more women are ordinarily employed at contract labor, there shall be provided 2 rooms reasonable dimension for the use of the children under the age of 6 years.
Okay.
Establishment is the place.
The place.
Now, lordship will kindly come. Rule 40.
Rule 40.
Chapter 5, page number 295, my lord. Lordship, you got me, lord?
Just a
I'm sorry.
Rule 40.
I'm sorry.
Yes.
41. 41. the facilities required to be provided under section 18 and 19 of the Act, namely sufficient supply of wholesome drinking water, a sufficient number of latrine, urinals, washing facilities, first aid facilities shall be provided by the contractor in the case of the existing establishments within 7 days from the commencement of the rules, and in case of new establishment, within 7 days of the commencement of the employment of contract labor therein.
That the
Now,
place where,
41,
where the work is executed, where
exactly,
the laborers are engaged,
engaged.
that is the place of establishment.
That is the establishment.
Yes.
Lord, with regard to
Accepted.
21(1).
Accepted.
So if that be so, you need to have a license which covers that establishment under 21(1). Also, will kindly have a look at 21(1).
Suppose, okay.
He is saying,
Accepted.
Yes.
Suppose there is a license against an establishment, maybe Sibsagar, maybe Jorhat, maybe all Assam. Okay. What does it mean then if you relate to all this? How can, that is the question I was asking from the day one.
sorry, Miller.
Suppose you have given a license of whole of Assam.
Yes.
Where are you have, where is the assurance that you are having this much, you are having that, where is the certification?
Certification means, Miller?
For this, see, what is the mandate of the license? That I will comply with the provisions of the Act and rules.
Yes.
Okay, what
If I
is the
fail to,
provision?
if I fail to fulfill the mandate of the act and the rules, that the facilities I have to provide to the contract laborers, wages, authorities are there. They can question me.
Therefore, don't be so.
Yes, yes.
Don't jump into
I'm sorry,
conclusions.
I'm sorry, Miller.
Don't jump into conclusions.
No.
We are again coming back to your provision.
Yes,
Section 25(2)(6).
25(2)(6). Yes.
What is the purpose of insisting a license, contract license in the tender? Tell us that first.
So that the provisions of the act and the rules with regard to, Milord, the engagement and the, facilities and emoluments to be given to the contract
Let
laborers.
us not,
are
Lord,
fulfilled.
let us not lengthen the sentence
I'm sorry.
to ascertain that the benefits given under the act
Yes.
or rule are complied with.
Yes, Milord.
This
Yes.
is, so what is this rule?
So is it
20?
his case that I, being a licensee
No,
of
no.
all over Assam, I will not be
See,
able?
We know we are not here to decide whose license is good, whose license is bad. Number one. Number two, here is a contract condition which says you must have a license, labor license.
Up-to-date labor license.
Up-to-date labor license. The tender conditions nowhere clarifies that it should be a state or to the specific district, or that you have a license earlier, that you have an experience of executing or engaging contract labor in any of the projects, so that in this case we have a satisfaction that yes, you will be able
What
to
should be trying to say
listen,
that?
listen.
I'm sorry.
Listen.
I am sorry. I beg apology.
Okay. So what would be the object of the incorporating an one-liner condition that contractor must have a labor license? Okay. So there will be an interpretation. You will argue that the employer is the best person to interpret a clause. There is no quarrel. Now, through you, they are interpreting that this license, according to us, will be a license either whole of Assam or in the Sibsagar district.
Just one line, Miller.
Okay.
What they are interpreting is that they want a license which covers that area. They are not saying that
No.
you have to give a license either all over Assam.
Covers that area.
Yes,
Okay,
exactly.
covers that area.
Exactly.
And Assam license will cover Sibsagar also.
Yes.
And Sibsagar license will also cover Sibsagar. So there are two situations. A contractor will be qualified if their interpretation is accepted, that a license should be relatable either to the state of Assam or to Sibsagar. Okay.
Yes.
In that context, we are asking, so as the provision of such kind of a license to approve this interpretation.
Such kind of
Such kind of license.
all Assam.
All Assam or the of the area. So give us that handle to accept their interpretation.
You know,
We understand.
21(1). I'm sorry.
We understand recourse limitation that it is the interpretation given by the employer,
There-
not by anybody else. The second question will be whether this will be an essential or not. And essential is to be determined in the context what it requires. Because that license will not make the person, even if contract is awarded, to execute the work. Do you agree?
Sorry, my lord.
Suppose the respondent, your client is having a license of the state.
Yes,
Tomorrow, your work is awarded.
yes.
Do you propose to say that the license on the basis your technical bid was accepted
Yes.
is the final license? You will
No,
have to
there
have a
is
fresh
no-
license.
no, There is no question of final
No,
license.
you will have to.
That is what I am trying to.
So therefore,
take
you
your
will have
lordships
to,
away.
you will have to have a fresh license relating to
No.
that project.
No, with
Okay.
all due respect, my lord,
Okay.
subject to correction, my lord.
Yes.
And subject to correction. That is what I am trying to, my lord, take your lordships out from my submission on the last date. I somehow
So
projected a
according
case
to
of
you,
previous-
no fresh license under contract labor,
No.
we can record it.
Yes,
This is, yes, you are also saying?
because why I'm
Let's
saying,
just take
I'm-
it because we should hear her, not you.
my lord, that's true. I am only submitting on the legal position
We'll hear her because we'll have to record who has submitted this. Yes,
because my that.
just take
I'm
a
sorry,
minute.
I'm sorry.
What is your argument?
Up to date license.
What do we mean by up-to-date license?
They should have a up to date license.
What is the what is the license per se, contract level license? Because ultimately they may say we have not argued all this,
My lord, lordships,
isn't it?
definitely, my lord.
Yes.
Lordship, I'm only on the big document, Lordship, only.
No, see, madam, just listen to us. Your one of the condition of the valid tender is that the bidder must have an up-to-date labor license. And you have rejected his case saying that you don't have a, what is the language? Don't have a?
Up to date labor license.
up to-
Labor, no, you don't
No.
have the labor license for that, only for the Kamrup district.
You don't have a, you have only a license for the Kamrup district, okay? So therefore, you are, as an employer, you must have interpreted,
Lordship.
is that it?
Right.
So according to you, how the license can be issued?
Lordship, like kindly turn to page annexure 6 of our affidavit, that is 387, Lordship.
Okay. 387, yes.
87, Lordship. That is form 5, Lordship.
386, 87.
7. 86, 87, both are form 5, form of the certificate by
Mm.
principal employer, Lordship. May I read, Lordship?
Mm.
Certified that I have engaged,
Where page,
page number 387, annexure 6, Lordship.
annexure 4, we have annexure 5, annexure 6 is something different.
Annexure 6, form 5, Lordship of
Okay.
certified that I have engaged, have proposed to engage Giant Account, KB Road, North Lakhimpur as a contractor in my establishment. I undertake to be bound by the provisions of the Contract Labor Regulation and Abolition Act 1970 and the Contract Labor Regulation and Abolition Assam Rules 1971
Mm.
in respect of employment of contract.
Now, where is your application? Where is the application of the respondent? This is N 386, that Khanapara Guwahati Development Department, joint account. Which joint account?
Respondent number 7.
And who is
Six.
consulting engineer?
Consulting engineer is the.
And who is the other one?
Other.
Who is the L1? You are,
No,
this-
no, no, L1 is the.
your is
respondent
joint
number-
account.
No, no, Lordship.
I am his friends.
Where is that? Where is that
Yes.
application?
Lordship.
382.
My
There is
respected seniors, academic.
382. Pagination are defective. 379. 381. Medicos engineers.
Lordship, annexure 1.
No, no, Medicos engineer.
No, Lordship, it's
Huh?
Trans Enterprise is respondent number 5, who is the lowest bidder, Lordship. L1 is Trans Enterprise, that is page number 366.
Annexer.
Annexure 1,
Annexer 1.
that is. the labor
License.
license.
No, that license we get, but in case of others, you have annexed the application.
Yes, I have the application
Not
also.
in my respect also, since date of issue of the license is 13/6/2023. My form 5 is prior to that. My grant of license date, page 366. Lordship will find 13/6/2023.
From top, fourth line from the top, Lordship.
Date of issue. Date of issue is 13/6/2023.
Mr. Nath, what is your notification as regards appointing licensing officer? Under section 12?
That I'll get. That I'll get by this time. But my instruction is not that the labor commissioner Assam, the assistant labor commissioner of a district, and labor officer in some places, they are the licensing authority in Assam. But what happens, Lord? Just I'll before taking your lordship to that, Lord, I'll refer to 2-3 sections of the main act.
Hmm.
The section 7, Lord, as regard the establishment.
Hmm.
Let us Lord, I feel that
Huh.
the establishment idea has to be clear first.
Mm.
The registration of certain establishment.
Mm.
The establishment in this case, establishment is the Directorate of Animal Husbandry. That is the establishment. Well, kindly come to section 7.
Mm.
Every principal employer of an establishment to which this act applies shall within such period as appropriate government may by notification in the official gazette fix in this behalf with respect to establishment generally or with respect to any class of them make an application to the registering officer in the prescribed manner for registration of the establishment. So ultimately,
So
the
your establishment is registered,
veterinary is a registered principal employer.
principal employee.
That is why they can give form 5.
That's why they can give. But who will give the form 5 then?
Kindly see the form 5. Lord. Kindly see.
Hmm.
Kindly see form 5.
Hmm.
Signature of the principal employer, name and address of the establishment.
But here it is not given by the principal employer,
No, form 5 has been given by the director.
director.
Page
Okay.
number
Okay.
page number
Okay,
387.
fine.
387.
Hmm.
Not that one. But 387, Lord, if lordship comes to 387. please,
Mr. Nath, can you argue on behalf of this department also as a senior government advocate?
can, Lord. But
Just
I have
assist
to-
us.
I have to just go through the affidavit, what is there. Lord. I don't have the affidavit, what is the stand taken. Otherwise, Lord, the question which lordship has posed, Lord, I have taken the instruction on that. If lordship kindly comes to annexure 5
Annexure 5.
in the affidavit, Lord,
Okay,
I have seen this today.
Hmm.
This is the form 5 issued
okay,
to the
fine.
issued to the petitioner.
Hmm.
This is in respect of petitioner. Well, this is the signature of the principal employer, name and address of the establishment. So this is the form 5 given to the petitioner.
Hmm.
We are taking the example of the petitioner, Lord. So, Lord, what is going on in this here, Lord? Whenever a tender is issued by a principal employer, or the PWD, suppose PWD is a principal employer, the chief engineer is the principal employer. After issuance of the tender, all the intending bidders, they used to approach the chief engineer to get form 5. And they used to, after obtaining the form 5, they used to apply online. Because now the system is online.
Okay.
Or in online system, they have to choose from which licensing officer they are seeking the application.
Hmm.
From the ALC concern, or from the labor commissioner Assam, or from the labor officer of in some places where district X is
Understood.
not there.
Understood.
So, Malab, there they have to choose the area also.
Hmm.
They have to choose for which
So
area.
therefore, that notification is very important.
The-
Can you give a license all of Assam, you are licensed.
Yes, no, the labor commissioner issues the license for the Assam and
So
what.
that's why, because
Hello.
it is to be notified under section 12.
True, madam.
And we do not see any, because see, this, whatever we will decide, will have a far-reaching consequences
Correct.
on the act itself. So
What they
where
do-
is who will monitor all this?
No, Malad, what they do after issuance of the notice, the license by the labor commissioner, they used to in their portal, it is available with them that to whom the all Assam license. they have
Just
given.
in the meantime,
Look,
the monitoring is given to the licensing authority. Power of monitor and implementation.
paid by them to the concerned establishment where the work will go, because there are some contractors, Malad, some big contractors under PWD, Malad, suppose PWD, they used to do 5-6 works or 10 works at different places.
Hmm.
That is why this all Assam thing has been made. And Malad,
No, see, Mr. Nath, we
Mal-
don't have any problem. You're doing certain things.
that has
But
been done.
our question is whether those things are done in accordance with the act and the rule.
True.
We cannot accept because Mr. Commissioner is made a form, this required, so they have issuing this. We are not concerned with it.
No.
We are concerned with what law permits
Notification.
and what is the procedure given by law. That's all.
True.
And if that is
That
not
can-
there,
that-
whether this license will be an essential condition for which a person will be ousted.
No, that is of course with the tendering authority, their decision is taken by them, Malad. So for the labor department is concerned, I am just apprising
No, therefore, this is because this is vital issue.
True.
What is the nexus of that license with the project? Ultimately, that can be granted, proposed also, for subsequently also.
for a Form 5 is very clear, whatever or proposed, because all the intending bidders,
Mm.
they used to take nowadays, they used to take, because the license is a condition in the contract NIT. That is why Malad, this sentence says that I certified that I have engaged or proposed to engage.
Engage.
So all the 10 intending bidders they used to take, ultimately one will be there,
Mm.
others will not be there.
Not be there.
Logic. So Malad, after issuance of the All Assam license, in their portal, it is available with the labor commissioner. Labor commissioner,
So therefore, let
Issues
us
the-
come to,
law.
let us see the form 4.
Form 4, logic.
Mm. Form 4.
Logic.
Yeah. Form 4.
Form 4.
Mm.
Here, Malad, the name and address of the contractor that the individual contractor will give. Particulars of establishment where contract labor is to be employed,
Mm.
then Malad, the principal employer.
No problem on this,
everything
you will
will be-
give. Mm.
Look, particulars of contract labor, nature of work, and what is the type, Malad, they will all fill up. Malad, now, all this has to be given online, Malad, everything is online. Whether the contractor has worked in any establishment within past 5 years, if so, give details of the principal employer, establishment and nature of work, or everything has to be given. Whether a certificate by the principal employer in Form 5 is enclosed.
Now,
This
see,
is-
what is the relevance of this, whether contractor has worked in any of the establishment within past 5 years? If so, give details of the principal establishment, so and so.
Logic.
Okay,
Then Malad 8, whether a certificate by the principal employer in Form 5 is enclosed.
Mm.
This has to be enclosed.
Mm.
And license fee,
okay.
that this has to be
This can even be given at the time of tender process.
100%.
No issue. They
Yes.
can file an application at the time of tender process.
Yes,
Okay. And now come back to again Rule 21(1).
yes.
Okay.
So Malad, just Rule 21, right?
Mm.
Application for license.
So how do you, relate to this section 21 to the contract condition?
Malad, my respectful submission is, Malad, in the central.
We accept everything
Yes.
that there can be a license even at the tender process, as Mr. Das is proposing. They can file application, the employer will give a certificate, fine. And a license can be granted. Now, section 21 says it is to be filed to the licensing officer of the area in which the establishment in relation to which he is a contractor is located.
Logic. Malad,
suppose he is a contractor in Rongya or Kamrup. Under Kamrup, you have given a certificate principal employee, he is having a license so far relating to the
But-
Kamrup.
Matlab, if the work is matlab under Rongya Municipal Board suppose.
So do you want to
Then-
say that this condition includes a labor license for the project in question?
Matlab, the principal employer has to have a registration. And they have to give Form 5.
Hmm.
Matlab, ultimately in the.
No, no,
project
Form 5,
document-
they will have to file an application under Form 4.
Yeah.
And Form 4, along with the Form 4, there is a declaration that I have Form 5.
Form 4.
Because
comes
Form
third.
5 is condition precedent, then while filing the Form 4, they will have to annex the Form 5. Now, Section 21(1) says to file the Form 4 where?
Form 4 is before.
Where
the-
to be filed?
Before the licensing authority, from whom he applies the license.
No, read 21(1).
Every application by the contractor for the grant of license shall be made in triplicate
In Form
in
4.
Form 4.
Okay, let us
to
stop
the-
here. Let us stop here.
Logic.
Now go to 2. Sub-
Every application for grant of license shall be accompanied by a certificate of the principal employer in Form 5
Hmm.
to the effect that applicant has been employed by him as a contractor in relation to his establishment and that he undertakes to be
Okay,
bound
that is
by-
fine. So that 5 is to be filled up by the principal employer. In this case, that is the head of the animal and husbandry director,
Okay.
whosoever.
Yes,
Okay. Now, in case of this, both in his case and his case, everybody's certificate is there.
certificate. is-
Certificate is there.
Now
So
the-
with that certificate, he will need to fill up the Form 4. Okay. Form 4 also, all are having Form 4.
Yes.
Now to whom it is to be applied and who will issue the license?
It has to
No,
be-
let us read the,
Applicant
let
has-
us read the Rule 21(1). Proceed further.
Yes. Licensing officer
Hmm.
of
Slow,
the,
go slow, go slow.
to the licensing officer of the area in which the establishment.
Hmm.
Matlab, I'll just indicate, matlab,
Hmm.
to the licensing officer, here we have 3 licensing officers.
Hmm.
Of the area.
Hmm.
Matlab, one licensing officer has the jurisdiction all over Assam.
Hmm.
One licensing officer has the jurisdiction over a district.
Hmm.
Now, matlab, in which the establishment is the director. Matlab.
Hmm.
Director is having jurisdiction all over Assam.
Hmm.
In relation to which he is the contractor, is located. So ultimately, to the licensing officer of the area in which the establishment, in relation to which he is.
So therefore, the license is to be issued by either Kamrup or by the commissioner. If we go by this.
Matlab, licensing, yes. That is why he has applied for Kamrup.
Kamrup.
And the license says that it is valid for Kamrup only,
Kamrup
because the Kamrup officer can.
Yes,
give
he has,
license for the
he has
Kamrup only.
applied for the assistant commissioner. So assistant commissioner issued a license for Kamrup.
While applying online.
So you
While
have,
applying online, he should have.
no,
opted- he
we
should
are
have
not
opted.
issue. There is no dispute on that his license is relatable to Kamrup. His license is relatable to whole of
All-
Assam.
All of them.
Now, accepting everything, can that be a ground to discard a person from until and unless you declare that its license should be relatable to Shivsagar?
That is on the merit of the case.
Ah,
That
okay.
is on the merit of the case. That is on the. Take some time.
Huh?
Because what my friend, I don't think my friend is prepared with regard to 21(1) submission, what my friend has given, because he was supposed.
So
to
your
get instruction.
submission is 2021 location will mean
Six seven.
Shivsagar.
Ultimate interpretation for deriving conclusion is with regard to the establishment manual. With all due respect,
No, establishment.
Lordship is. not-
Establishment, there are
I understand.
two contexts in the establishment.
In.
One under 21(1), which is relatable to Form 4 and Form
Not
5.
21, I'll just make myself clear, then your lordship will pose a query. 21(2), the establishment
Mm.
is the principal employer. There is no doubt about it.
Mm.
Because if we plainly read this, it says every application for grant of a license shall be accompanied by a certificate
Mm.
by the principal employer.
Mm.
In Form 5,
Mm.
to the effect
Mm.
that applicant has been employed by him
Mm.
as a contractor in relation to his establishment.
Mm.
If a director gives a certificate
Mm.
in relation to his establishment, it will be by the, it will be the directorate.
What do you say,
Employee.
what do you mean by the to his establishment?
To his establishment means it's the directorate. Because his establishment is directorate.
Okay.
That's why in the definition of establishment, there are two things.
Mm.
Two definitions, 1 and 2. One is the employer, officer, or the head of the office. Second is the place where the work is to be executed.
Mm.
That's why two definitions. Now, if your lordship reads Form 5, what he say? It doesn't say that I am proposing or I am giving Form 5 for this particular work.
Mm.
He generally says certified that I have engaged, proposed to engage.
Mm.
Now, this proposed to engage is not there in Rule 2.
Mm.
My friend has rightly just now said that engage in an emphatic manner, but we have to read the form and the rule. Now, that's why it says certified that I have engaged, proposed to engage the applicant ... name of the contractor as a contractor in my establishment.
Mm.
That is in the directorate.
Under the directorate.
Now, 21(1),
Mm.
if we have to understand 21(1), then that's why I have taken to the various provisions of the rules
Yes.
to make your lordships understand that what is establishment. Every application by a contractor for the grant of a license shall be made in triplicate in Form 4 to the licensing officer of the area in which the establishment, in location to which he is a contractor, in relation to which he is located. Licensing officer of the area, if it's a directorate, then where is the requirement of 21(1)?
So therefore, it
So that
should
is
be,
what I'm saying.
it should be relation to which the
Milord, I may be wrong, Milord.
establishment is located.
I may be wrong.
Establishment is located.
Yes.
So what is the establishment in terms of 21(1) in this case?
25(5), 25 Roman 6.
Establishment.
Establishment.
Where the contract is to be executed.
Contract is to
Where
be-
is your license from that area?
Lordship is going to an area. Lordship is kindly appreciate. Here the issue is
No,
not
had
that.
the contract clause been clear,
No, it is the employer has that liberty. They can interpret a particular provision. That liberty they have. They said up to the
that liberty they have, but
Now-
they cannot interpret sun to be moon. We are judicial courts are here,
Your
judicial.
lordship.
yes.
Milord, your lordship has all the power.
See, no, we don't have all the power.
No.
We have the
Okay.
power whether Article 14 is hit.
Yes.
Okay,
There is
Article
no hit of
14
Article
is
14.
when it is when it is a contract. In contract, our power of judicial review is very limited. We are aware of our power. But here it is a case, they says up to date license. So moment they say up to date license, we will have to dig what is a license?
True.
Who will issue a license? Because your ground is that license has been issued by Kamrup, therefore not acceptable. License has been issued by the all of Assam, so therefore it is valid. This is the ground. So whether that decision in the context of the act and the object of the act and rule is violative of Article 14, that's all. Nothing more, nothing less. Therefore, we are not going whether, what is being done, what is not being done. The act says you must have a licensing authority to an area. An object of that act, a purpose of that act is so that it can be monitored by the licensing authority. Isn't it? Why then reason is given? This could have been state can issue. A specific mandate is given by the act. Now, therefore, the notification will be important. And what is his area jurisdiction? Suppose a commissioner is given a jurisdiction of whole of Assam. Now, what is the under the authority of the, what is the necessity of giving area to different assistant labor commissioners?
It is required because suppose Romia Municipal Board,
Hmm.
they are also registered. Now a work will be done at Romia. then the officer of that jurisdiction can also issue.
That
to
we
each-
understand, that we
to each-
understand. But
to
the
each-
labor
each person.
commissioner in Assam also is issue.
Yes, yes, labor
So
commissioner-
what is the, see, if
While-
labor
while
commissioner can
applying-
issue for whole of Assam, if his jurisdiction is whole of Assam, where is the giving a multiple jurisdiction to others? We'll have to answer it.
Malad, while applying for online, these are three authorities, then the particular contractor has to choose.
There
from
is
both.
no, Mr.
And
Mr.
Malad-
Nath, that is why again I am repeating,
Malad-
I may not be able to make you clear that whether it's your online application, whether by a postcard application, this is to be supported by law. Your online software cannot be beyond the scope of an act. We are not going to what you have determined, but we'll have to interpret.
Malad,
In this context, whether a license by a Kamrup authority can be thrown out in this context of the scheme of the act. That's all.
That lordship has to ultimately adjudicate.
That
Well,
is
as-
adjudicated.
as-
As
the
license, it has been written Kamrup only, why that is written then?
That's why.
So
So therefore, the question will come,
cannot go beyond Kamrup.
beyond
That's why
beyond Kamrup.
cannot go beyond
Hmm.
Kamrup, and he doesn't have the license of beyond Kamrup.
Hmm.
So how it will?
Then
But-
therefore, we'll have to see
As regard-
where is the scope of giving an Assam, whole Assam under.
Perhaps, Milord, is it, Milord, subject to correction, Milord? The issue is very plain and simple, what my understanding is.
It is not
See-
very plain and simple.
No,
It
No,
it
fact,
involves,
fact,
it
it has
is,
to be
it
decided.
involves public exchequer.
correct.
It involves the condition of the condition of the tender, a license. What the, therefore we'll have to dig what the license is.
Absolutely. Lordship will
Because
go in.
it had it been clear that a license must pertain to this department or must be applicable to either whole of Assam or to Shivsagar, there would not have any question.
The issuing authority, but
Malad,
let my friend come.
the establishment, what is the projection made by my understanding? As regard the establishment, that may not be correct because the establishment has to be registered as per section 7 and the principal employer has the registration. The particular office of a particular district, they are not registered, they are not the principal. employer.
Not registered.
Because the principal employer has given the form 5 and
Because
he is the director.
fundamental issue is more than licensing a contractor, fundamental issue is the registration of the establishment.
Principal
You
employer.
must, principal employer must register.
Yes, and so the director, veterinary, director of veterinary having jurisdiction all over Assam. And they are having, because of that, the labor commissioner, that has been made. And that notification I will place, that the labor commissioner has the jurisdiction all over Assam. Wherever, because the contractor may today work at Kamrup, tomorrow he may go to Jorhat.
No problem on that.
But-
That,
Because
if,
under-
if you
under
are,
this
if you have
department-
issued a notification in exercise of power under the act, no problem, you have given an as whole of Assam, you have given an Kamrup, but whether license given, up-to-date license will mean a license for whole of Assam, or is it will mean a license for us, our district? That is not clear. And that will have to take a call, whether it will be a validity of Article 14 or not, on the basis of the scheme of the act. If scheme permits,
If I submit that is on merit, but I'll just make.
no,
make
that
my
I
submission,
understand.
Make my submission, Lord. But the decision-making process Lordship is examining.
Hmm.
The authority, they found that a person is holding a certificate which has, the certificate itself says that this is applicable for Kamrup only.
Hmm.
And he has to execute the work at Shivsagar.
Hmm.
That is why they have taken the decision, Lord. Whether it is so arbitrary, well, that is the.
Now, second,
that is-
then
that
the
is
second
Lordship's
question will be, second question will be
No.
whether the license given shall suffice the contract.
But that is the second question, Lord. And now,
Therefore, second question is intrinsically connected to the first question.
now, Lord, as regard the power of the licensing authority.
No, we are not, basically we understand what is the scheme of, that's why we wanted your assistance.
Yeah. The power of the licensing authority, Lord, as per the provision of the Assam, these rules, the licenses are being issued by 3 authorities,
Hmm.
that notification I will place. And 3 authorities, Lord, the labor officer and the labor officer is having jurisdiction over a particular area.
Hmm.
Assistant labor commissioner is having jurisdiction only within that jurisdiction, because the ALC of a particular district cannot certify cannot give license to a person, to a contractor beyond his jurisdiction.
Hmm.
So the Assistant Labor Commissioner Kamrup cannot give a license beyond the jurisdiction of.
So license is having three kind of authorities,
Three authorities. are-
3 or 4 maybe.
Three,
So
three.
one is region is specified that this may be for a local area. Some is for the whole of the district.
Lottery,
Some is for the state of Assam.
State of Assam.
So everybody is having a power to issue a license.
Yes, madam.
Now, admittedly, the employer is not seeking a license relatable to the work in question.
He said a valid license is required.
Valid license is
Valid
required.
license.
Now, a license issued by Kamrup is a valid license.
But they interpreted that since the work belongs to Shivsagar, so your
So
license
that
doesn't
will,
cover-
that also will accept it, provided they can show that no further license is required. That original license is over for a contract, specific work. Who will look into that building, the hospital, there is having 10 this kind of things.
Look,
It is relatable to that.
that accountability will come to the principal employer. Because the provision of the
Ah,
act says-
that we have seen.
provision of the act says
Mm.
that the principal employer, because this Form 5 itself is very clear.
Mm.
It says that the second sentence, I undertake to be bound by all provisions of the Contract Labor Regulation and Abolition Act 1970
Mm.
and the Contract Labor Regulation and Abolition Assam
Mm.
Rules 1971 in respect of the employment of contract labor by the applicant in my establishment.
Mm.
So in his establishment, the 1970 Act and the 71 rules will be applicable and he will implement it.
Mm,
This is the undertaking given by the principal employer.
mm.
So if there is any violation, ultimately he is responsible for that.
Mm.
So the director herein, he has given this Form 5, the certificate, this is the certificate, madam, Form 5 is a certificate
Mm.
by the principal employer.
Mm.
So the contractor has to abide by some conditions, and that is why the Form 4.
So therefore, then if we accept all of your argument, then the question will come whether a person can be deprived from an work only on the ground that though his license was issued by a competent authority, but not relatable to the area in absence of any clear indication.
Then, my lord, the ultimately Lordship is posing an issue that when a person is otherwise eligible,
Hmm.
he
Can he be ousted?
only because of
Because his
Kamrup or
license
Shivsagar.
is,
because
the
he-
object of the
Object.
contract is the condition is to follow the mandate of Contract Labor Abolition Act and the rules thereof.
otherwise he has the competence to employ contract labor.
Employ contract labor.
That is the object.
That is the
That
object.
is the object.
Employ
So
contract.
now the area,
Hmm.
whether the area
Whether
is-
the area is relevant for the execution of that work. A building is be constructed.
that will be the
That will be the
ultimately
test of Article 14.
object. That is the object. That is the object.
Yes.
That is the object.
Thank you for your assistance. Give the notification.
I'll- Matlab,
Yes.
As regard the merit, matlab, if it
Now
is
we'll now
because
hear
I have to-
Madam.
I have to go by the feeding floor.
Hmm.
I have.
Yes, Madam, come
I have not
forward.
seen one.
You be here.
I am here.
That if we may ask you to assist
Lord,
after the period. Yes, Madam, Argo. Affidavit filed by whom?
Affidavit is filed by the director, Lordship. Our affidavit is filed by the director.
Hmm. Okay.
Okay, before starting that, I'm going to the affidavit filed by my learned friend for the consulting engineering, Lordship.
No, we'll go to their affidavit later on. Let us understand what is your stand. Because till now we are on the scheme of the act. Now we'll come to the facts. Yes.
Before going to the just,
No, we'll see your reason, then we'll go to his affidavit.
Lordship. From paragraph 8, Lordship.
Hmm.
Page number 355.
Okay, that is your ground. The labor license of the petitioner is valid only in Kamrup Metropolitan. Therefore, the bid of the petitioner was rejected, which was as per the terms of the, which were as per not the terms of the, as per terms of the NIT.
Lordship. Paragraph, Lordship. Which page, Lordship?
Page 5, page 3, page 5, internal page 5 of your paragraph 9.
Thanks, Lordship. And they to submit that because of the Directorate of Animal Husbandry and Veterinary Department is sending it to Kamrup Metropolitan submission of labor license only for Kamrup Metropolitan District doesn't make the petitioner eligible to construct the multi-care hospital in Sibsagar district as per terms and condition of the NIT. Therefore, the allegation of ground of rejection of the bid of the petitioner as absolutely irrational and not tenable in the eyes of law. We are being based on the 30.2 of the NIT document, Lordship. Okay, one context is there which I come to know from the department, Lordship.
Mhm.
That till last year, 2000.
How anything has been defined in the term of the contract? What are the historical documents?
Yes, Lordship. 30.2, Lordship.
30.2.
30.2, page number 55, Lordship. No, Lordship, page number 50. Okay.
Page 50 of
Page 50 of the petition, Lordship. It is defined 30.2.
Mm.
The bid evaluation committee may request the
You have
bidder.
quoted at paragraph 10. That is
That
paragraph
is
10 of your
paragraph
affidavit.
Paragraph 10 of our affidavit. The bid evaluation committee may request the bidder to submit necessary information and documents which are historical in nature, like audited statement of account, tax clearance certificate, PAN, etc., within a reasonable period of time. Failure of bidder to comply with the request within the given time shall rejection of the bid.
What is the public procurement rules 2020, which is relatable to clause 30.2?
The procurement. Public procurement. Okay, I'm just. Seven. Okay.
What is the clause 2AD3?
Act, Lordship.
Clause 2AD3. Section 4 of the bid document. Page
Section.
That's at page 55, your lordship, which says that you have to have the labor license, ESIC, and up-to-date EPF challan.
That is in the page
55, your lordship, of the writ petition.
We have short for the shortfall documents as per the public procurement rules, Lordship.
What are the shortfall documents? What the rule, what is the relevant rules? That is your grounds, that's all.
That is not, Lordship, as it is in the big document, Lordship. Earlier also, the department told that earlier also till 2022, Lordship, they didn't know about the labor license. They have accepted labor license from PWD or something. The petitioner had submitted in their affidavit also. They have procured one project in Silchar, giving a document of PWD, labor license of PWD for all over Assam. They get the
Your whole case is that we want either Assam or Shivsagar, either Assam or from Shivsagar, and he also submitted North Lakhimpur, somebody who submitted North Lakhimpur.
Joint account.
Joint account submitted North Lakhimpur, but we find out historical document that he is having a license of state, so therefore we have accepted this. That's your case.
Actually, in the portal, when
No, that is historical document.
this is for historical document, but we want either all Assam or a document where that particular district is included. Some of the licenses perhaps they have included 2-3
We
districts
understand.
also. Lordship.
Let us not go to all the debates, all this licensing and not licensing. Just give us the notification. Yes, Mr. Das.
Perhaps, Milord, I have been able to convey to your
Yes.
notice, Milord, that whatever be the establishment, whatever be the principal employer, the main issue is that whether with this license, which is only pertaining to Kamrup, it has specifically stated that it's only belongs to Kamrup, whether he can be a valid tenderer with this license.
No, another question is there.
Yes.
Another question is there, whether in terms of the contract, it is a valid license. Number one.
Chief has to consider rule also in that event to come to that conclusion.
They say,
Because
they
rule-
said that this is not a valid license for the purpose of this contract. It's a valid license. Otherwise, it's
for
a.
the, yes, otherwise he is registered with the labor.
So
license.
according to them, this is not a valid license because the condition is a valid license. According to them, it is not a valid license.
Because of the,
According to them, it is not a valid license because it the valid license should be either by state or by the where the contract is to be executed.
Yes.
That is their interpretation. Now we'll have to look into whether license, what is the validity of a license, and in the scheme of the act, if a license is valid and the term of condition is a valid license, the interpretation so made by interpreting that his license is not valid will hit the Article 14 in the scheme of the tender as well as the scheme of the act. That's all.
validity of license qua the tender.
Quite a tender.
It's not that tomorrow a tender is issued with regard to Kamrup.
Quad tender question
Tomorrow-
will come. Quad tender is the interpretation, not the condition of the contract. Condition of the tender.
Lordship is correct. They
The
say up to date
tender
labor
condition is a valid license. So in the, what will be a valid
to date.
license, we will have to look into the rule and the
Now the only
act
question,
and the rule.
only
So
question,
if under act and the rule, his license can be treated as a valid license. Now we'll come to the next question, whether in that context, the interpretation given by the authority to disqualify a person will hit Article 14. That's all. This is the issue. Anything more?
that is the issue, Milord, whether that he can with the Kamrup thing, he can go there and work in Shivsagar. That is,
No, you'll have to read the clause. I want a valid license.
No, Lordship
Listen,
is
listen.
correct. The clause says I want a valid
Valid
license.
license.
but
The
it is
tender condition says I want a valid license.
Absolutely correct. but-
As per the licensing issuing authority and under the scheme of the act, there is no doubt that his license is a valid license. Now, therefore, the interpretation given by them as regards validity of license is can be allowed or not. That's all.
Milord, with all due respect, Milord, the views expressed by your Lordship, Milord, the Honorable Apex Court has limited the scope of interpretation on the 226, Milord, with all due respect, in the judgment.
Yes, it
One
was.
judgment I have given, and there is another judgment. Honorable Apex Court said the employer is the author of the tender condition,
Hmm.
and it is they who can interpret the terms or what is their requirement. It is they who
Yes,
will
yes.
interpret.
No doubt about that.
So going by that ratio, whether we can go to that extent, interpret the
No, no, we are not,
tender
we are
condition,
not
that
interpreting.
whether their interpretation with regard to valid up-to-date labor license, these 4 words,
Hmm.
whether they are entitled to interpret that we want a contractor whose license is covered either All Assam or the Shivsagar or stroke, whether the work where is it to be executed, whether Shivsagar is included in his license or not.
That's all.
Whether to that extent it can, last occasion 2 judgment I placed.
Give us. Which were the judgments? Uh-huh. Bharat Coke. Bharat Coke and
Bharat Coke and Utkal
Utkal.
supplier.
Yes, paragraph 15. Is that it?
Perhaps Lordships only considered Utkal last occasion. Bharat Coke.
Paragraph
I could
15 is not it?
place.
Just a
Yes,
minute, just
yes.
let us read it.
Para 15.
Hmm.
I'm only relieving the relevant portion, Milo.
Hmm.
Or I'll just write 2 small paragraphs. Equally, this court in Afghan Infrastructure Limited and Nagpur Metro Rail Corporation
Hmm.
has laid down. We must reiterate the words of caution that this court has stated right from the time when Ramana Dayaram Shetty and International Airport Authority of India was decided almost 40 years ago, namely that the words used in the tender documents cannot be ignored or treated as redundant or superfluous. They must be given meaning and their necessary significance. In this context, the use of the word metro in clause so and so in section 3 of the bid document and its connotation in ordinary parlance cannot be overlooked. We may add that the owner of the employer of a project having authored the tender document is the best person to understand and appreciate its requirement and interpret its documents. The Constitutional Court must defer to this understanding and appreciate the appreciation of the tender document.
Hmm.
Unless there are malafits, because here is also there is no malafits or perversity, there is no perversity in the understanding or the appreciation or in the application of the terms of the tender condition. It is possible that the owner or employer of a project may give an interpretation to the tender document that is not acceptable to the Constitutional Court, but that by itself is not a reason for interfering with the interpretation given. Now, your lordship, kindly come to page 622.
Just a minute, just a minute. Just a minute.
I'm sorry.
What was the interpretation of the High Court in this judgment? Which
My lord,
paragraph?
the interpretation was that, my lord,
What is the issue here?
was with regard to labor license,
Huh?
whether the labor license will be under the Contract Labor Regulation and Abolition Act or Orissa Shops and Establishment Act. So the High Court had High Court interpreted,
Where is that? Where is
I'll
that?
just place my lord. High Court interpreted that that will suffice the purpose.
Where is that?
17,
Paragraph?
9, 8.
Paragraph? 9 we have seen that
No, no,
bidders should
it's
have a
not there,
valid
it's not
labor license. Is not it? In our case, clauses,
Up to date labor license.
up to date labor
Absolutely.
license. Okay. Now, where is that interpretation of High Court?
The High Court, para 17, my lord, will kindly come.
No, para 17 is a decision of the Supreme Court.
No, there the High Court has not awarded to any of these decisions, and the second guessing of the authority's requirement of a license under the Contract Labor Act has clearly oversteps the bounds of the judicial review in such matters. In any case, a registration certificate under Section 4 of the Orissa Act cannot possibly be the equivalent of a valid labor license issued by the Labor Department. Section 4 of the Orissa Act reads as follows. 4. Registration of establishment.
Okay, we get the point.
Your lordship, that is at page 618. I'm sorry to interrupt, page 618. It starts from acceptable.
Page?
618 of Utkal, if your lordship is getting the
Paragraph?
9, and it starts at 61A.
Hmm.
Therefore, the contention of the opposite parties.
Where? Paragraph? Page
618, above,
618, yes.
acceptable. Therefore, the contention of the opposite parties
I'm not-
requiring the labor license
I'm
under
not
the
getting anything.
I am also not getting, my lord.
Your
618.
lordship, it's 617, it
The
starts.
contention of the opposite, paragraph, after paragraph 9.
Yes, your lordship. It ends at 617, now
Ah.
it starts in 618 at acceptable.
Except, yes.
Therefore, the contention of the opposite parties requiring the labor license under the Contract Labor Regulation and Abolition Act 1970 does not seem justified in view of the stipulation made in TCN when the submission of the labor license registration number and date by the petitioner under the Orissa Shops and Establishment Act is not
Okay,
disputed.
okay.
In our considered opinion,
Okay.
same.
Here it said labor license, they said, High Court says it's an shop and establishment is equivalent to a labor license. Okay.
High Court-
Yes.
My friend will try to distinguish saying that the facts
No,
are
no,
different.
there is no question
Lord,
of
I am not
distinction.
on facts. In every case-
Your thing is that the interpretation given by the authority should not be interfered by the High Court in a judicial review, more particularly when it relates to a tender, isn't it?
Yes,
This is your argument.
yes.
Okay.
So, what I'm trying to submit is that the facts in every cases, there will be difference in facts.
No, we have to understand.
Yes.
Your argument we have
Lordship is
understood.
correct.
Oh.
Lordship is correct.
We have to understand in what context this judgment
True,
was
true.
passed.
Very true, my lord.
Yes, next case.
Now, my lord, in this case itself, para 16, my lord,
Para
16,
16 in
after-
Galaxy Transport.
no, further in the recent judgment in Silpi Construction, my lord. After that, after Galaxy Transport, my lord.
Ah.
It's a quoted portion, my lord, in the next page.
Hmm.
Further in the recent judgment in Silpi Construction. Lordship,
Oh,
what-
yes, paragraph 16. That's
it-
paragraph
It's
16 of,
not original 16, it's
Oh,
a
it's-
quoted version of
it's,
the,
it's
I'm
a
sorry.
16 of Galaxy's.
16 of Galaxy, my lord.
Yes,
I'm sorry. Further, in the recent judgment in Silpi Construction Contractors versus Union of India, this court held as follows. 20. The essence of law laid down in the judgments referred to above is the exercise of restraint and caution. The need for overwhelming public interest
that
to
is what
justify.
I am saying. What is Article 14? Article 14 it is reasonableness than arbitrariness, that's all. We'll have to test that.
May I read further?
Yes.
To justify judicial intervention in matters of contract involving the state instrumentalities, the court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit in like the court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the base judge of its requirement, and therefore the court's interference should be minimal.
Hmm.
The authority which floats the contract or tender and the and has authored the tender document is the bid just know how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The court will only interfere to prevent arbitrariness, irrationality, bias, malafide, or perversity. With this approach in mind, we shall deal with the present case. Now, para 17, my lord, original 17, not the quoted version. The High Court has not adverted to any of these decisions, and the second guessing of authorities' requirements of a license under the Contract Labour Act has clearly overstepped the bounds of judicial review in such
That is
matters.
not clear.
So,
There is no dispute that this is a labor license
so he came before
under
this-
contract labor.
He came before this honorable court under a situation saying that the respondents gave opportunity to the other two tenderers to submit documents and he was not given. So he is basically arguing that it was a case of discrimination. I am having that license, but I was not given the opportunity. Other two persons were given the opportunity. So it is, their decision is wrong. You know, perhaps the respondents, they have, by relying on the historical document and the respective clause of the tender, has explained that aspect of the matter. The respondents, why the documents were asked from the other two persons. They said that they were already in possession of those documents. Nothing new document has been asked to qualify any one of them. That was the,
He did not have that history.
they did not ask him.
No,
They did not.
because he did not have the history.
He,
What will they ask? Their case is that, what will we ask?
exactly.
Because we got, by checking the history, that these two persons are having this license. So please,
Exactly.
you have, by mistake, you have given,
Mistake.
please give us this license.
So,
In his case, there is no history. So what should we ask? This is their case.
so that is their case. So under that situation,
So there is no
And-
discrimination.
so there is no
Because you are
discrimination
not equally positioned.
and
Had you been in equally positioned,
exactly.
we would have accepted. So
Exactly.
therefore, there are no violation of Article 14.
exactly.
You are
sir.
two different persons with different set. So
Exactly.
you cannot be equalized. That's all.
So that is, and second, going by his statement made in para 7 of the writ petition, saying that I have the license registered with the director. So I am entitled to work anywhere with that license, whether that will be, my lord, correct in the context where the license itself is provides that it is for Kamrup. Again, the tenderer has got the option, my lord, to apply. As my learned brother, senior government advocate has said, that tenderers have to be prudent. I am prudent. I am having a license all over Assam. I know that that license will do the needful. Proposed to be issued. I am again repeating, my lord. When you are participating in tender process and the rule provides that place has to be, you have to have, your license has to cover that particular place, either all Assam or whatever manner, you could have applied for.
No, that is not a tender condition. That is the explanation given in affidavit.
That is, no, I am going by the explanation given in the affidavit only. Because tender condition, it's not there.
No.
And it is for the employer.
Yeah, that is their interpretation.
So it is the employer's interpretation.
According to them, valid license will mean a validity either Assam or the area. This is their interpretation of validity of a license.
True.
Now we'll have to answer whether that interpretation
No, they'll have,
can be accepted or not accepted, looking into the parameter laid down by Supreme Court as regards interpretation of document by employer.
they'll have to satisfy before your lordships that their Kamrup license,
Hmm.
with that, they can work in Sibsagar. As simple as that. They committed a mistake. I am at the beginning also, my lord, I said, perhaps they have committed a mistake, which cannot be cured now. After the NIT was issued, since they knew that they don't have, all other tenderers they have submitted covering that area.
One submitted Lakhimpur.
No.
That's from, that by mistake, they have submitted from.
That
other
was
department.
corrected.
It was corrected.
No,
at the-
corrected, but at the time of tender, it was
He
submitted.
was having that
Have-
license.
uh.
No, it
So
was.
that is a source of historical document.
That is
So,
such a historical-
ultimate conclusion is that all the others have submitted all Assam license. That is the ultimate conclusion, whether after such of historical or what.
Mm.
Now, they have committed a mistake by not.
By the way,
Apply-
what is the difference?
59 lakhs. And let him complete, I'll submit.
So, my lord, if they have committed a mistake, how they can take benefit of their own wrong, my lord? How can they argue a case that, because senior government's argument is absolutely clear that district-wise, all Assam by the director. So it is normally in all other departments, after the NIT, they apply online, they get the license. It's a
Okay.
5-10 minutes business.
Okay, I
Well,
think we have
but-
understood the case.
One more
Yes.
judgment,
Yes. That
Bharat.
Yes,
Working Group.
paragraph.
Paragraph 28. The scope of judicial review in tenders has been explored in depth in the catena of decisions. It is settled that the constitutional courts are concerned only with lawfulness of a decision, not its soundness. Phrased differently, the court ought not to sit in appeal over decisions of executive authorities or instrumentalities. Plausible decisions need not be overturned, and latitude ought to be granted to the state in exercise of executive power, so that the constitutional separation of power is not encroached upon. However, allegations of illegality, irrationality, procedural impropriety would be enough ground for courts to assume jurisdiction and remedy such ills. It is especially true given our unique domestic circumstances, which have demonstrated the need for judicial intervention numerous times. Hence, it would only be the decision-making process which would be the subject of judicial inquiry, not the end result, save as may be necessary to guide the determination of the former. This position of law has been succinctly summed up in Tata Cellular Union of India, where it was famously opined that therefore it is not for the court to determine whether a particular policy or a particular decision taken in fulfillment of that policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of duty to act fairly will vary from case to case. Shortly put, the grounds upon which an administrative action is subjected to control by judicial review can be classified as under illegality. This means the decision maker must understand correctly the law and the regulates his decision making power and must give effect to it. Irrationality and procedural impropriety. Now, para 31, my lord. In cases where a constitutional right is infringed, writ would ordinarily be appropriate remedy. In tender matters, such can be either when a party seeks to hold the state to its duty by treating all persons equally, or prohibit from acting arbitrarily. When executive actions or legislative instruments are challenged for being in contravention of the freedom of carrying on trade and commerce. However, writs are impermissible when the allegation is solely with regard to violation of a contractual right or duty. Hence, the person seeking writ relief must also actively satisfy the court that the right it is seeking is one of public law and not merely contractual. In doing so, a balance is maintained between the need for commercial freedom and the very real possibility of collusion, illegality, and squandering of public resources.
That will try to balance.
Yes, my lord. My lord, I am placing the law. It's my duty as an officer of the court to give your lordship's
Law is
absolutely clear.
Law is absolutely
I'll
clear.
just coming, my friend was quoting the price and all, there also observations has been made. Such a proposition has been noticed by this court even earlier in Jagdish Mittal state of Orissa so and so. Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and malafide. Its purpose is to check whether choice or decision is made lawfully and not to check whether choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tender and awarding contracts are essentially commercial functions. Principles of equity and natural justice stays at a distance. If the decision relating to award of contract is bona fide and it is in public interest, court will not, in the exercise of powers of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to a tenderer is made out. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or decide constitutional dispute. The tenderer or the contractor will, with a grievance, can always seek damage in a civil court. Attempts by unsuccessful tenderers with imaginary grievance, wounded pride and business rivalry to make mountains out of the molehills of some technical procedural violations or some prejudice to self and persuade courts to interfere by exercising power of judicial review should be resisted. Such interference, either interim or final, may hold up public works for years or delay relief or succor thousands of millions and may increase the project cost manifold. Such conscious restraint is also necessary because judicial intervention by itself has effects of time and money, which is unchecked would have problematic ramification on the state's ability to enter into contract and trade with private entities. Further, it is not desirable or practical for courts to review the thousands of contracts entered into by executive authorities every day. The courts also must be cognizant that often a time the private interest of a few can clash with public interest of the masses, and hence a requirement to demonstrate effect on public interest has been evolved by this court. Para 34, Milo.
Jagadish Mandal,
Yes. Sorry, Milo.
many times read. I'm just listening therefore, read it.
Yes, Milo. Thus, it is imperative that in addition to arbitrariness, illegality or discrimination under Article 14 and encroachment of freedom Article so and so.
All these judgments, still the recent judgment, MP Power Corporation, the fundamental thing is a contract, when it's a contractual right, until and unless it's statutory contract, writ court's hands are washed off. When it relates to a contract. But MP Power Corporation, it says that even if it is not a statutory contract, when Article 14 is violated, of course, writ court will not be remedialist.
True.
From Tata Cellular to Jagadish Mandal to
And
all these
Conan.
cases, Utkal Supplies, Bharat Coking Coal, all judgments.
There is no doubt about it.
In all judgment, it says that this is in the realm of this contract. This is give handle to the state.
Yes.
Give handle to the state. It's an executive things. Importance of public importance are
Basically
there.
public
Buildings
interest.
are to be completed. Bridges are to be constructed. So therefore, you restrain yourself.
Yes.
But at the end of the day,
What is that?
what remains is the Article 14.
True.
That's all.
Now that principle has to be applied here.
That's
Lordship has
all.
to see what is that blatant, Milord, discrimination.
There are many,
or-
suppose you come to the Tata Cellular.
Yes,
You come to that, you have quoted.
yes, yes. ma'am.
So this law is well settled.
Absolutely,
We
yes.
need not even quote the.
Milord, if Article 14 is there, Milord, then
So-
nothing can stop your
So
lordship.
what is an arbitrariness? What is Article 14? Article 14 is the arbitrariness.
Discrimination,
Discrimination.
And if there is any flaw in the
So-
decision making
So
process.
therefore, if you go by Tata Cellular's clause 3, clause 1, illegality. In the government contract, illegality has been defined. This means the decision maker must understand correctly the law that regulates his decision making power
Yes.
and must give effect to it. So this line will have a definite relation to this judgment or this issue, because we are not reading a document as such. We are reading a contract clause which says give a valid license. So what do you mean by valid license? Valid license is to be at when there is no dispute that it is a contract license. License as a contract labor abolition and regulation act. There is no quarrel on that. So if that is be so, validity will have to be determined in the context of the act or in the context of the interpretation given by the state, given by the employer. That's all. If the interpretation given by the employer as regards validity overrides the concept of a validity of a license of the act, will it not be arbitrary?
Here
Will
is
it not come under section 1, illegality?
Here it is not there. The decision of the respondents are in sync with what the rules and the act says. Establishment is, your lordship will kindly go to the rule.
So
Ultimately, that question, your lordship.
because they say that I want a valid license. They are not saying that we want a valid license which is effective for state or the district council.
Milord, one simple question I am asking myself, only one question.
Mm.
Whether their license is valid or not, even without going into that aspect of the matter, whether in the, whether they can be a valid tenderer having a Kamrup license, Milord.
That is the interpretation of the clause, because your rejection is on the ground that his license is not valid.
Tender clause vis-a-vis rule and the act. Tender clause, we cannot
Madam,
obligate.
are you having the record?
Yes.
That the tender committee's decision? Give the record. Please,
We
this
will
matter.
also have this notification, wanted to have the
That will
notification.
be
Yes, yes,
fixing it on Monday.
fine. Milord.
Yes, what you want to say? Now, how do you say that this is not your case, what you are being argued? Your case is that there is a discrimination by not giving me chance.
I have categorically stated in my, if your lordship is taking about two, I can just.
Not two, people are waiting.
Then my
Monday.
lordship, I can just.
Not. Monday. We want that, and please give us the record.
Lordship.
More particularly the tender committee's decision and deliberation.
Right, so there are two
Monday
minutes
report.
of the
Huh, give the minutes out.
Lordship. Lordship, further one more submission from a learned friend that the financial bid, he is not responsive for the financial bid. So we don't know, the department don't.
No,
know
you
whether-
don't know. You
we
will
don't know
not
their
know.
committee. We
You
don't
will
know.
not know. This is, see,
Lordship.
why he is fighting this case?
Yeah, he is fighting this case because he knows.
Because
that
he knows your price.
He knows that he is the L1 if.
No, he made a statement in the writ petition, giving the price, our price, his price, all.
No, your price is not.
Everything is
your
disclosed
price.
now.
Your price is in public domain.
Yes.
His was
No,
not there.
mine also not in public domain.
No, he's in public. Your price bid is
No,
open.
No,
not,
Lordship.
not open,
No,
but
not
he
open.
stated in his writ petition, para 7, what are the rates of the parties? Lordship will have a look.
No, price bid is not yet open.
No,
Stop it.
Lordship will have a look, para 6, 7.
Your lordship, that is, when we upload the documents, when you upload the documents, I can also, once the documents are obtained, your lordship on 12/7/2024.
No. How do you get the price of others?
Your lordship, that can be obtained from there. Once it's open, the bids they are finalized on 12/7, your lordship.
That's what I'm saying. Price bid was open.
Yes, your lordship. That is.
What you
very
said,
evident
I
from
have got it in the pleadings.
307, page 307.
Price bid is
very
open.
categorically, your
Price
lordship.
bid is not open, not made public.
Not made public, Lordship.
Not public. When a person participates in the tender, he can see this.
So,
Lordship.
So this is kind of a public domain.
We don't know his code, Lordship.
You will not know.
I
Because
don't.
he
You will
is
not know.
open.
His price bid is not open.
Yes.
He knows it from the website. Because he will, since he is having the key, what digital key? Since he is having the digital key, he will know the price.
He is not responsive, he is not.
I know what bid I have quoted.
No. You are not getting the point.
No, the court is, what court is saying.
What
he'll
we
be
are
able to
saying
know
is,
from-
he knows your price, despite that he's fighting. That shows the thing, why he's fighting. Because he knows that I am the L1. Otherwise, suppose, why should we would not have wasted so much of time?
True, my lord.
See, but this is the second phase, he is not complying with the.
Oh, madam, you are not getting anything.
Only 1,500 difference in the bid of these three persons. And one is.
So that we are not concerned. That we are not concerned.
Fiscal thing is nothing, because rates are almost similar.
They may think that this rate work will not be good. That is not ours. That is not right. 60 lakhs difference, according to him. Your consideration may be no. If it is executed in that level, quality of the work will fall down. That is the employer's discretion.
They can take any call, my lord. Yes, they are difficult.
Monday why are you fixing will dictate in the open court.
Fine, my lord, fine,
If you want to say anything, but it will take this matter after the list is over.
fine, no problem.
Let Mr. Nath also complete his work, but we want a notification. And here, madam, my minutes,
Order.
give this to my.
Your lordship, can I place one judgment? Your lordship may have a look at it. on-
What is the judgment? Tell us,
The-
citation.
The law is well settled on this issue, your lordship.
What is the citation of the judgment?
2018-5 GLT 470.
Say the party's name.
Puja Associates. I have a copy, your lordship. I'll just hand over the copy, wherein the honorable court has opined that this
It's a
license
different
can be obtained after the work is awarded, your lordship. Para 9 and 10.
That is in a different context, my lord.
No, your lordship, that was in, let me submit.
No, this is not your case. We'll look into it. This is not your case.
No.
It is not your case that I have still a chance to submit a license. Your whole case is that why did not you give me a chance?
No, my whole case is that I have complied with the terms and conditions of the tender contract. In spite of that, you have.
We'll see. We'll see. Yes, madam, just I want to see before I rise. We'll see that 210.
Minus to D.
Why 2 minus?
Condition.
I thought এটা return নে বেলেগ বেলেগ।
Minutes are there.
Hmm.
One for asking for the documents, okay? For the shortfall documents, Lordship. And they have asked for the shortfall documents, Lordship.
Yes. Okay. At 210.
Much obliged.
Deeply.
Deeply obliged.
I have to connect. Okay. Yes. Yes, Mr. Singh.
Yes, my lord, my learned friend is also there in Itanagar.
Anybody entered appearance?
For dusty service, I think.
Service is complete?
Service is complete.
Anybody
My
appears?
learned friend is not there, he has filed affidavit, my lord, as per your lord.
Respondents had entered their appearance?
Not yet, my lord, not yet.
Where is the report, office note, service report? And what is this IA? Mr. Singh, what is this IA?
IA, my lord, is not in our case, my lord.
Uh-huh.
My lord, IA is not in our case, my lord. Mine is item number 1, Campudolo.
Have you received a copy of the IA?
My lord, IA is for item number 2 and 3, my lord.
What about, let us first take item number 1. Item number 1 is your case?
My lord.
Service is not service is complete.
My lord, that's what I have been informed by my learned friend from Itanagar that service is complete.
Okay.
They have
Any
filed
office
affidavit
note?
also. They have filed
Any of-
affidavit also.
Affidavit, you have filed affidavit. That is not
Yes.
on record.
For
Now,
dusty,
when can we fix the next date, Mr. Singh?
my lord, is your lordship, please, because we can
No,
file.
no, it's an election petition, so we want.
Assort that, assort that.
Oh, no. Okay, okay. Okay. একটু নতুন কে এসেছিল মনে হয়। অফিস নোট তো আনার ব্যবস্থা করা হবে। ওকে ওকে ওকে। Though this matter was listed, directed to be listed on 23rd of 23rd of August, isn't it? 23rd of August 2024. However, as it was a holiday in the principal seat, the matter could not be listed. Accordingly, matter is placed today. Mr. G. Singh, learned counsel for the petitioner, is virtually present. Full stop. In terms of this court's order dated 5/8/2024, steps for issuance of notice has already been taken, and notice has been issued on 7/8/2024 with registered post as well as through dusty service. Full stop. The petitioner has also filed an affidavit in proof of effecting dusty services. Full stop. The affidavit reflects that notice to dusty was served upon one Hayang Mangti, 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 upon the respondent who put this signature, Pranab Sonowal. What is the name of the Hayang Mangti? What is your statement, Mr. Singh? As per the affidavit, it is seen that as per the affidavit, the notice was served upon one. Notice was received by one Pranab Sonowal on behalf of the respondent. One Pranab Sonowal, comma, who is the personal assistant of the respondent. It is also stated that the petitioner himself personally served the notice upon the sole respondent, though the notice was received by the said Pranab Sonowal. Full stop. Accordingly, service to dusty is effected. However, as the matter pertains to an election dispute, let the registry await for service report in respect of service taken through register post as well as through usual process. Full stop. Accordingly, list this matter on, give a date. Give a date, Mr. No. Before that. Just it will be an order. 16th of September 2024. Registry to put an updated note as regards service through registered post as well as through usual mode. Stop. Registry may also file a report on the basis of the track consignment report. Okay. List accordingly.
Obliged, my lord.
Now this is item number 2. Who is
Lordship, I am appearing.
item number 2?
Yes, Lordship.
Yes, what is this IA?
Lordship, I am appearing for Election Commission of India. And there is a direction from Election Commission of India to preserve all the EVMs of State of Arunachal Pradesh in a strong room. And if there is any election petition, then those EVMs are to be taken out with due permission from the Honorable Court. If there is no election petition, no problem. But if there is any election petition in that respective constituency, the EVMs along with other materials are to be kept in a strong room until further orders from the Honorable Court. Now, here is a case wherein there is no amendments regarding EVMs, but for abundant caution, we have filed this.
Here basically some others. Yes, please, the petitioner. What about the state service?
Yes, Lordship. The petitioner in person is also here.
Here. Yes, Mr. Petitioner, what about the service? Have you taken steps?
Yes, Lordship. He has received it.
Yes, Lordship. I have received it.
No, you have received the IA. What do you want to say?
I have no any objection, my lord.
No objection. Okay, we'll go to that. What about the steps here?
For state, I have Dusty, I have delivered accordingly. And I have filed an additional affidavit.
AP 02 AP. These are the earlier files. So you separate them. No? Office notes. Files are those where the office notes are there. This is new files they have sent. Okay. Steps up to steps. Then you write it down. Where is your affidavit?
Additional affidavit I have filed on.
Put the order that direction I issued to take steps both the ways. Affidavit has been filed.
Yeah.
The affidavit reflects that.
Wait, receipt copy, my lord. Dusty service I have delivered accordingly to on 7th of August. Or number 2 also on 7th August. And number 3, respondent number 3 on 9th August.
Who received all this?
The one is the candidate himself.
Where do you see that? Where received?
Number 2, page number 184.
Come to
184.
184
page number 2. Dihom Kitnya, he himself have received the
Tesam Pongte.
Yeah, he has.
Where is his received?
Tesam Pongte has also received. I have delivered.
Where do you get that?
Yeah, speaker cell.
What is speaker cell?
Speaker cell is his receipt office receiver.
No, office receipt will not do. This is an election petition. And what about the respondent number 2?
My lord, I am representing respondent number 2, and my lord, I did not receive the copy of
respondent number 2 is fine.
Yeah, 1.
What about respondent number 3?
Number 3 also has received.
Okay. Peruse the affidavit. It is seen that respondent number 1, respondent number 2 and 3 has themselves received the copy.
Yeah.
Full stop.
My lord.
However, the receipt of the respondent number 1 was issued by one speaker cell without any signature of the petitioner. Therefore, service to Dusty upon respondent number 1 is not accepted. However, service upon respondent number 2 and 3 to Dusty is accepted. The respondent number 2 has also entered appearance. Is that it?
Yes.
Entered appearance through learned counsels. However, none appears for the respondent number 3. In view of the aforesaid, let this matter be listed on 15 or 16. What was the date? 16th of September 2024. Full stop for orders. Full stop. Registry to put an updated note on service upon respondent number 1, 2 and 3. Through registered post as well as through usual process. Full stop. The IA shall be taken up on 15th. Okay, we'll go through it. What is the provision? Have you annexed
Lordship.
the Elections Commission's decision?
Yeah, Lordship,
Notification?
in earlier petition, in last election also, we have records from on this honorable court's
Election
order.
Commission of India, page 12th journal.
Yes,
Okay,
Lordship.
okay. We'll pass the order on 15th, no? 16th. We'll pass an order on IA on 16th.
Lordship,
Okay.
Lordship, Lordship.
List the IA along with the election petition on 16th for necessary orders.
Lordship.
Keep these two files separately, sir. Your office notes. Next time, ask them to give only the office notes and updated orders. Every time you need not send the files. Yes.
This matter pertains to non-payment of compensation amount of land acquired by National Highway Authority. There are 4 petitioners. Total land acquired was 1 bigha 3 katha 2 lesers. Out of that, compensation was paid for 2 katha 11 lesser. And remaining 1 bigha 11 lesser is yet to pay by the authority.
Now, what is your stand?
Let's see. On last occasion, let's see. The additional deputy commissioner filed an affidavit admitting the whole facts, let's see, and stated that they have no fund in their bank account and they have.
This was land was acquired for whom?
Highway authority.
Huh?
Highway.
Who is for highway?
Highway.
Have you deposited the amount?
So earlier, what happened in this case, some different persons' name were included in the 3G application. So that persons were wrong. So those checks were issued wrongly in their name, but the check was not disbursed. Later on, now the government deputy commissioner has filed an affidavit stating that they have wrongly put the name of the other persons. Actually, the 2 persons were entitled to get the compensation. 1 person is also Das and 3 others, and their brothers, and 2 is Digambar Vaishya. Now, item number 3. They are entitled to get the compensation.
Now, who will pay when it will be paid?
We'll pay the compensation.
When?
Actually, what happened last letter, we have written to the deputy commissioner in their affidavit in opposition. They have annexed our letter, Lordship. In that case, we have stated that present status of the ability of the fund, Lordship, that is only the as on date is 15,55,300. Lordship, if Lordship pass an order, then we have to.
Total requirement is 23 lakhs.
23,40,875.
So we'll direct you only.
Yes.
How deputy commissioner cannot pay? He is the acquiring authority. It is the you who wants the land.
Initially, it was a joint account. At some point of time, that money has withdrawn by the NHIDC. This is.
Other person, somebody withdrawn. That-
And I said it was a joint account, my lord.
NHI
But
and
they have withdrawn the
competent
money, so
authority.
there is a lacking of this few lakhs
Okay.
rupees. my
So
lord.
you have
So-
taken back the money, now we'll give you,
Now
give
we
it
will
back.
Deposit lordship, direction may be given and
See, one thing, let's say this process initiated in 2010
Hmm.
and part compensation amount was paid in 2011. Now we are in 2024, let's see. And in the.
What should be the
affidavit-
interest?
Let's see,
that is also
I'll
not a fault of the competent authority, not our fault.
We do not know.
let's see. I
They have
leave it to
wrongly
your
put the name
lordship.
of
No, no,
other.
what you leave, this is your right. What is the percentage of, what was the act?
It does not prescribe for any interest. lordship.
Yes, this was acquisition under Highways Act.
Lordship,
Lordship.
lordship.
What was the interest? Any prescribed interest? In the Highways Act?
Compensation is
9%.
prescribed to be determined, let's see, as per, 3.
So that we understand. See, under 1894 Act, there is an provision of statutory interest. Is there any statutory interest under Highways Act?
Nothing directly
Nothing.
is not mentioned.
Sure,
Let's see, I have not.
sure or not?
I
Say
have
that
not
I
got
do not
this
know is one
yet.
thing and there is no provision is one thing. Which one? There is no provision of interest or we are not aware?
To my knowledge, my lord, there is no such
No
statutory
provision.
interest.
No
mentioned.
statutory
Let's
interest.
see.
Hard. MSA Devi. Learned counsel for the petitioners. Also Hard Swenso, learned counsel. So naam likhi diyo sorry. The case of the petitioner is that how many petitioners in 1297?
4 petitioners.
4 petitioners. That they own and possess a plot of land measuring 1 vigha, just correct me, 3 kathas and 2 lessas, covered by Dag number 349 capital B and Patta number 8 KM,
Let's.
situated at village Kohara Pothar under Sobrupata Revenue Circle, District Borpeta. Full stop. Within bracket, hereinafter referred to as subject plot. A notification dated 10/5/2010 was issued by the Ministry of Road Transport and Highways. Within bracket, MORTH, MORTH, Government of India, declaring intention to acquire the plots of land specified in the schedule therein for building, within bracket, widening / 4-laning, etc., bracket close, maintenance, management and operation of National Highway 31, on the stretch of land from kilometer 982.00 to 1041.00, within bracket, Nalbari business section, bracket close, in Borpeta district. Amongst the plots of land so indicated for acquisition, the subject plot of land measuring 1 vigha, 3 kathas and 2 lessas was also included. But when the sanction was accorded for disbursal of compensation by the competent authority, National Highway Authority, the additional deputy commissioner, Borpeta, on 29/10/2011, the petitioners were paid compensation of rupees 10,45,796.
459.
By check number 962977 and check number
Okay,
962978 only for 2 kathas, 1 lessas, within bracket 1 katha, 11 lessa, out of aforesaid 1 vigha, 3 katha and 2 lessas. It further transpired that 10 numbers of other persons, namely Sompok Das, Okon Ali, Bhaskar Padgiri, Poroma Das, Himangsu Das, Zakir Hussain, Abdul Hakim, Atwar Rahman, Sahidul Islam, and Ranuara Begum were sanctioned and paid compensation for rest of the areas of land falling under Dag number 349 capital B of the land in question. it is not disputed by the respondent number 2, who has filed an affidavit of an opposition. Wherein the notification dated 10/5/2010 is also annexed, and to the effect the petitioners' names were only reflecting, showing them to be entitled to receive compensation for the plot of land measuring 1 bigha, 3 kasas and 2 lesas. Therefore, the petitioner is aggrieved by the decision of the authorities in not paying them land acquisition compensation for the entire plot of land measuring 1 bigha, 3 katha and 2 lesas. Isn't that it? 2 lesas. Full stop. The deputy commissioner has filed an affidavit.
ADC, my lord.
ADC
Competent
Borpeta
authority.
has filed an affidavit and has admitted the stand taken by the respondent, taken by the petitioner. Which paragraph?
Page 36 of interlocute.
Which paragraph?
Para 4(1), my lord, last stanza.
Paragraph 4. Paragraph 4.
4(1). And paragraph, last paragraph of that same subpara, page 39.
13 subpara.
39, page
Yes.
number 39. my lord.
Page 13 sub,
Yes.
which subpara?
Both paragraphs, my lord.
It is a specific stand in the affidavit that in terms of the report of the circle officer, comma, Sorupeta Revenue Circle, that Pattadars are Ashok Das, petitioner number 1, comma, Sri Deepak Das, petitioner number 2, and Sri Gagan Das, petitioner number 3, and Sri Mahodhar Das, petitioner number 4. And accordingly, it was further stated that therefore the petitioners are entitled for the compensation for the entire plot of land, and such compensation was quantified to be rupees 21,48,869 over and above the amount already paid.
Yes.
Over and above already paid. Full stop. It is the further stand of the respondent competent authority that the competent authority has already requested the National Highway Authorities of India for payment of balance amount in as much as balance amount. Full stop. The MS Bora Learned Council appearing for National NHAI on instruction has submitted that they are in receipt of the communication dated 37/20/24, whereby the where is that? They are in receipt of the information from the additional deputy commissioner, and accordingly, by a communication dated 37/20/24, 74, it was intimated that the compensation amount will be processed after receiving the final determination that has been made, that is to be made in the present litigation. Full stop. On instruction, MS Bora submits that the highways authorities is also aware of the fact that the petitioners are entitled for the balance amount, and therefore they will be duty bound to reimburse the said amount and transfer the amount to the accounts of the competent authority, so for further disbursal of the to the petitioners. In view of the aforesaid stand taken by the additional deputy commissioner, as well as the stand taken by the National Highways authorities, in the considered opinion of this court, the dispute has already been resolved and the right of the petitioner has already been ascertained and affirmed by both the authorities, that is the competent authority, that is additional deputy commissioner, and the National Highway Authority of India. Full stop. In view of the aforesaid, the present petition is disposed of directing the National Highways Authorities of India to remit the amount to the account of the competent authority slash deputy commissioner slash additional deputy commissioner, Borpeta district,
Yes.
Borpeta district, within a period of,
Lordship, we have to take approval from the higher. authority.
with that is within a period of,
Months.
within, but that will cost interest, with a period of 3 months from date of, from today. From today,
Lordship, like 2 months also.
2 months from today. Full stop. And on the receipt of such amount in the accounts of the deputy commissioner slash additional deputy commissioner slash competent authority, the competent authority shall forthwith release the amount to the accounts of the petitioner after due verification. After due verification within a period of 2 weeks thereafter. Full stop. The learned counsel for the petitioner at this stage submits that no fault of the petitioner, they have been deprived of their legitimate compensation, and therefore they are entitled for interest. Accordingly, she submits that a 9% may be awarded in their favor from the date the said amount due till the payment. Full stop. This court has also considered the matter, this aspect of the matter. Full stop. From the material available on record, it is seen and it is an admitted position that the petitioners are entitled for the compensation. However, due to mistake or for any other reason on the part of the authorities, on the part of the competent authorities, such amount was not, amount in total was not paid to the petitioner, and the amount deposited in the account of the competent authority was returned back to the account of NHIDCL. Full stop. In view of the aforesaid, this court is of the view that the petitioner should be awarded with an interest. Full stop. This court is of the view that 6% interest will be a reasonable interest in the given facts of the present case. Accordingly, it is directed that along with the amount due, an interest at the rate of 6% also be added from the date of the amount became due till its payment. Full stop. With the aforesaid, the present writ petition stands disposed of. What about the other?
That's it, one thing, Lordship. Payment will be made by issuing SEC, Lordship.
SEC. That they cannot issue cash now. It is SEC to your
Lordship,
account.
Because petitioner's account number, they don't have, Lordship.
That they will ask you.
That's
And what about the next case, Diganta
Lordship,
Vishwa?
here, Lordship, 10 lessons land, they are yet to pay compensation.
What is the affidavit here?
Total-
Which paragraph?
Lordship,
Same.
same.
Same stand.
Same
It will be
stand.
same order.
Same
The
order.
amount and.
Amount
Amount
and-
is-
and,
amount
amount
is-
payment, amount is 1092, 1,92,006.
1,92,
006.
006. And what is the DAG number, patta number?
That's it,
And
tag
an
number,
area of land?
Area of land in this case, my total acquired 1 bigha, 0 kotha 15 lesser.
1 bigha, 0 kotha, 15
15
is
lakh.
under. Madam, please give the
That's it.
DAG numbers and patta numbers.
Let's see.
Huh?
Let's see.
And compensation were paid amounting to land.
No, what, please tell us what is the area 1 bigha?
1 bigha, 0 kotha 15 lesser.
There is only one petitioner?
Yes.
Let's
One
see.
petitioner.
Dag
What is the DAG number and patta numbers?
31B Patta.
77.
77 km, Khirasmati.
The DAG,
Same village is same.
same village.
Yeah.
Now, what is the total amount determined?
As
What
per-
was the amount paid?
Well, it was paid for 1 kotha 11 lesser already.
It
paid.
was paid to same one, payment was made for 1 kotha 11 lessons.
Yes, ma'am.
And who are the other persons whose names were there?
One person's.
It is one person.
What is the name of that person?
Pinku Das.
Pinku Das.
Huh?
Pinku Das.
Pinku Das. I'll correct it, just write it down, Pinku Das. And
Amount to be received by them is already
no.
1,92,006.
they are yet to receive 1 lakh
92,000.
92,000 yet to receive and paid,
So that is the amount after verification, my lord, that they are left to be paid.
left to be paid, 1 lakh
1,92,006.
92,006. Okay.
Rest are same.
The payment was made for 1 kotha 5 lessa in a second case.
Dispose of. Payment made 1 kotha 5 less.
What of that?
Okay, it is subordinate. After this order is dictated, then only we'll go to it. Affidavit is same. Only dag number, patta numbers and amount and party's name. Yes, Gogoi.
So CD is probably.
Yes, case very voluminous. I want both of you to go. Give the file.
Then my lord may post it next week, then.
Next week we'll put, that was my man. Mr. Bharali. Go through it, huh? The case diary of Shivsagar PS case number 291/91 in connection with WPC 47G W1 is received in terms received full stop. The Mr. K, I'll just record Mr. K Gogoi, learned counsel representing the state, may go through the same and assist this court on the next date fix. You also go through, not CD generally we do not, but you go through, giving it informal.
Next Thursday, madam.
Next Thursday. Next Thursday possible, Muslim? Next Thursday may be difficult then. 10th?
10th, lordship. Whether lordship, I can go through in the court or.
You can take it.
Lordship.
You can take it.
Lordship.
You go through it. The case diary is handed over to Mr. Gogoi. He may go through it and return back to this. You have that authority. We cannot give it to him, but we can give it to you. I continue.
On 10th, lordship.
Huh?
On
On
10th.
10th. Or not on 10th. 10th, no? 10.
Oblige, lordship.
Yeah, please, your lordship. Lordship, please pass over the matter for the time being. Yes, my senior is in.
Today Passover may not be possible. You are enjoying a stay?
Yes, madam.
Yes, enjoy a stay. When? Passover today, many matters are there. Everybody is waiting. First half we spend in one case. On the prayer of Mr. Talukdar, SK Talukdar, matter stands adjourned and be listed on. Listed after 2 weeks.
Interim.
Already there, I think. Who is from the municipality?
Government.
Huh?
No, government, no, not government.
AK Talukdar is
AK Talukdar.
Chairman represented by the AK Talukdar, and so far as the municipal administration is concerned, my lord, affidavit filed by the government. 2 affidavits, one by the chairman, one by the municipal executive officer.
Are you going for final disposal?
Lordship.
Possible today?
Lordship. I will, this is a small issue, your lordship. Your lordship, ultimately, your lordship, the room was in the name of my father, your lordship, since 1970, your lordship. Thereafter, he expired, your lordship. And then initially my mother, your lordship, ran it. And then, your lordship, it was behind my back, your lordship. The name was the name of the private respondent, and along with me, your lordship, was included as a lessee of that particular room, your lordship. And when he is running, Your Lordship, ultimately. And then, Your Lordship, when I came to know, I submitted certain representations, Your Lordship, and then I came before this honorable court, Your Lordship. And when we came before this honorable court, and our ground was that he, first of all, Your Lordship, he cannot get it. And secondly, he is an employee, full-time employee of municipality, therefore he is not entitled to get it. And then, Your Lordship, the affidavit was filed by the authorities. And in one of the affidavit, it is said that there is an application submitted by, joint application submitted by my mother, Your Lordship, and
Mr. Gogoi, are you ready? Huh?
Yeah, that is also file is handled.
That's why I'm asking, because we are shortage of time. We do not, looking at his speech, I could understand that he is not ready. So we'll do half again, not for the session. Here issue basically is there are some disputes, whether he filed, not filed. Now, even if it is filed, whether that can be done, what is the power of the municipal? Assuming that there is no dispute, we'll accept that for the time being, there is maybe one way into looking it, except that there was a joint application. So on the basis of joint application, can lessee be sent under Municipal Act or the rules framed there under in the manner it has been done? If it is permissible, then our way of looking it will be a different angle. If not, then we need not go to any other.
And Your Lordship, my prayer ultimately would be, Your Lordship, to send the matter back.
It will have to be.
Municipality, and they will take a call on
that.
who is
That's
entitled,
all.
Your Lordship.
Next week is difficult. Madam Usumi will say, how many matters are, so many matters are. See, that is the basically.
That is.
But we'll have to give a finding why we are remanding back. That's all. 17th. On the prayer of Mr. K. Gogoi, learned counsel representing the state, matter stands adjourned and be listed on 17th. Full stop registry to reflect name of Mr. K. Gogoi in the cause list, so that you are aware of this.
May I please, Your Lordship? Your Lordship, the conducting counsel for the APD itself, Mr. KP Pathak is in Lakes in court number 3.
What is your stand? What is the report says?
Otherwise, we have file a fiction.
What is the report says?
We have file a fiction. On 8.
Electrical inspector report.
Lordship, report is there, Lordship, it is fault.
Whose fault?
Admitted, my lord.
So if it is their fault, what is the provision given order will pass this order? Dispose it of. They will give you the statutory amount.
Yes.
Rest you can file go to any other. Is that it?
Well, may I submit some?
Yes. Yes. But if you say that we will have to give more than what is prescribed, then we'll have to hear Mr. Pathak. Isn't it?
Lordship. Otherwise, Lordship, the
Otherwise,
electrical officer's report is specific, Lordship. Contravention is there, Lordship.
what is the amount?
My lord.
What is the total amount that is, some statutory amount is there, is that it?
Lordship. No,
There is some regulation.
Regulation is there. Lordship.
Regulation is there. There is some time to time there is some enhancement. They have quantified.
Lordship.
That quantification is there.
Lordship.
Now beyond that, I think that is more than 2 lakhs nowadays.
Yes.
What is that amount?
In those cases, my lord, 2.5.
No, here 2.5. Here the court went to determine the damages. Of course, we are not saying that we are not powerless. We can decide that. When it's an admitted position that negligence on the part of the ASCB. But there is a prescription under the rules. So far I recall, I'm not sure. Do you know?
The prescription is there.
Prescription is there that in case of death, this will be the amount.
Injury, death.
Death torture. And if beyond that, provision is that they can file for, because it is to be established. Anyway, madam, please wait for some time. Let us see. Yes. We'll see. Yes, next case.
This matter, your lordship.
This matter is unlucky matter, yes.
Now, your lordship, senior government advocate is not there. Your lordship.
Who will
He was supposed to appear, your lordship, last time.
wait for some time, given information. Yes, Mr. Mohanto.
My lord, I am the issue. Challenging the, my lord,
Challenging what?
challenging the municipal by Annex 7, my lord, page 27. My
Yes.
lord, I am a tenant under the respond number 7 and 8, my lord.
Oh,
So they cannot do it directly, which done or indirectly, my lord. So, my lord, our livelihood, 40 years more than we
we are
are
still enjoying. Still
No,
you
that
are in.
we are still, I am tenant, I am. But now your lordship kindly see
Mm.
that because of the, it is apparent, my lord, that is that issued, my lord, the behest of the respond number 7 and 8. So, my lord,
What
just
is the procedure prescribed for this kind under municipal act and rules?
my lord.
Suppose there is a building which is ended.
Yes, it is a and then
What,
to my
what is the procedure?
procedure, my lord. It
Any
actually,
procedure under the act and rules?
and directly, my lord, nothing.
Hmm.
Directly nothing. But they can examine, my lord.
No,
with
they
the
can
competence.
examine, but there must be some
Yes.
procedure in this
My
respect.
lord, municipal
Yes,
has,
Mr. Das.
municipal has not
Suppose
filed-
forget about this case. There is a situation like this. How will you do?
I did not look.
This is
no
the
evidence
vital.
also.
If there is a procedure prescribed,
Then I have
may
to
be
follow.
relatable to, you will have to follow that. You have not followed, we'll set aside and ask you to do if permissible under law.
That prescription I did not get.
That is a vital issue.
No affidavit filed, my lord, by the
I'll
municipal.
Suppose the owner says that my building is in a very bad condition. He can demolish it, no problem on that. I'm having a house. House condition is bad. I can take permission that I want to demolish it. I can demolish it. But here, right of others are involved. So therefore, it should be, there must be some procedure prescribed when and how this house can be demolished.
Yes, then my lord, municipal can issue a notice to the owner, not to the tenant.
That is what.
Yes.
So therefore, we want to know the prescription. What is the prescription in such a situation? We are genuine. We think that he is a genuine person. His building is in a very bad condition. Tenants are there. He want this to be demolished. What is the procedure? Address us on that. Then we'll decide.
1 week time.
Okay.
On one occasion, my lord, I tried to.
Because otherwise, if it is an unfettered power, then this can be used as a eviction of tenant. We are not saying this is that case for the time being, but we want to know the procedure. If procedures are there that has been followed, or this is because nobody can, there must be some assessment that yes, this building is this situation. Of course. There will be power in some cases where there is an emergent dangers to vacate. These will be under disaster management. That is
Under
also
this
there.
amendment, there is a law.
So therefore, if municipal act and the rules are silent, we may
Then
take
disaster
help of
then
some
disaster
other,
management.
what is the law? That is why we want to know.
2 weeks time.
No affidavit, then let them file an affidavit because they have not filed.
Yes, Mr. B.D. Das, Learned Senior Counsel, submits that the authority would like to file an affidavit and to incorporate the procedure that is required to be followed in case of a demolition of building for becoming dangerous to human life. Full stop. Prayer is allowed. Please, this matter. Thus, give a date. Because he is also having an anxiety. They are also under anxiety.
In spite of there being no stay order, they are not taking any stay. That on the other hand, I haven't.
Oh, there is no stay order.
There is no stay.
But then they are now finding out how to do it. Now Das will advise them how to do it.
Like the procedures are there, my lord, and
Procedures are under which act?
my lord, under the
Disaster management.
no, my lord, the Assam notified urban area other than Guwahati building.
What it says?
It says, my lord, every building after 40 years, the owner has to, my lord, assess, my lord, the structural audit has to be done. And if, my lord, any things are there, that has to be given to the, my lord, municipality. Municipality will accordingly whether, my lord.
Have you given all this?
My lord, here we failed to, my lord, submit that one. So the municipality themselves has done it. And then
On whose request?
his, because the primary response.
No, we'll just see. We are here not to sit over the decision of the municipal authority or your equivalent. What we'll see is what is the
Law.
procedure prescribed and whether that has been followed. If not followed, it will go. If it is followed, he will be out. That's all.
Well,
Yes,
their-
after please.
Their basic contention is that the structural audit is not there.
No,
No,
and in
number one.
addition, they say we have
We have
ourselves has-
our own, my lord.
we have done our.
Government contact.
So we are not going to all those.
Their second contention is that the structural, the audit which has been done, it is in respect of DAG number of the holding number 65 and they are in 66. This is one building having two, my lord, holding number. And all the audit report are in respect of both the, my lord, first, ground floor as well as the first floor. One, they have done, my lord, ND test. There is another, my lord, test required. Here also ground floor and the first floor has been measured and, my lord, it has found that this, to some extent, my lord, the building has been, my lord, needs rectification. And the municipality also has found. my lord.
Okay, we'll do that, Mr.
Well,
Let
it's a, my lord, the life of the person living there is, well, the main things. my lord. It's more than a 50 years old building.
that we understand. Yes.
So those procedures that have been, my lord, followed, they are only, my lord, thing is that.
No,
the holding number
before
is-
that,
I have not
see,
seen that. It's one of the-
we will have to deliver a decision. So to deliver the decision, we want to know that what should be the exact procedure, whether it has been followed, not followed, you follow it. Or followed, he's out, that's all.
But their contention only with respect to the holding number.
No, not only one government. No, we'll see that, all those we'll see, we just, because nobody is saying that this is the exact procedure. Das must say that,
No,
municipal,
that-
yes,
yes.
English.
My lord, date after 2 weeks. my lord,
Give a date.
Got it.
Yeah, it's a date as per agreement.
25th, my lord, 25th September. 25th.
25th of September. Yes, Mr. Ghosh.
In this petition, my lord, 2 weeks petition has
The
been.
instruction, I'm preparing my affidavit in this case, Lordship.
They have taken several times, because my suspension under license is under suspension, nothing has
Not-
been done.
No procedure.
No procedure, nothing.
Okay, when you will file?
Lordship, after 1 week, within this week, I can.
That's a last year.
Mr. Borua learned council, state council submits that he has received his complete instruction and would be, and he will file an affidavit by next week. Full stop. In view of the aforesaid, matter stands adjourned. Though Mr. Ghosh has expressed urgency as the license of the petitioner has been under suspension since
Year 23. my lord.
Since?
Since, my lord.
9/10.
9/10/23.
9/10/2023. Full stop.
Well, a date kindly make it.
Full stop. Be that as it may, as an affidavit shall be necessary for proper adjudication, matter stands adjourned and list this matter on 9th of September 2024.
The internal order is there.
Huh? So therefore, we are not fixing it on 9th. Okay, 9th, interim order pass earlier shall continue until
Okay.
further orders.
Obliged.
The last occasion, we were granted time to file the counter affidavit. The counter affidavit is ready, my lord, is being sent to the.
So
Debt
somebody's money is paid to somebody else. Who is that other beneficiary? You are.
But unfortunately, I was one of the, Lordship, my prayer is that I am withdrawing from this case, but my name is Stapin.
Huh?
My name is Stapin.
Why?
Certain matter other reasons are there, and my other, my colleagues is competent matter, he's defending this one.
IA file, what money is already disbursed.
So
Or-
long back it disbursed and there was an inquiry
Hmm.
which is made at level of Deputy Commissioner, SP.
Hmm.
And there is an undertaking given to the SP also by the letter itself. He said that I will return the money. And in the affidavit, he is saying otherwise. Affidavit is saying that no, this is my money. Actually, there is a land which belongs to him. So that compensation belongs to him only. So that rightly I have taken the money. But fact that he letter written by Deputy SP, in the SP letter, there is written by him. He said, I have written a letter. SP said,
How money was transferred to him?
no, that's, but that's belong to me because name is same. His father name is different. No, my name is Probin Bora. His name is Probin Bora. My father is his father is Rajiv. Some
No, no.
Rajiv.
How the district administration do
That's
this?
the whole issue, my lord. How they will so careless. So what
This is not a few
This is-
10 minutes back we have dictated an order.
my lord,
It's
this
good
is-
that they have admitted money was not disbursed.
No, my lord. My lord, my subject to correction, my lord. Though my lord, I am trying to withdraw this from this case, but facts is this. Both
No,
the
no,
person,
if
both the
don't-
person.
you cannot go a step further when you say that I am withdrawing. You cannot.
But the facts is that.
No, we do not want to know
Both
the facts
person
from
did
you.
was well,
No, no, we
No,
are,
I'm-
we are,
but
we
I'm-
are not interested from
But I'm
listening the
right.
facts from you.
I am
Because
right.
you made a statement, I want to withdraw.
But I want to withdraw.
Okay,
My name is-
Mr.
Letter to- My lord will kindly see one.
Hmm.
I could have understood they have given a affidavit has been filed by the other side,
Hmm.
by the party who has already received the money.
Hmm.
But appears from page 47,
Hmm.
can you see two sentence?
Page 47 of?
47
Of?
of my read petition. 47.
Hmm.
This is a letter which has been written by the ADC to SP. Kindly see DC wrote to SP 14/6. You are hereby informed that as per the 3G list, Probin Bora, one of Rajneet Bora, who is the.
Mr. You do one thing, if you want to withdraw, you will have to give a notice to the registry, then registry will issue a notice. Otherwise, we cannot allow this like this. You'll have to say to your
My
client.
brief has already been taken away, well, so difficult is, well, so, and the affidavit that is filed, problem is.
File and file.
No, no, this is affidavit has been filed, but without consulting me, so, my lord, I am in some embarrassing position, so that is why I don't want to.
No, that we understand. We want, what we suggest is, if brief has been withdrawn, you give an application to the registry, my name may be deleted
Okay,
because I have done it. Then registry will put a note. Accordingly, we'll do whatever is necessary. Yes, affidavit.
But
it's
now I
very-
come from this, my.
Huh? What
understanding
is your instruction?
Right.
Instruction is that there is a criminal case pending now.
No, forget about the criminal case.
That
Do
is-
you
that is
admit,
the stand.
do you admit that money has wrongly been paid to a third party? That's all.
Yes, my lord. Structure compensation already received by Probin Bora, son of Rajani.
Who is he? Do you make a
Instead of
state-
Probin Bora,
you
son
make
of
a statement
Bapti.
on affidavit
Yes, my lord.
that whether he is entitled and the other party is not entitled, and that has been fraudulently transferred. Matter ends there.
And one letter is very important. That's why I'm showing this. Kindly see at page 47, 4 lines from the bottom, from the top.
Hmm.
Probin Bora,
Hmm.
son of Rajni Bora, that is respondent,
Hmm.
was informed about the matter, whereupon he sent a letter dated 29/12/2015 requesting 1 month time to refund the compensation collected by him for so and so house of a son of so and so.
Heard Mr. D. Das, learned senior counsel, assisted by, yes, Mr.
Yes, my submission is because I don't worry about it. I have, according to Kala, I have already deposited this amount, his amount. And Kala has wrongly decided. My here problem is coming up, my lord. After 3D, as your lordship ever, after declaration, this is 3D. This, as per provision of CA from NSA, it is a state, it is transferred to central government. But this, as this is now, I thought this in earlier occasion I was not submitting, because this might have been finished. But due to pendency of this case, petitioner's structure is on the way, the service route on the way. Now we are unable to go for decision, though it is as per provision of law 3F of NS 50 Act 56. It is belongs to central government after declaration of 3D. Now that is one question. That is why, my lord, I have prayed in this one an affidavit in paragraph 15 that look into this one, praying for lordship to allow to this one. Because money, there is no dispute between amount of compensation. It is a dispute is between the two parties to whom is to be given. Son of Bout to be give this Praveen Bora, son of Bout.
Your anxiety, you understand.
My, because this is the because
Now
I thought
is there any
by
stay, is there any stay order?
the problem is this in my lord. There is though sometimes what happened, my lord, though there is a specific not stay
No,
order.
there is a problem also. That when there is a stay order, there will be hundreds of contempts. When there is a no stay order, you will not proceed because of the reason that pendency.
That is
That,
also-
that we have seen.
That is also another second.
Uh,
That is your
therefore,
not
when interim order is specifically there, you will demolish and go ahead. When there
No,
is no,
that is-
no
Here-
order, you will
Here,
stop.
my lord, question would have been payment for us. It is a question between two parties. Because my road
See-
is, there is public
see-
interest, my lord, that's why I'm submitting.
No, what we are saying is public interest should be dealt with you.
That-
We have not passed any order against public interest. It's up to you how to you deal with. We are not here to
Mm.
suggest how to execute.
No,
it.
that
This
is
is not
correct.
our
That
job.
is also correct. Next
The-
period is, my lord, another IA is filed by me only.
Why?
That is by NSAI. This is not a party affected by, as I'm also appearing for NSAIDCL also, as I'm taking burden of that NSAIDCL, this matter entire. NSAI is not a party who has constructed the route. That is my strike of the route. This may be disposed of. If lordship pleases.
You want to
NSAI should be
implicit.
no struck off. Because I do, I have
We'll struck
construct-
off on the next day.
next day,
Next day.
lordship.
Is there there is no provision of representing two parties together?
No. Here,
No
sir,
benefit?
there is though I am standing
Enjoy the
council one,
benefit.
standing council one, but separate entity.
Enjoy the benefits. We'll
That is
pass
correct,
the,
my lord. I am enjoying now.
enjoy the benefit. Uh,
How was it?
This is 1792, isn't it?
1792.
Item 15 is not related to this, Mr. Das. Next item is not related to this.
Next item, no.
Okay. The present writ petition is filed with a grievance that though compensation amount of rupees 50,21,953, correct? Was determined as the structural compensation in respect of the property belonging to the petitioner. The said amount has been paid to somebody else who is not a party to the land acquisition proceeding, nor an aggrieved interested person. From the materials available on record, it is also seen that the Assistant Commissioner, Land Acquisition Office of the Deputy Commissioner Jorhat has already lodged an FIR before the Superintendent of Police, Jorhat District, Jorhat, affirming the fact alleged by the petitioner that land acquisition compensation has wrongly been withdrawn by respondent number 8. Respondent number 8, and the petitioner was entitled for such compensation. Full stop. In the aforesaid backdrop, the competent authority, that is Assistant Commissioner Land Acquisition shall file an affidavit incorporating the following facts. One, whether the petitioner was entitled for the compensation as claimed in the writ petition for structural damages. Full stop. Whether the amount has been, whether the facts narrated in the FIR lodged by the aforesaid officer is correct, and whether money compensation amount which was meant for disbursal to the petitioner has been disbursed to the respondent number 8. Such affidavit be filed.
And 10 days time, subject to the convenience of the Honorable Court.
Place this matter on. List this matter on 23rd. 23rd of September. 23rd of September, Monday. The affidavit be filed on or before affidavit be filed on or before 28th of September 20.
It is 24th, it is no problem, it's Tuesday.
Monday. Okay. 23rd. Such affidavit be filed on or before 28th of September 2024.
Deeply obliged.
Otherwise, the said land, otherwise, the Deputy Commissioner Jorhat, within, not Deputy Commissioner, Additional Deputy Commissioner, within bracket Land Acquisition, Jorhat, shall personally remain present and explain the
PWD was also given large chance to file affidavit, PWD.
What will they file?
No, they did not, because your lordship, there is an order passed by this court.
Oh, they have written a letter to the registry,
But they have
the
not
officer.
filed.
Page 121.
Paragraph 5. No, that's a different. That's a land company, land equity, not structural. Yes. That has been referred to Deputy Commissioner, not this subject. Land acquisition, land.
No, that is, no, Mr.
Written, I don't know.
Mr. Nayak. Mr. Nayak, we'll go to that aspect after this affidavit is clear. That's all.
My lord, this officer should be called in the court for chaos.
No, we are not calling him, calling him.
We are suffering, my lord. Like
No, understand. We'll be compensated for payment of interest.
Making a statement. This civil code, what civil code? This is no. Please read the sentence properly. Then you refer to the court.
No.
I read it.
Mr. That is in my mind also.
Yes.
But question is that is to be clarified. Then why FIR?
Correct. And my lord,
what is the meaning of reference?
FIR by the officer has given
Officer,
the FIR.
that's why you want that clarification.
And a vigilance inquiry has also been initiated. Kindly see,
Therefore, this will clarify whether it is a case of apportionment or case of fraud.
Yes.
That's all. Somebody will saying something will not do. The competent authority is the Additional Deputy Commissioner. He will say what is his case. That's why we have made it specific. That's all.
I'm for 20, madam.
Yes, sir.
20.
Oh,
yes. What is this?
But there are two writ petition before this court. Writ petition 228. 2288. 2024. My lord, that will.
What is the subject matter?
I'll tell you a subject matter. There are two first writ petition which was filed before this honorable court is 1840 of 2024. My lord, I'll tell you subject matter. What is the subject matter? I had a piece of land, 1 kata 5 lectures, my lord, which I have been occupying since 1982. I have been occupying that land. Then they wanted to demolish one structure of that particular.
No, land belong to whom?
Land
Patta
belongs to-
lands,
it's
the
a
government-
government land.
It's a government land, okay.
So since 1982, I was there, 1982. Then 2014, my lord, one part they tried to demolish. I came to the High Court by way of a first round of litigation at page 32. Kindly see page 32.
Page 32 of which
32
repetition?
of 22288.
2288, yes.
That will be suffice before your lordship.
Page
Page 32.
32.
That's the first round of litigation. 2019. First round of litigation, 18th of February. If you turn to page 34, kindly see paragraph 5. Paragraph 6, be that as it may, the eviction process has been preceded by a notice under Rule 18.3 of the settlement rules made under the Assam Land and Revenue Regulation. And in the absence of the same, an eviction process will not be legally sustainable. In view of the above, this writ petition disposed of by directing the petitioner in question shall not be
Okay,
evicted.
it was interfered with only for in a want of notice.
Yes.
18.
Now, thereafter, my lord, 21, page 21, then another notice was issued under 18.3. They said you have to appear before us. This was put to challenge by way of the second writ petition at page 35. That is 29/6/2021. See para 37, page 37. Last portion.
Considering the facts.
Considering the fact it is a provided petition say appear on so and so as per the impure, but his position over the land in question shall not be disturbed without leave of the court.
So this
Now, that particular petition was disposed of finally at page 39. 39 on at page 40 is 28/8/2023. And if you see at page 43, last para 6, under such circumstances, it is opinion of this court that no interference called for by impugn notice. Be it as it may be, this court further finds revealed to observe before concluding the responsible authority shall be liberty. Sixth step is permission of law by taking into account the order dated so and so. Interim order so passed on so and so and merged with this or taking into account the stand of response, liberty is granted so and so. Now this was disposed of. Now, thereafter,
as per this order, almost this was writ petition was dismissed.
No, this was merged with the final order. Final order meaning thereby the order which stands that not to disturb my position and without notice under 18.3. Now kindly see page 44 now. 44. Kindly see
Just
page
a minute.
Yes. Such steps as permissible.
What was the stand of the Deputy Commissioner
No,
Rural
no,
in the earlier proceeding?
No, I'll tell you, Lordship. See page 44. I'll tell 44.
Yes.
After that order, Biotech Park, they want to make Guwahati Biotech Park has given a notice. Kindly say notice to vacate the occupied land for development of so and so, so and so. Now, my lord, this we have finally replied page 45. 45. We given a reply. Thereafter, my lord, at page 48, the circle officer has issued a notice. 3 days time was given to vacate. These two notice given by Biotech and the circle office was put to challenge in the third round of litigation at page 50. Third round of litigation at page 50. And the Honorable Court has set aside both the order saying that a Biotech has no authority to issue a notice. Secondly, Deputy Circle
Where is
Office
that? Where is that order?
at page 54. 54 at para 9.
No, not 54, 51.
No, 51 is 50 is the 54 is the relevant.
That is 7581.
7581.
55.
7581, which starts at 50 and operative portion is at 54, para 9. As the impugn notice dated so issued by circle
So it
officer.
is to be now done in terms of the order dated 18/2/2019.
Yes. So, and the Biotech, they doesn't have an authority, Biotech to issue a notice.
Okay, fine.
So this gone.
Okay,
So
then.
thereafter, my lord, I represent the matter at page 56. On 29/12/2023 for allotment under the land
How many
policy.
petitioners here? One.
One only.
How much land?
1 kata 5 acres. So I made a prayer for allotment at page 56,
When have you filed the allotment application?
2023, 29/12/2023. 9/12/2023.
2023.
Yes.
Then when is the next notice issued?
Now, my lord, next notice was issued at page 63. Page 63.
Yes.
63. You are informed that you are occupying government land so and so. Hence, in accordance with this so and so passed by Honorable High Court, it is not Supreme Court. Honorable High Court in 7581, you are required to vacate within 15 days from date of receiving this notice. So this was given. This was put to challenge in the fourth round of litigation at page 66. Page 66. This is item number 15, my lord. Item number 15. Now kindly see the order passed at page 68. Till then, the state shall not carry out eviction department. In the meantime, they will file an affidavit. Now, what has happened, my lord? When the first writ petition was pending and there was an order, my repentation was not disposed of. They took a decision to dispose of my repentation. And accordingly, at page 69, an impugn order was passed. Kindly see this circle officer order.
Any type copies there?
I'm sorry, type copy 9.
Very bad. How this is passed? Because we know the reason how it is passed.
69, 15/3/2024. On the other hand, the petitioner Pukan has submitted
We'll cancel the license of the clerk.
On the other hand, the petitioner Pukan Chandra has submitted one application dated requesting the allotment of land on ownership basis. In this regard, I would like to inform land covered by DAG number 305. Your lordship will kindly note down 305. So and so has already allotted in the name of Guwahati Biotech Park on 5/3/2014. Please note down DAG number 305, as per the report of the circle officer, has been allotted to Guwahati Biotech on 5/3/2014. Kindly note this date. Along with the district committee establishment, other ancillary so and so, field so and so. So his finding is that it will be allotted. Now thereafter, on the basis of report filed by the circle officer, it was placed before the deputy commissioner, district commissioner. And district commissioner at page 70 has passed this impugn order. Kindly see the third line. The circle officer report also state, lordship got it, there is no alternate government land in the vicinity which may be allotted to the petitioner Pukan Chandra Bora. It is also felt that allotment even if in the alternate government land would only encourage such encroachers further and would set a bad precedent. Hence, such prayer cannot be entertained. That's the view. So these two orders are being put to challenge before this Honorable Court by way of this writ petition. Second. So practically, your lordship is deciding the second writ petition. So all has brought here. First round, second, third, fourth round, and this is the fifth round.
At the end of the day, at the end of the day, admittedly, this is a government land.
Correct.
And this land was already reserved for biopark on 5/3/2014.
Now this is the area where I want to. That's why I say please mark this area.
So it
Why?
is 5/3/2014. It is earmarked for biopark.
I'd like to give a photograph so it will give a clear picture.
Biopark. Then how can we help you?
Please, my lord.
It is at the center.
My lord, please hear it. Then take a decision. You reject it. I don't
The central
please
part,
hear it.
the
first.
central portion, how the work has been
My lord,
staged.
my lord, before your lordship looks into that picture, please work.
No,
please go.
we'll not go.
Yes,
No, we'll
please
not
don't
decide
go.
on the picture.
My lord,
but
we
we'll
go by
strategize.
document which has been annexed by the affidavit which is taken by biotech. Please see the affidavit by biotech. Kindly take the affidavit by biotech. What is
Can
the
you
step?
complete today?
Today will not so possible. Because if first part, there are two parts. One part is that allotment, we are indigenous person where we are 1 kata 5 lectures are occupying it. Whether I get the benefit under a land policy or not. This is what your lordship has to look into it because
So your whole
there
case is that the rejection of my settlement is not relatable to the state land policy.
Right.
This is your case that
Right.
this is not relatable to the land policy. Therefore, that order is not sustainable.
One. Secondly, which is most important, whether there is real allotment in favor of biotech. I will show by a document where it has not been allotted to biotech. It has never been allotted to biotech. Why? I'll just show one document and your lordship will kindly take the affidavit that has been filed by biotech.
Yes, sir, Mr. Advocate, you are appearing as Advocate
Yes,
General.
sir, it will not take 10 minutes from my side.
You know, why I'm saying is, today we have spent a huge time on one matter and many matters are pending. So if we can
Otherwise,
decide.
then let it, today is Thursday.
We know you have also urgency, he is also having
But
urgency.
no, he is enjoying.
No, I
And this
enjoy-
public property, the public project could not be completed. That is the plight.
See page 90.
Yes.
Page
Let
90.
it be next Tuesday, Lordship. Do not want that urgency. It has been waiting for 2014 onwards, so another 4
We'll
days.
decide this, decide
Lordship
this.
may keep the matter as part heard.
Well, give it on Wednesday, man.
Wednesday,
No difficulty at 2 o'clock on
2
Wednesday.
o'clock, Wednesday, 2 o'clock.
holiday.
Oh.
Mr. Das wants to come. us here.
Third.
Either he goes to Arunachal or he enjoys the holiday.
Third.
3rd of September. Huh?
I can finish my part. I don't know because
No,
Lordship
I
has other
don't want to
cases.
have a, let us finish in both of your
On
presence.
Tuesday, Lordship.
Third.
Third.
কিভাবে দুটা প্যাকেলে হবে?
2 or we may take it at around 3:30 also.
Yes.
Yes, on 3rd, Lordship, no difficulty. Tuesday.
Generally, Monday, Wednesday,
Third,
Friday,
say two, Wednesday.
miscellaneous matters, we finish up by 2:30.
Then if it is convenient for Lordship on Monday, then.
Third.
Monday
Third
is possible.
Tuesday.
Monday at 2
Third
o'clock.
is okay. Third Tuesday.
Monday.
No, Tuesday is,
2 o'clock.
Mr.
Tuesday,
Das,
Lordship is-
Tuesday is difficult. Today is Tuesday, we are not even reaching 17.
He will do. I will not be there. He'll let him do it. But they are in urgency. That's all.
No. That is not, we'll take Wednesday, Wednesday holiday.
Then not Wednesday.
Wednesday holiday,
But then Friday next
next Friday.
at 2 o'clock. Yes, Lord.
I think we'll.
And Lordship may keep the matter as part heard, Lordship.
Okay. Heard Mr. Didas, learned senior counsel at some length, full stop. Place this matter for further hearing on Friday, is the date, 6th of September, 2024.
6 September.
Further. So basically, we can decide everything on 2 to 8.
Yes. There is
Interim order pass earlier shall continue till then.
I was about to leave. My learned friend saying interim.
No, we cannot do anything in this 1 week's time. He has already enjoyed it. Maybe not from 1982, but subsequently. Only 2 cows are creating the problem. He has a cow shed where 2 cows are there. The first paragraph of his writ petition.
We'll see. Whether I'm entitled to stay there or I'm not
So
entitled
Mr.
to.
Das, he want to say that there is only cow shed. The landless is having somewhere else.
No, that is why
That is
I'll not
why.
disclose my cards. Lordship has rightly indicated.
So landless is having land somewhere else. That is only for his cows.
It has already fallen from Lordship.
But landless having some, it has to be justified by way of document that I.
See, our eyes
That-
are
That's what
closed.
I'm
No,
saying.
we do not see anything. We'll just see the law. That's all.
And
And I supplemented with that photograph.
But I will show the judgmental reference code of the legitimate expected doctrine of legitimate expectation 43-44 and backed by Supreme Court judgment. Otherwise, the land policy will be meaningless. My lord, otherwise it has to be removed, the land policy. Entire land policy has
Understand,
to.
your argument would be, okay, you cannot give me land there, but if I fulfill all the criterias, you are supposed to give me land day after tomorrow.
No,
Why
if
not
it-
today? Give me somewhere else, I'll go.
No, they say
Where
they
is
are
that
not giving.
application?
Where is
That
that?
is the crux.
No, then
Where
we
is
can
that?
file an application.
This
2023.
application is not that application. The application should be under Project Bosundhara, where there are certain specific columns, which I am sure
Project-
you will not be able to fulfill.
Project Basundhara land policies of 2019, 89. There was no Basundhara project with a form in
You
1989.
have filed in you have
Yes.
filed in 29/12/2023.
I'm sorry.
You have filed the
Yes,
application on 29th.
Yes.
That is just a representation.
He said that we
Okay,
should
okay,
not
next.
encourage.
Keep your energy for
I will
Friday.
always-
Full of energy.
My
Lordship,
energy is-
last
my
week he was in
energy-
Arunachal.
My lord, my energy is always there.
Yes,
With
yes.
blessing of God.
Yes.
He
And
always
whenever-
played five setters.
My lord,
in
whenever
tennis.
we both are there, one of the judges, I will not say, one of the judges retired. Always there is difficulty because we both other side, we fight,
Okay.
Get your blessing.
but that's a beauty. We
That's the
go
beauty.
out and we forget and.
Only we miss Mr. Mohanta Lordship.
Yes,
That is the problem.
That is the problem.
That's why when we argue, tooth and nail, but there is no personal involvement.
Yes.
We must
That should be-
understand,
that
he is
should
on no personal involvement.
For me
There
also.
But
We may
I
review-
have a personal involvement here, Lordship. The public interest is paramount.
Fine, you go ahead.
SG can say that.
No, no,
He may not
say-
have any interest with the
No.
cows. But
He will
No,
say.
SG can say that I am having public interest, but you cannot say that I have
AG
personal
has
interest.
said- No,
No, no,
AG has said,
the solution is
personal
very
involvement-
easy. We can send the 2 cows to the Gosala.
but AG said, I have got some personal involvement here, public interest.
Yes.
Let's see.
Yes. Okay.
I'm deeply obliged.
Next case.
Highly obliged.
Yes.
So here we have on the maintainability of the petition.
We have seen that.
Actually, when this case by Leonard Regard we have discussed in the last time also. This case is completely different from other cases.
Okay.
Recently, one judgment has been passed.
Mr. Kyle, have you filed any objection
no,
raising preliminary?
I'm relying on, because this is a law point lordship.
Yes, yes. I will explain, it will take up 10 minutes, my lord. If that your lord is satisfied, then it will be maintained, otherwise, no, I have no hesitation on that. My lord,
Yes.
here, page number 81. In the writ petition, make kindly.
Page
81. And next 5. Here, the Assistant Commissioner Audit Circle 2 issues one notice on the petitioner on 28th June 2016, demanding 5 years documents for verification and audit regarding taxability of the petitioner. So here they've asked for balance sheet for 5 years. Trial balance, annual sales tax return, annual income tax return, internal audit report, financial statement.
Okay,
payment,
then?
all these documents. Thereafter, these documents will be verified by the audit team. Page number 2082. The audit observation is issued. Audit observation, short payment of tax is 1,25,000, education says 2,416, and secondary higher education disbursed total
So
1,20,000.
total is 207,385.
Hello?
207,385. Okay, then
This I
paid.
deposited.
Okay.
83, page number 83. Page number 83, Annex 7. This is the audit report. After payment, it pays serial number 9, period for which current audit has undertaken, April 2011 to March 2016, 5 years. And the amount 1,29,000 in the last item of serial number 17. Revenue involved in the audit para 1,29,150. And it pays 84.
What is the period here?
Period here is April 2011 to March 2016. That is audited, completed. Then in
When this demand notice was given, this was demand 2020.
20. This is, my lord, I'm coming to that. At page number 84, that observation, SSC agreed the above point and paid service tax.
Accepted and closed.
Closed. Then matter has been closed. Again at page number 85, a demand comes so called notice is issued on 29/9/2020, which is illegal and without any jurisdiction.
Now, this is tell us what is the period of this?
This period is our so called notice starts from April 2014.
Let us see where.
At page number 85.
Financial year.
Financial year 14-15.
15, 16, 17, 18.
Up to June 2017. So this period covers up to October 2016. Audit has been completed. When audit has been completed, the department has no authority to issue this demand of show cause notice, and on that basis, the department has no authority to confirm the demand by his ordinary original. My lord, in this case, section 73, 4A of the Finance Act 1994 may kindly be referred. 4A of the 9. So in this case, the department is.
Mr. Kyle, this matter will require some adjudication.
Lordship, from the impin order, Lordship, I'll show everything it was considered and
Either you file an affidavit or we take it some other day. It will
Lordship,
need some
Lordship,
application of mine.
4A may kindly be seen.
may
Huh?
take some
Section
other
4A,
day
this is
taken.
complete against this.
On other day, sir,
procedure.
may be taken.
Because many questions will be involved, the period, at
Lordship.
what stage you have done it. At-
No, Lordship, here, our main objection is that alternative remedy in way of filing appeal is there.
No, alternative remedy, we understand, we are well
Lordship.
aware of that fact, we have
And-
passed judgments also, but prima facie,
He has no
uh,
authority to issue this.
we are prima
Demand
facie,
notice.
we'll have to make a deliberation that two things. One is, this demand is in the year 2020. More than so many period is expired.
18 months, more than any, but limited period, limitation period
Okay.
18 months.
That is over. That some reason is given for assuming jurisdiction. Second issue is that apparently prima facie, subject to what you argue, this was dealt with by audit. Can you allow a person what time and again?
Lordship, whether it has been considered by the adjudicating authority or not. Lordship, may come to.
No, that will go
Why
to
not
this. Do you want
section
to file an
4A?
affidavit or not? Tell us.
Not required.
Not
I'll-
required.
I'll submit
Okay.
on the basis of the impin
Okay,
order.
Well, section 4A may kindly be
okay,
seen.
no, we will not decide, you will not decide. You are enjoying a stay?
Ah, yes.
You enjoyed a stay for
Yes,
some
yes,
time.
yes. I have not, my kindly issue the stay order for the purpose. So like,
No,
there
there
are
is a stay order.
no stay order.
No, demand is there, na?
Demand is 1 crore.
No, where is that order? There is a stay order. I have seen it.
This matter was heard by.
Demand is
earlier
1
also.
crore 69 lakhs and penalty also equal amount, but so no stay order has been said be passed.
The present petition is filed assailing and assailing and demand comes so cause notice dated 29/2/2020 issued by
Joint
the Joint Commissioner dated 29/9, no? Issued by Joint Commissioner of
Central Excise Goods and Service Tax.
Joint Commissioner
and Service Tax.
GST.
Yes.
Joint Commissioner GST. Whereby a demand of rupees, how much?
1 crore 69 lakhs 71
1 crore 69,71,108 was made,
penalty.
including cess for the period for the financial year 2014-15 to financial year 2017-18. Full stop. Mr. S.C. Kyle, Learned Counsel for the GST has raised an preliminary objection as to the maintainability of the present writ petition on the ground that such a action is an appealable order under section
Section 85 of the Finance Act,
73, 73.
Section 73
We have the Finance Act 1994.
or the
85,
fin- huh?
85.
85. It's an appealable order.
Yes.
Is an appealable under.
क्या बात कर रहे हो? ये देखिए appeal है.
Applicable under section 85. 85
Yes,
of the Finance Act 1994. Par contra, the learned counsel for the petitioner submits that the alternative remedy shall not be a bar to entertain the present writ petition, more particularly in the given facts of the present case that already an assessment was made for the aforesaid period. Already an audit was conducted by the competent authority as regards aforesaid period, and short payment was detected to the tune of rupees 129,150, which was already paid by the petitioner and accepted by the Assistant Commissioner, Dibrugarh Audit Circle 3. And therefore, the Joint Commissioner shall have no jurisdiction to issue a demand notice in the manner that has been issued. Full stop. Therefore, in the considered opinion of this court, this matter requires further consideration as to whether the Joint Commissioner GST has issued the demand notice and within his jurisdiction and competence. Full stop. In the context of aforesaid issue, Mr. Kal submits that the GST need not file any affidavit in as much as the demand notice impugned itself discloses that all the aforesaid facts was considered by the Joint Commissioner. Full stop.
But see here, final order has already been passed on 27/3/2024.
And that already a final order has been passed on
27/3/24.
So therefore, you need to that is in a part of the record.
Yes, Lord.
25
understand does not reflect the
2024 demand notice was issued and subsequently and final order was passed on
27/3/24.
2024. So this matter needs further consideration as regards maintainability, more particularly in view of the issues raised by the learned counsel for the petitioner. Accordingly, list this matter when?
Anytime, Lord.
Give a date.
In the next week,
Huh?
in the next week.
Not next week is not possible. Too busy.
Lordship, another thing, that amount was malentment that has already been abated. That is also
Why not,
mentioned here, Lordship.
No, we'll see that. We'll see that. See, Mr. Kyle, why I'm saying is it will require some application of mine. That may not be possible at
No, that is correct,
45.
Lordship.
That's why. That's why I've recorded so that on the next day looking at it, everything comes into our mind.
My Lordship, that is the my landed.
No, we are keeping the maintainability open.
No, Lordship, it is due to the petitioner, counsel of the petitioner to place the correct fact before decision of.
Okay.
That is Lordship.
Okay.
It is there.
They have
Why
given the jurisdiction, my lord. When they already supposed heard every issue, whatever.
No, I understand. Your case is that he has no authority. Everything will fall flat.
Yes.
That is your case.
That's why
We'll
my
see that.
comment
We'll see
is
that.
that.
We'll see that.
So,
Now, next question will be if everything falls, whether the appellate authority can even decide
yes,
whether it fell fast frauds or not. That is also another issue.
yes.
And whether it's an absolutely legal issue.
Legal
That is also a question.
Legal
We'll see.
issue, Section 4 completely bars.
25th of September 2024.
Yes, my lord.
As
My
the
lord,
matter
till
is
then,
under
there will not make
adjudication,
any course action, my lord.
in adjudication till then, no coercive action may be
Yes, my
taken upon the petition. What is this?
Instruction.
Yes, Mr.
Yes, Lordship, the instruction was sought from us whether that lady is still living in that land. Still living, Lordship, no eviction was conducted.
And
This
what
is
is
the-
your proposal?
So Lordship, maybe on that line it can be disposed of. উপরোক্ত বিষয় সন্দর্ভত লাটমণ্ডলৰ সৰজমিন তদন্তৰ প্ৰতিবেদন মৰ্মে সন্মান সহকাৰে জনাও যে চপাই মৌজাৰ মঙলদৈ টাউনৰ ইমান নম্বৰ চৰকাৰী ডাগৰ অংশত
Print out a Just wait for a minute, we'll
Lordship.
dispose it.
Lordship. May I read the 2 lines?
Yes.
ইমান নম্বৰ চৰকাৰী ডাগৰ অংশত গোচৰকাৰী কণিকা শৰ্মাৰ পৰিয়ালে ঘৰ সাজি বেদখল কৰি আছে। ভূমিলেখ নথি তদন্ত মৰ্মে দেখা যায় যে উক্ত ইমান নম্বৰ চৰকাৰী ডাগৰ মাটি কোনো লোকৰ নামত আবণ্টন পত্ৰ হোৱা নাই।
Only thing, your lordship, her application for settlement, probably, your lordship, you will have to file a Kobula.
How the deputy commissioner will communicate?
Lordship.
Deputy commissioner will communicate her, assist her how to file the application.
Lordship.
And then let them decide. Just wait for a moment. Third, Mr. Borthakur, learned counsel, who is
And in the first page, Lordship, in English, the 5th line, no eviction has been carried out in connection with eviction case number 6 of the 25, which is under challenge in this case.
Yes. Full stop. Bottom area, order dated 21/8/2024. In the aforesaid backdrop, none represented a petitioner on the on 21/8/2024. And in the aforesaid backdrop, this court requested Mr. Borthakur, as Borthakur, learned counsel, to assist this court, and also requested Mr. H. Sharma, learned state counsel, to obtain instruction from the concerned deputy commissioner, Dorong Mongoldoy, as regards the present status of occupation of the petitioner over the aforesaid land. Full stop. Mr. Sharma has obtained instruction in this regard. Full stop. The instruction reflects that on the basis of the circle officer of the concerned revenue circle has ascertained on the basis of the report of the lot mandal that the petitioner is occupying the government land under Government Dak 2282, and no person has been granted, nobody has been granted settlement in respect of the aforesaid land, and though eviction case number 6 of 2015 was initiated, however, no eviction has been carried out. In the aforesaid backdrop, Mr. Borthakur, learned counsel, submits that the record reveals that there is already an application for settlement way back in the year 2000, way back on, where is that?
27/6 page, your lordship. 4/8/2015.
4/8/2015. 4/8/2015. However, 4/8/2015, and therefore, in terms of land policy, as well as the principle laid down by the division bench in Salahuddin versus State of Assam and 2 others, this court may direct the respondent deputy commissioner to consider the case of the petitioner in conformity with the land policy and the ratio laid down in Salahuddin Supra. Full stop. Mr. H. Sharma, learned counsel, state counsel, has also submitted that in view of the determination made in Salahuddin Supra, and in the backdrop fact that the petitioner had already applied for settlement, the competent authority is to come to a logical conclusion on the basis of the application filed by the petitioner in permissible under the land policy as well as the ratio laid down in Salahuddin. We have considered the matter in entirety. From the record, it is seen that the petitioner, from the record, it prima facie appears to the court that petitioner is a landless lady and she is occupying a government land. It is also seen from the instruction of the circle officer that such land has not been allotted to any institution or any individual. Full stop. Such land has also not been already earmarked for any purpose. In the aforesaid backdrop, full stop. The division bench in the case of Salahuddin Supra laid down the following principles of law so far relating to an eviction process. It will go paragraph 7, huh? Paragraph 7. Full stop. Then in view of the aforesaid, in the aforesaid proposition of paragraph 8, theatre side, okay, dispose of.
Only thing, your lordship, she is under occupation of 1 kotha 5 lakhs.
5 lakhs of land. That is also permissible. 1 kotha 5 lakhs as disposed of. While parting with the record, this court puts on record its appreciation as appreciation to Mr. Korthakur, who has ably assisted this court on its request.
Obliged.
Hey, please, your lordship.
Yes.
In this matter, if I may please be granted 10 days time, there's some miscommunication. We couldn't send the letter.
There's this one, there's one document which I found.
In the record.
I submitted to my senior friend also. Yes. Your lordship would kindly see the case which is cited at the end of the first paragraph. Jagpal Singh and others versus the state of Punjab. Your lordship sees that. This case was relied by them, by the state, to deny the settlement. This notification came in 2015 and it's not retrospective. My right accrued sometime in the year 2006. And there are other factors also which.
Now, see, we are in a very precarious situation. Lawyers, they are not being represented. Petitioners are not being represented. So we made a request to Mr. Sharma to assist this. And we want your instruction, what is the present status of the land? Because he can only go from this, suppose they are not interested. Or the land has already been, they have already been evicted. There are some construction has come or something. We do not know.
Whatever it is.
Whatever. M.S.S. Sharma, Learned Council, State Council has prayed for
10 days time.
10 days time to complete her instruction. More particularly, whether the petitioners had already been evicted or they are still occupying the land from which they are sought to be evicted. Inasmuch as this court has requested Mr. M. Sharma, Learned Council, to assist this court, as the petitioners are not represented by their engaged councils, and they and for the reason that brief has been withdrawn from the said councils. You just have it like Mr. Sharma earlier case, you just have
Pursue this in honor. I will. Obliged, lordship.
We are keeping it. Please this matter on after 10 days give a 12 after 2 weeks give a result.
Deeply obliged.
Pending matters. Number 8.
Yes, Mr. Pathak, what is the law in this regard? Suppose there is a negligence by report of negligence by the electricity, forget about this case, the electrical inspector. That negligence is on the part of so and so. What is the procedure, Deputy?
Then there is either a possibility of the distribution company to file an appeal under 164, Your Lordship. And if it accepts, then compensation has to be paid under the.
What is that compensation?
4 lakhs, Your Lordship.
So in this case, when report is there, you prefer appeal, whatever you want to do, you do. You pay them 4 lakh subject to outcome of the appeal. But I want that notification, that's all.
Lordship, I have otherwise sent a copy, emailed a copy. I have a soft copy if Your Lordship may like to.
We'll have it, madam, we'll have it day after tomorrow. Okay, we'll pass because I want to go through it because this is not clear to me
My
also.
colleague was handing the brief, actually, I was.
Okay, so here affidavit has been filed, more or less it is the duty. So if that, then 4 lakh, then if they want enhancement, they can also go to civil court. That is the provision.
That is the.
That provision I want because I'm dealing with many cases in this,
Yes,
and nobody
very
has been able to.
Very well.
That is the provision. You are getting more than 2 lakhs
Yes. Lordship may have it tomorrow, Your Lordship, I can.
tomorrow. List this matter tomorrow by slip.
Oblige.
Mosumi, give that. Mr. Pathak, you have sent it, soft copy?
Soft copy I have already emailed.
Okay, you give it. What is this item?
Item 10, Your Lordship.
Yes, not. 45 minutes left. Okay, let us start this.
Yes, yes.
Lordship, the case.
Just refresh us.
Lordship, the case is, Your Lordship, the petitioner who is a businessman, Your Lordship, the nutshell is like this, Your Lordship. He purchased some, Your Lordship, betel nut from Jiribam area, Your Lordship, and loaded it in order after paying GST, etc. in a train, Your Lordship, for onward transmission to transportation to Your Lordship, Nagpur, Your Lordship. Now, while that was done, Your Lordship, police, Your Lordship, suddenly, Your Lordship, intercepted and Your Lordship, they lost an FIR and seized these articles. It was not only.
How many matters are there?
Well, there are 2 cases.
Huh?
There are 2 cases.
Today, how many matters are there?
2 petitions. Here.
No, not here.
Oh,
Total matters. Mati Diamond just I going pastel. Yes.
Police intercepted and Your Lordship seized it, Your Lordship, and prior to that they lost an FIR. Your Lordship will get the FIR at page 32, Your Lordship.
Page 32.
Page 32. Your Lordship will see the language of the FIR and the case section under which.
Just give me 5 minutes.
Lord. Case of unlawful and dangerous goods is being transported through malicious uses of the goods transportation services provided by the Indian Railways. A parcel special train currently halted at Badarpur railway station, supposedly arriving from Dharamnagar and Jiribam areas, contains their suspected substances concealed with other consignments. It is highly suspected that such transportation of illegal good is not only harming the nation's financial security, but also threatening the national security. Information has been received that the transit of illegal and unlawful goods involve number of influential persons who are conspiring these activities to wrongful gains by using false documents. Hence, you are requested kindly to register a criminal case under the social elements, this conspiracy, and do the needful for the protection of the society. And case is registered under Your Lordship section 420, cheating and dishonestly inducing delivery of property, 379 theft, 411 dishonestly receiving stolen property, and using 471 using as genuine a forged document, Your Lordship. Now, on the face of the FIR, Your Lordship, these sections cannot come, Your Lordship. And then Your Lordship may kindly come back to page 24, Your Lordship. Your Lordship will find that these are the e-way bills, Your Lordship. We have paid GSTs. Page 24, Your Lordship. This is the e-way bill. Then Your Lordship, tax invoice at page 25. Local Erakan at Your Lordship, 1,95,800 we have paid, Your Lordship. as GST. And this is your lordship will find next page, your lordship. This is the your lordship from the railways, your lordship. For booking, your lordship.
Anything disclose what is.
Lordship. Then what they did, your lordship, your lordship will then find your lordship. Then on this FIR was on 11/9, your lordship.
Just a minute, we want to see the railway parcel, how it is written.
Lordship.
What is the,
Your lordship will chargeable distance, your lordship, Ziribam. Then 2,800 kilometer, your lordship, and the original is at page
the most
31.
vital part you have not typed at page 26.
Page
Most vital part, page 26. You have just typed chargeable distance 2800.
Lordship.
But most vital document is you have declared there also dry Arakanat.
Lordship, lordship.
That
Dry
is-
Arakanat.
Yes, then
Then your lordship,
what is page 28? GST.
GST, your lordship.
Okay. Okay, these are okay.
Then your lordship, on 11/9/2021, this FIR was lodged, your lordship. On 29/2021, there is a prayer before this, before the Chief Judicial Magistrate, Karimganj, your lordship, by the investigating officer, your lordship, for page 37, your lordship. For passing an order under section 451 of CRPC for action of this seized unclaimed battle Arakanat, your lordship. Now your lordship will find, your lordship.
Where page 37?
Page 37. With reference to the subject cited above, I have the honor to report that on 11/9/2000, based on a specific information from a reliable source, that a package of unlawful goods substance was being transported through malicious use of goods and transportation service provided by Indian Railways. A parcel van and special train halted at so and so, supposedly arriving from Dharamnagar and Jiribam area contained suspicious substance, and it was being transported to other places with a conspiracy for their wrongful gain in this.
When the FIR was given?
11/9 euros.
11/9. And when this application was filed?
On 29 euros. In course of investigation, self-examined the complainant, recorded his statement under 161 CRPC and all suspected goods.
Who is this complainant? That is the officer.
Officer, your lordship,
Officer.
police officer.
Okay.
ASI. Complainant recorded 4,680 number of gunny bags containing Arakanat, amounting to total of approximately 3,85,164 kilograms, in presence of the executive magistrate and other independent witnesses, by observing all formalities and duly seen the seizure list and seized exhibit before the Honorable Judicial Court. All the efforts have been made to find out the consignor, consignors, consignees, claimants of the seized item for the instant case, but no claimant has turned up in respect of the seized items, your lordship. And moreover, the expert opinion report of the seized exhibit was obtained from the concerned authority, where the expert food safety officer Karimganj opined exhibit are fit for human consumption.
Whether they have interrogated any railway officer, any seizure has been.
That your lordship only record can reveal, and your lordship will find, your lordship. In GST, my address is there, your lordship. Will.
No, therefore I am asking whether you have seized or something, or that is coming, because according to you, these were transported with documentation. So railway authority will disclose them that this is our copy, that this is the matter is coming from here to here. Where is there any case there is there?
Yes.
Okay.
And
Just go through that.
And then, your lordship, auction was ultimately completed. Before auction was completed, your lordship, I filed my writ petition, your lordship. But somehow, your lordship, when the matter was taken up, the police officer came, remained present personally in the court and said that auction has already been completed. Therefore, no stay order could be passed. And my money.
But money was kept. Money was there.
Money was kept there, your lordship. My case, your lordship, essentially is this, your lordship. Your lordship will kindly come to page 39. That is the order of the CCM. I have put all this to challenge, your lordship.
Page
39, your lordship. First part, your lordship, the narration of the facts, your lordship.
What is form of deposition? Why dear deposition? Deposition under what?
One deposition under the provision of section 451, depositions can be taken of the investigating officer, your lordship. This is the deposition, your lordship. And then your lordship will get the order at page 41.
Yes,
41. your lordship.
deposition of,
No, this is your lordship, the order, page 41, by which auction has been allowed to be done. First part, your lordship, the what IO has stated, your lordship. Page 42 is the finding, your lordship. In spite of examination of the witnesses, preliminary investigation, no consignors could be identified and communicated, hence persons entitled to the seized property remain unknown and none has approached the claiming their ownership. The seized bags are huge numbers and occupying railway platform and causing inconvenience and risk to the railway passengers. In view of the quantity of seized goods, it is difficult for securing proper.
now how do you say this is, there is a report at page 42. I
Lordship.
communicated to concerned local police station for address of the enterprises.
Lord.
However, it was been reported that no such enterprise physically exists, which was changed. In spite of examination witnesses, preliminary investigation, no consignors could be identified. Now, what can we do against this order at this stage?
No, your lordship, this has, your lordship, virtually your lordship, auction has already been
Done.
your
Only
lordship.
thing is that
My
whether you,
only- My only prayer. is
your only thing will be if we are satisfied that you are the person who is entitled for
Lordship.
the possession of this arakanats, you are entitled for the money to be refunded back with an liberty to approach competent authority for damages and compensations if so advised.
Your lordship, my prayer is that since the entire exercise they have been carried out is out and out illegal, your lordship. The money they have been keeping it, your lordship, by executing a bond, hand it over to me. And I will execute a bond against that, your lordship, and my money, your lordship, my business has been, your lordship.
No, that yes, let us see the case diary, how they have.
In her case, probably, your lordship, the auction has not been completed. There is a stay order from the.
Because
No, we'll see. We'll hear you. Don't worry about it. Now we want to see Mr. Nath. On 11/9/2021, this is the material. On the basis that these are illegal. Now on 29, they produce before this, that is within 9 days, they say that we have failed to identify who is the owner. And they say that these are the documents with railways. Whom they have interrogated, railway officers, what is the consignment, that is traceable. We will not believe that this is not traceable.
No, page 41, Lordship has seen the order dated 21/9/2021. This is in fact the impugned order in this petition. But here they have challenged this order, and Lordship has seen at page 42. Thereafter, all it is mentioned there. Thereafter, all efforts have been made to find out the consignee claimants of the seized items, if any, in the instant case, but no any claimant has turned up claiming the seized items. That on requisition, the railway authorities informed that the total 8 consignors, namely so and so, they have mentioned.
So that requisition is made by the magistrate.
Yes, Lord.
Magistrate.
So
we want to know prior to that, when it was seized, how they proceeded in the investigation. Because it is the police's case that we have failed.
And even the
magistrate is second stage.
Yes, yeah, even he has also recorded that I have communicated to the concerned local police station of address of all the enterprises, because from the railway authority addresses have come to the learned court below, that these are the consignors, these are their addresses, because the documents they have given. And what he found, that I have communicated the concerned local police station of address of all the enterprises. However, it has been reported.
What is the final outcome of the investigation?
No, investigation, the records are with us, and possibly at that stage,
What was the last stage of investigation?
They have referred.
Have you recorded their statements? Have you seized their GSTs and all?
I'll just indicate.
This is the
I
case
have
of,
seen,
if,
I have
if,
seen,
if these are the correct facts.
if I may, I have seen the railway officers in and so many statements, so many statements of all many officers they have taken. For whether their statements have been taken or not, I'll just indicate. I'll just indicate.
Yes, what you want?
Page number 60 in item 10, my lord,
Ah.
in my matter, there is a representation because seizure was done from the, because we have booked under the railway. The goods were seized from the railway. Therefore, we submitted a representation before railway authority, your lordship. Page number 60.
Okay, we'll go, let us understand.
And the
Then-
date of the representation is, my lord, 1 day before the auction. And the railway has filed the affidavit saying that they have not received any representation. But in my petition, your lordship, the representation has been received by the authority.
No, this issue is having a serious consequences. Mr. Nath,
Lordship.
see, suppose I have sent a suitcase to my son with some materials to Bhubaneswar. Somebody lodges an FIR that see these are some illegal materials. Do it, seize it. They have seized it. Okay. What are the illegal materials? That is to be verified when it will be illegal. Before proceeding within 9 days, therefore we want to see how they have within 9 days concluded these are illegal. So for making a prayer for auction.
Lordship, I have seen.
See, Mr. Nath,
Lordship.
it is a case, there may be illegality, but the high-handed action subject to what you say, if these are allowed, if railway is a silent spectator, we can accept that if you open it, you get the packet of ganja. Of
Then
course.
the would have been different. Your
That is, of course, this is because you are having a right to suspect. You are having a right to seize. But after seizure, if you get Areca-nuts, prima facie Areca-nuts is not the illegal things.
Areca-nut is not illegal.
Not
but-
illegal.
but
So
but
the
Areca
moment
nuts-
it is
but-
not
but
illegal,
the
then you will
source
have
of-
to do further investigation. Why
But-
you need an auction immediately?
But the source of, because the Areca nuts were full of 7-8 wagons in the railway station.
Therefore-
And there is no space to keep all those Areca nuts. Those were in the
Because
wagon.
railway will charge you. Railway will charge you because railway is not, have not doubted.
Ultimately, after seizure, police has to take some steps. And Lordship may see, Malad, these 7-8 thousand bags of Areca nuts, thousand bags of Areca nuts. Ultimately, they are claiming that these are local produce. But in the writ petition, as
Don't
well
go
as
to
in
that
the
arena.
investigation.
Don't enter into that arena. Local, unlocal.
Then customs will
Moment you say it is unlocal, you are out. Simply
then
you are out.
customs.
Mr. Nath is out. We will have to call SC Kyle.
Malad,
You are out.
at this stage of suspicion,
Mm.
at this stage of
No,
suspicion,
you cannot. Is the even if you have a suspicion that this is a foreign good transported into India, the first duty is to inform the central customs.
after investigation, if they
No,
found
no,
that
no,
there is
no.
no, because they said that
Your whole case is this is an illegal thing.
illegal thing.
So illegal thing substance. What is the substance?
Railway says that these are the persons they have booked and
I will
these
say
are the
what is.
address.
I will say what is what.
Lordship.
Thing is that earlier moment it is Areca nuts, it was said that this is source of Burmese origin. And it continued for years.
And
And
that-
police will listen to me.
Lordship.
Let me tell you the history. And I'm saying history not on the from air, from judgments of this course. Then it is continued. Not only the police, even army used to seize it that these are foreign goods. Then there is a challenge. The High Court says that you don't have jurisdiction. What you can do is under the Customs Act to intimate the custom. You can keep it for some moment, some time, so that it will not go out of your hand, and immediately you will have to forthwith intimate the customs. Then customs will take over the investigation. If customs thinks, and there is also some areas when custom can exercise its power. You cannot say that in Borpeta there are some arenas without it to be Barmit. There is a relation to the border. It's not that easy. So therefore, when this judgment came, now Arakanat is to be seized. How to seize? Two way. One, I'll have to say it is stolen, or that it is an suspect to be an illegal substance. That is what has happened. That power also you are having. Moment you open it, you find it in Arakanat. Your first duty is to whether this was legal or illegal. Prima facie, how will you decide it's legal or illegal? Whether there is tax is paid, GST is there, transportation permission is there, or consignment is declared. That whether consignment is declared to be something else and we found it to be something else. This is not case. Consignment is declared to be an collectively dried Arakanat. GST is paid. That all documents are with the railways. Now you seize it, put it in the platform without verification of anything.
Railway has given us the goods booking receipt. They have said that these are the persons. Suppose Sri Bhairavnath Enterprise of so and so is the person, is the consignor. Then the order reflects that we have verified from that address, that we have verified that where from, who is the owner. Ultimately at that particular place there is no person or the address given in the receipt. There is no such.
Who says no person? Person is here before us.
No,
this is your failure. We'll give the not only the amount, the compensation also. Yes. The person is before you. This is your failure on your part for that the huge damage has been caused to the persons.
They could have issued an advertisement, Your Lordship. For auction, they have issued advertisement. But for this, they don't have time to issue even an
9 days.
Your Lordship, in paper, Your Lordship. I don't even know, Your Lordship, that the goods has been seized.
Yes. Case diary.
Yes, the statements of the persons claim to be the owner or claim to be the beneficiary. Their statements are also evident.
When those statements were taken, date.
210 already. 210, 310 like that.
210, 310.
Yes.
So 20 on 11/9 you seize it. On 29 you say that our hands are off. We do not know these people. On next month you get everybody. You record their statement. You have everything. Now who will compensate this person?
Good. That Malad, in fact, the trial court has passed the order under 451. Malad, they have filed the application and they have their remedy there. Malad, they can go because the Badarpur.
No, remedy they can go, but auction was already done.
Some portion has been done to ultimately it protects their interest.
Already done. What is the report from whose report that they are not, nothing is there? Can a magistrate pass order like this?
Malad, the auction and keeping the money in safe custody protects in fact their interest. Malad. Otherwise, suppose
No, protects their interests. We are not saying not their interests, but if we allow the police to proceed in this manner, prima facie these are genuine products.
No.
Prima facie.
I would submit.
Later, therefore, I'll see the case diary.
Yes,
What is the stolen material? What is your finding on that?
Suppose in respect of the other repetition, the goods are not auctioned. Ultimately, those are perishable goods. Malad, possibly by this time quality has been degraded, and this
for industrial purpose.
That has also been declared by division bench, saying that this is not of your business. Division bench, our High Court.
The value.
Our High Court division bench judgment in a custom case, this is not your business. If that is not human consumable, if they have taken it back, if that is used for human consumption, that will be a different new cause of action. This is not your business.
I'm on the auction part. That if it is auction, ultimately the money is in safe custody and it
There is no quarrel on that. See, today we can return back the money. No problem on that. We can give them the money. But see the carelessness of the situation. I'll see carelessness. We'll record it from the case diary. So citizens should not be allowed to suffer like this. Genuine case, okay.
2021 onwards, Your Lordship, my business reputation gone, my money, Your Lordship, for 4 years, Your Lordship. They are keeping my money, Your Lordship. Not, they have not even been even filing the charge sheet. this
Yes,
case, Your
ask him to flag mark the important parts of the
Yes,
case.
yes,
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 Mr. Nap.
yes.
So at the end of the day, let us not go to all this. They have been able to establish here prima facie that this material belongs to them. Auction has already been done. Let them return the money. Let them give
I
the
will
custody
execute a bond, Your
with issuance of bond. If we dig deep inside, many body will be in the problem. Let us shortcut it.
I'll submit the case there along with the statements and whatever they have found.
You just
during
flag mark it.
investigation. That I'll submit, that I'll submit.
Otherwise, it is not so necessary because prima facie you are satisfied that they are the owner. That is what is required. And what is the judgment, Supreme Court judgment? That
Ambala, Your Lordship.
Ambala. Ambala,
have
then
it.
our division bench, then this court has laid down the principle balancing all these judgments. What should be the principle?
That's true.
So therefore, you take them, they will give a bond, keep some sample of the Arakanats for trial. Have the photographs.
Otherwise, case is registered, investigation has gone to an extent, let them complete.
So
the investigation,
therefore,
things go on.
we have laid down its proposition on the basis of Sundar Bhai Ambala that it is keeping the Arakanats or vehicle or anything is not necessary for the purpose of the investigation. You cannot exhibit, that's why you have sold it. Is not it? Let the money be returned back to him with an undertaking. That subsequently he will give it a bond and she will also give it a bond to compensate and
Since there is a stay order here and because of the stay order.
no, that will clarify. And so far relating to her material, her things, she will take samples will be taken, representative samples, photographs will be there, and
I'm ready to give a statement, my lord, that I'll sell or whatever. for
so
the
they will
industrial
give a
purpose.
bond, normal Jimma petition.
They have to go to the court below, my lord.
No, my lord.
They have to.
No, money is where? Kept where?
Money is there, my lord.
Money is there means whose account?
No, in the
Whom will give the direction to transfer to the account of the petition?
Auction notice was issued by the additional deputy commissioner, Your Lordship.
ADC has given the auction notice. Possibly
No, the auction is the deposited in which treasury?
in the Karimganj possibly.
No.
Just give that information. We'll pass this order in the
Yes,
chamber.
Yes.
Monday.
My lord.
Give the information.
I'll give it. I'll provide.
If sample has drawn, because 21 it is lying on their go down, they are taking time.
Sample not for the testing.
Other.
Because that test has already been done and they have said that this is
That has
human
been
consumable,
human consumable.
not for purpose of its quality, for the purpose of the representative sample. What is seized? For that, not that.
Otherwise,
No.
again.
No, I'll furnish that.
Keep the case. How many meters? 3. And what is this IA?
2 here, my lord.
IA, Your Lordship, now.
We will not go through all this. Let us not waste time. We'll say that in view of this, already auction is given in your case, and in your case, we'll say that this is not done, we return it back. Like normal Jimma orders.
Lordship. Deeply obliged.
Disposal. I dispose of. Give the case there. We may not even mention all those. We'll go, but I want to see it, how it is.
I'll just flag mark. Kindly give me some.
Not sometime. You give it tomorrow. No issue.
Yes.
We'll upload this order on Monday only.
Tomorrow in the morning.
Monday or Tuesday we'll upload.
Deeply.
What is this? This has been done. Yes. Yes, what you say. I'll note your argument in the
earlier question, Mr. Das, Not seen, my lord, but.
Now,
but
what
I-
you say? Are you arguing this or you want Das to come?
No, no, perhaps he will be not available for some time, my lord.
What happened to him?
No, but he's in the interview board.
Oh.
Yes, that is, so I had to begin from the beginning, my lord. And I have to late for the evidence also, my lord. I prepared the case as it is.
We have already read, we have recorded, everything is there. These are the evidence recorded, typed. This is the difficulty.
Yes, ma. Then.
We have already read, therefore we have limited to this question 3 and 4 years answered, no further.
Or whether you, shall I talk to Mr. Das, my lord? For today, my lord, at least wait.
Oh, see, you
Perhaps
give him, see,
Saturday.
basically paragraph, their whole argument is paragraph 4 and
So, my
5.
lord,
So you answer this, that's all. This is
Yes.
their ground. You answer it, that's all.
So, my lord, Mr. Das names will be there, suppose, or what, my lord?
No, we are not saying anything.
Yes.
We want that the matter was heard.
Yes.
It is almost complete. Mr.
Yes.
Das was to address on last 3 occasion, we adjourn it on the ground of
Yes.
Mr. Das.
Yes.
If you say that I will argue because their whole argument is limited, only
Yes.
paragraph 3
Yes.
and 4.
Yes.
You answer it, that no,
Paragraph
this
3
is
and-
not
yes.
correct. As an appellant, they have raised this issue.
Yes, my lord.
As a respondent, you say that these issues are not valid. If you want a days or 2 days time, or you can, we'll definitely grant you.
2, 3, my lord, what has been, my lord, argued by my learned friend, my lord. There is only 2, 3 points, my lord, has said that first.
3 points only.
Yes, yes. First is said that there is sample was not according to the rules, that there is no certificate. Actually, there is no certificate. It's
So-
a separate certificate, my lord. That is, but I'll come to that, my lord. And other things, my lord, that he is, the punishment should have been under section 22C, my lord.
Because he
That-
said that 2%.
Yes, yes, that also I will reply, my
Okay.
lord. Then, and then another thing is that they have.
Here basic issue
yes,
is that in
delays.
other case also, their whole argument is that there must be separate certificate for each of this.
Yes.
That otherwise these are secondary evidences.
Yes.
To get a color of
Yes.
primary evidence, this certificate certifies that you are primary evidence.
Yes.
According to them, so therefore 3 certificates will be required, 3 or 2 whatsoever,
Yes.
whatever the method. And they are relying on the decision of the division bench.
Yes, division bench judgment also I have read, my lord.
So if
So I
you
can-
want some time, we don't have any.
Yes, my lord. I'll.
When?
My lord, I'll taking the Saturday, perhaps if my lord does, Mr. Das can come, but if he don't come, so then also I can do it
Monday?
Saturday or,
No, Saturday to
Yes.
this court is not sitting.
yes, then Monday.
Monday. Monday. Monday. That all, that much
Some
only.
time will take, my lord, that is. on-
Because here basically that certificate, so
Yes.
who exhibited it, who was the authority, that
Yes.
evidence will again read it, no problem on that.
Yes, because my evidence, 4 or 5 evidence, not much, my lord, but is relevant, my
Okay,
lord.
we'll,
I'll check.
yes.
Some of like.
21 and 22. Acha, how you propose to do this? These are the evidences we have got it done. Okay. Musmi, get it Xerox. And give the copy to Mr. Pathak, the CBI counsel, and Kukasto. We'll start it from tomorrow. Will take some time, though evidences are typed. I want you to also go through. Okay, because this is the main part. We have a soft copy. Whatever correction is required, you are free to give your corrections. And on the basis of this, we'll start it from tomorrow, Friday. By next week, we'll finish it up.
Very good. My lord, may I request, my?
Yes. No, tomorrow we are not finishing. You will argue on Monday.
My date may be fixed on Tuesday.
We'll see. We'll see. If we think that we'll give your clients an acquittal without hearing you, why should we hear you? Will not, this is a matter, I think this is the oldest pending criminal case in High Court, 2005 April. And this was the difficulty, so I have got it done. Give a copy to everybody and you just go through it, then we'll start dictating. And what we'll do is, these evidences are there, we'll just start dictating your arguments on the basis of this evidence. That Mr. Pathak has said, so and so, you will argue, they will type. Otherwise, this matter is not going to be finished. And these, how many evidences are there? Total 46. 46 witnesses. So half part we have done already. So you will argue, they will record, I will summarize, then thereafter we'll pass the judgment.
Very well.
1 week to 10 days will take for delivery of the judgment. In the meantime, we'll complete the other part. What is the facts? What is the evidence and what are the arguments? Musmi, get it Xerox and give it to them tomorrow morning.
Yes, my lord.
Huh? Tomorrow, huh? Ask the registry and give the copy, list this matter for further hearing tomorrow. By slip. Need not send.
May I please, as a WhatsApp, my lord? Lord, take some time, my lord.
What takes some time? 5 minutes.
My lord. Take a look at the DC.
We have no other business or what? Who will be the member of the masjid? Who will be there? We will decide here.
No, my lord, the right of the minorities has been blatantly violated, my lord.
Not right of the minorities. Right of the fight between the minorities. Not no minorities right has been taken in.
No, my lord, the government in manner in which they have intruded, my lord, is not permissible, my lord. The order,
Okay,
my
argue.
lord.
Yes.
My lord, can it be fixed next Tuesday, my lord?
Why this matter is listed today?
For hearing, my lord, for hearing.
Is there any stay?
No, no stay there.
Who is now running the show?
That committee, my lord, the committee which has been, the masjid committee, my lord, which has been constituted by the deputy commissioner is running, my lord.
What is, how masjid committees are constituted and under what authority of law?
My lord, there is no authority of law. These are privately managed religious institutions, my lord. The society who has established the masjid, my lord, they have the right to constitute the committee, my lord. In the state of Assam, my lord, this is the first instance wherein, my lord, the government.
Because there is a apprehension of law and order
No,
situation.
law and order can be handled with by following the due procedure of law of the CRPC, my lord. But that does not give the right to the deputy commissioner, my lord, to intrude and, my lord, to manage the interfere with the religious affairs, my lord. This has, my lord, has a consequence, my lord. That's why, my lord, this matter has been put into challenge, my lord. The manner in which, my lord, the deputy commissioner has constituted, my lord, is in total violation of Article 25, 26 as well as Article 30, my lord. My lordship knows, my lord, that the masjids, my lord, is a purely a religious institution.
Yes.
So therefore, my lord, the committee is being protected by Article 26 also, my lord, that this community has the right to, my lord, manage the affairs. Now, who will be in the committee, my lord, the deputy commissioner has stepped into, my lord. Law, by citing the reason of law and order, my lord. There is no any such issue of law and order ever occasion, my lord. If any law and order derail, my lord, they have the power, the deputy commissioner have the power under the CRPC to follow the provisions, my lord. And, my lord, there is a madrasa is also operating under the, my lord, this committee at the mosque, my lord. That committee has also been interfered with.
On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 6 weeks on a date to be fixed by registry. Yes, next.
Milord, may I pray to fix that date?
No. Either you can argue today or.
Milord, on Tuesday I will.
No, no. Mr. We have seen we are fixing matters up this month and up to next month, there is no slot. No slot. If you miss the bus, you will have to take the next bus. Yes, next case.
Obliged.
Three analogous matters, Your Lordship.
What is this?
Three analogous matters, Your Lordship. The last occasion when another batch came up, Lordship, I had made a prayer that the matters will be taken up together, Lordship. I've given the numbers now.
What are the issues here?
Lordship, we are under the old under the income tax act, Lordship, there also exists a settlement commission, Your Lordship. Where the last date was given was 30th of September. Then we had to file our claim before that, settlement claim before that. But inadvertently, we filed it on 22/11/2021.
It was last date was given on
30th of September 2021.
30th September 2021.
We filed ours by 22/11/2021.
2021. But before that, there was further extension given, power was given to for further extension. Isn't it?
It was given up to till 22/11. We filed it on 22/11
And
the
what-
last date was 39/2021.
Okay, then.
So beyond that, Your Lordship, on 18/1/2020, Lordship, the commission rejected our settlement claim, saying that we had filed it once the cutoff date was over. But our primary case, the Lordship, due to COVID at that point of time, Lordship, limitations were fairly relaxed in most of the others. In most of the cases, Lordship, limitation was relaxed at that point of time. But otherwise, Lordship can take up all the 7 matters together, Lordship, all different claims. So I've given the list, Lordship. All these matters were carved together after 3 weeks.
What is your ground? Now, where is the power to extend that time? Suppose we extend it today. Many people may come. You have missed the bus. Is there any, do you say that limitation during COVID granted by Supreme Court will also be applicable here?
Lordship, in this regard, we have come across a judgment of 2 months back, Your Lordship, of a different High Court, Lordship, where they've given a similar provision. I don't have the judgment with me today, Your Lordship.
Okay.
So the initial plan was to tag all
What
the
you
matters
say?
together.
Lordship, my senior has some personal difficulties.
Who is your senior?
Mr. SCKR.
SCKL.
Lordship can have all the matters together, Lordship. I have sent the list.
Okay. It is submitted that analogous matter being
WPC 834 of 2022.
834, 1061, 1076 and 1581.
This, the ones I've highlighted, Lordship, have come up today, Your Lordship.
Okay.
And the ones I've written with the blue pen, Lordship,
Okay,
those are the
okay,
matters which are not.
Okay. Analogous matter being WPC 834, 2022, 1112, 2022, 1116, 2022, 1067, 2022 are.
And WBC 834 of 2020.
834 we have said.
Lordship.
834, 22 are pending for disposal and a joint prayer has been made by the learned council that these matters should also be listed along with this batch of writ petition. First of prayer is allowed. List this writ petition.
After 4 weeks, Your Lordship.
After 4 weeks, along with the process.
Lordship.
No problem.
With please, Your Lordship.
Yeah.
Lordship, my matter pertains to.
I don't any other, it will take some time. Any other.
What is this West disposal?
Already it is functioning, Lordship.
My lord, we are not for opposing the disposal plan per se, but we are on the site selection.
Understand? You say that there is a prescribed procedure and mandate of law.
Yes.
And that is to be followed because this will be also a hazardous thing. So that hazard is to be done and therefore they have not followed the mandate of law. This is your case.
Yes. There's a management rules.
Our case is there, Lordship, as per expert committee report, we have done everything, Lordship.
Fine. If expert is opined that this should be the place. And if expert has opined as per law, we have nothing to say. But if expert says that no sun rises in the west, then of course we will say.
As per procedure, Lordship.
As per procedures means whether it is as per the mandate of
As
law.
per the mandate.
If it's per mandate of law, we have nothing to
As
say.
per the mandate.
But if expert, we are not on expert. If expert also opines that shockingly it says that sun rises in the
That
west,
part not, Lordship, that part not.
then we will interfere.
That part not, Lordship.
On the prayer of Mr. K. Gogoi, learned counsel for the petitioner, for the state respondent, matter stands adjourned and be
Lordship, anything,
listed after 3 weeks.
Lordship. Otherwise, this is the first project in the state of Assam, Lordship.
That's why you may not be aware what should have
And
been.
Lordship, from expert from the Lordship, Maharashtra and Gujarat, Lordship, they are coming. And
No, they are coming how, whether structure is made properly or not.
Even Lordship.
Site selection, whether it is from Gujarat.
No, Lordship, as per the procedure which is prescribed by the manual, Lordship.
There is some prescription, the site should be
Lordship,
qualified for this.
Lordship.
If that is primacy, that is
Lordship,
there,
Lordship,
will not interfere.
Lordship, that
If
is the
not there, we'll have to be concerned of these citizens whose right lungs, heart,
Lordship,
isn't it?
Lordship.
But this matter has now almost become infructuous
Hmm.
because the tenure of the panchayat is for 5 years. So it lapsed in February 2024. So now we are in September.
Now, what is happening to these panchayats now?
Malad,
They
the
are
elections
extension.
are due in November, Malad.
They are not, what you say?
Yeah, Lordship, I have no idea regarding the case. My senior is,
So here is the disqualification. Disqualification is on the ground that she is having 4 children. Now, according to you, the children, 4 children were born prior to the date of notification.
Prior to the cutoff date.
Prior to the cutoff date. So therefore, when it is prior to the cutoff date, she ought not to have been disqualified.
It's a wrong order by the DC, Malad. Prima facie on the perusal of the birth certificates that the petitioner has annexed. The cutoff date is 19/3/2018. The 4th child was born on 14th of March 2018, 5 days prior to the cutoff date. But the DC's order observed that the 4th child was born in the year 2019. So disputed.
No, but certificate, you are not, DC is not disputing the
No.
validity of the certificate.
No, not at all.
If DC is disputing the validity of the certificate, if the certificate is admitted, the disqualification is likely to be set aside because panchayat may not be, but this will have a far-reaching consequences. Next election, she will not be able to appear. But if we say that her date of birth is this, therefore she will not be able, this will not be a ground for disqualification.
Then his order will go.
His order
Set
will
aside.
go. If his order goes, now she will be qualified for next election
Next
also. It's a valuable right.
Yes.
So we thought we'll decide it, but she is not interested in doing this. case.
My lord, because the birth certificates are very clear.
Stay order was not granted only on the ground that birth certificate was issued subsequent to that cutoff date. Is not it? But deputy commissioner is not disputing the genuineness of the certificate. If deputy commissioner is not disputing the genuineness of the certificate, who are we to decide? We'll see the decision making process. So if it is admittedly, if the certificate is not disputed, her date of last birth is before cutoff date. So that cannot be a ground of disqualification. This will be an writ petition will allow in one page.
My lord, may dispose it of. There's nothing because
no,
we.
Lordship, kindly, yeah.
No, it's going in your favor.
Your
Only. My
favor.
lord is saying everything in your favor.
Heard. You are
As they,
S.
they.
They learned counsel for the petitioner or and Mr.
P. Handick,
P. Handick
for
learned
PNRD.
the learned standing counsel for the
PNRD.
PNRD department and Mr. J. Handick for the deputy commissioner come competent. What is his call for disqualification? What is his or he's having some name?
Millet, he's the DC, Millet.
No DC, but
He's the ward member, Millet.
No. Deputy Commissioner is given a designation under this disqualification rules. Competent authority, something like that. By the Deputy Commissioner.
The act prescribes him as
Ah.
district commissioner only.
District Commissioner, okay, is it? Okay. The, write it down. The, by way of the present writ petition, an order dated, yes, Mr. Hendrik, help us. An order dated,
Order dated 21st of December.
Where do we get that?
2022. My lord, page 33
page 33.
of the writ petition.
An order dated, page 33.
Last, my lord.
Just a minute, page 30. Order dated, order dated 21st of December 2022. Passed by the Deputy Commissioner Hailakandi, whereby the petitioner, who was an ward member of Ward number 3 of North Narayanpur Gao Panchayat, was disqualified to be member as number 3 North Narayanpur Gao Panchayat under Algapur Development Block on the ground that she gave birth to the fourth child on 14/9/2019, which disqualifies under Rule 62, read with subsection 1B of Assam Panchayat, within bracket Constitution, comma, Amendment Rules 2018. 18, full stop. Where is that rule?
My lord, I have it.
Please give the rule. The basic ground of the petitioner is that the Deputy Commissioner has passed the aforesaid order on an erroneous presumption of fact and law. A presumption of law. Presumption of law, in as much as the fourth child of the petitioner was born on 14/3/2018. 14/3/2018, whereas the Deputy Commissioner has held it to be 14/9/2019. Where is the notice?
My lord, notice. My lord, the notice is at
The brief facts of the
page 30.
of
my
the
lord.
case is that what is this?
Page 30. is the notice.
Jatiyatabadi Yuva Sangh. The case is that one organization, namely Assam Jatiyatabadi Assam or what? Jatiyatabadi Yuva Chhatra Parishad lodged a complaint before the Deputy Commissioner Hailakandi, requesting removal of the petitioner as the elected as the ward member of the concerned Gaon Panchayat, on the ground that she had gave birth to her fourth child on 14/3/2019. On the basis of such representation, no, thereafter notice was issued to the lady.
To the lady at page 30, my lord,
Okay.
by the CEO.
Thereafter, the Joint Secretary to the Government of Assam Panchayat and Rural Development Department requested the Deputy Commissioner Hailakandi to submit thereafter the joint check thereafter the who is that joint secretary, no?
Joint Secretary, my lord.
Joint Secretary PNRD communicated to the Deputy Commissioner Hailakandi that the president of Dr. Himanta Biswa Sarma Fans Club has informed the said Joint Secretary that the petitioner had given birth to her fourth child on 14/9/2019, and therefore in the event such fact is true, same is in violation of Rule 62 of the Assam Panchayat within bracket Constitution within bracket Amendment Rules 2018, and accordingly the Joint Secretary requested the Deputy Commissioner to submit a report and take necessary action. Thereafter, the Chief Executive Officer Jila Parishad Hailakandi issued thereafter by communication dated 10th of October 2022 asked the petitioner to appear before the Chief Executive Officer on 15/10/2022 on 11 AM to respond to the allegation that she had violated Section 2 within bracket 1 within bracket B of Assam Panchayat Raj Amendment Act 2018. It was further asked to ask the petitioner to explain why action should not be inflicted upon her. Thereafter, the petitioner requested the executive officer for providing a complaint petition and other documents on the basis of which the aforesaid notice was issued. Notice was given or not? Documents are not given. However, no such document was given, though a hearing took place on 15/10/2022 at 11 AM.
Well, at that aspect, the question that my lord has just raised, my lord, we had written letters to the department. We have not received any information.
Maybe.
That is a
in that proceeding, a written statement was also recorded, which shows that the petitioner has refuted such allegation. Thereafter, on 21st of December 2022, the impugn order was passed. Full stop. An affidavit has been filed by the Additional Deputy Commissioner Hailakandi, wherein it was admitted that the complaint has been received from the Himanta Biswa Sarma Fan Club, North Narayanpur, and as regards the communication of the Joint Secretary, full stop. It is also discernible from the affidavit that on the receipt of such representation from Dr. Himanta Biswa Sarma Fans Club, inquiry was constituted through one Namrata Sahu, ACS, Assistant Commissioner, Hailakandi, and she was asked to submit a report within 7 days. Thereafter, according to the affidavit, said officer submitted a report on 9/12/2022 with an observation that as per existing report of concert SDM and HO, 4 child, namely Sahil Ahmed Laskar of of the petitioner, was born on 14/9/2019. Thereafter, a report was report dated 6/10/2020 was also received from the BDO Algapur, and another report dated 28/12/2022 from the CEO Jila Parishad on the matter. And both the reports suggested that 4th child of the petitioner was born on 14/9/2019. And on the basis of such report, the Deputy Commissioner Hailakandi had issued the order of removal dated 21/12/2012. Full stop. From the specific averments made in the affidavit, it is seen that entire decision was taken on the basis of the allegation, on the basis of the report submitted by the executive magistrate, the BDO and the CEO of Jila Parishad. Full stop. However, this inquiry, admittedly, such inquiry was done by the aforesaid authorities, and no copy of such inquiry report or the material of such inquiry report was disclosed to the petitioner, giving her an opportunity to rebut the finding of such inquiry report. And admittedly, the Deputy Commissioner arrived at the final conclusion on the basis of such report. Where is the rule? Rule 62.
62B, my lord.
Where do we get that?
My lord, I've given the book.
Assam Panchayat Constitution rules.
My lord, 62.
Hmm.
E, read with section 111, my lord.
Rule is
62.
Assam Panchayat Constitution Amendment rules.
Amendment rule, 62 subclause B.
Rule 62 of the Assam Panchayat Constitutions of Rules 2018 prescribes that an affidavit is to be filed at the time of filing or nomination by a candidate that the candidate is having not more than 2 living children from a single or multiple partners.
Now, whether that affidavit has been filed or not, my lord, that is.
No, that is the affidavit file.
That is there.
That is there. Admitted.
Admitted. My lord,
Then we need not go to the date of birth.
Not 4th child was born before the cutoff date. My lord, let me just
No.
wrap it up at
Okay,
that.
full stop. Button additional subrule F further provides that the on receipt of any information that the candidate is having more than 2 child as on any information that any child is born after 19/3/2018, the Gao Panchayat secretary shall inform the same to the concerned Deputy Commissioner through Chief Executive Officer Jila Parishad, and on receipt of such information, the concerned Deputy Commissioner is to examine the matter and on established fact is bold, emphasis supplied, on established fact shall remove the president, can remove president, vice president, member of the Gao Panchayat concerned accordingly under intimation to the state government as well as Assam State Election Commission. Thus, from the aforesaid rule, it is the fact that a person is having a person cannot have more than 2 children.
Two or more than two children after being
Cannot have 2 or more than 2, cannot have more than 2
more
children.
than two children.
2 children on or after 13/3/2018.
Well, 19/3.
Sorry, 19/3/2000, 19/3/2018.
That is at the footnote, my lord.
That to 2018. Who's the 19/2018? So therefore, in the considered opinion of this court, the establishment of fact as required under subrule F shall necessarily mean a reasonable opportunity of hearing to the person concerned against whom the information as regards violation of clause B of Rule 62 is alleged. In the case in hand, admittedly, the complaint was not initiated by the Gao Panchayat secretary. Rather, it was initiated on the basis of by the deputy commissioner himself, on the basis of an complaint received from an organization.
Fan club. The fan club.
Organization, namely Himanta Biswa Sarma Fan Club. And the record and the affidavit clearly establishes that the petitioner was neither given any copy of such complaint nor any copy of the inquiry conducted by the deputy commissioner was given, furnished to the petitioner. Full stop. That being the position, in the considered opinion of this court, the impugn order has been passed in derogation of the principles of natural justice. Full stop. Principles of natural justice. Law is by now well settled that until and unless the adherence of principles of natural justice is excluded by provision of law, every action which results in civil consequences must follow due procedure of principles of natural justice, which has not been followed in this case. On this count alone, the impugned decision of the deputy commissioner is liable to be set aside. Accordingly, same stance state aside.
My lord will not go into the merits of that.
Will not go to merit because there are because hearing, date of hearing and the birth certificate is different. So we cannot comment that date of birth. If it comes later on, we'll let her have that defense in subsequent things that no, this was the birth certificate.
But because in their affidavit also, they have not denied the date of birth of any of the children.
Okay. Just though the learned counsel for the petitioner has asked that the birth certificate clearly discloses that the fourth child was born on
14th of March 2018, my lord.
14th of March 2018.
Page 26.
2018 and
Prior
2018, that is prior to the cutoff date of 19/3/2018,
as per
19/2/2018, and that she has not been given any chance to produce such certificate. Therefore, on that count also, such decision is liable to be set aside. We'll just say that. In next provision, let accordingly, the writ petition stands allowed by setting aside the impugned decision of the deputy commissioner dated so.
Please, my lord's order will now allow her to participate in November. In case she
Yes.
insists.